All right, I do have officially 9 a.m. On my state issue computer, so we will go ahead and get started. For the record, today is Tuesday, December 6th, 2022. This hearing is being conducted both in person and telephonically using Microsoft Teams and is currently being recorded. If you have technical difficulties or for some reason get disconnected and are not able to rejoin the hearing, please either call me directly, and I'll give you my direct line in a moment, and or email me, and we can make sure you get reconnected and we have a full hearing. So my direct phone number is 615-747-5292, and I'll repeat that in a moment. And my email address is robin.pope, that's ROBIN, .pope@cot.tn.gov. And once again, my direct phone line is 615-747-5292. We are present today before the Tennessee Assessment Appeals Commission, who have been appointed by the State Board of Equalization to review initial decisions and orders of administrative judges and other related matters. My name is Robin Pope. I currently serve as the Executive Secretary to the State Board of Equalization, and I'm designated to sit with the Assessment Appeals Commission as a hearing officer. As a hearing officer, I will preside at this hearing. I will rule on questions of the admissibility of evidence. I will advise the commission members as to the law of the case and otherwise ensure proceedings are carried out in accordance with law. I will now make some introductions before explaining the rest of the procedure today. During deliberations, Mr. Matthew Childress, to my right, will serve as counsel to the commission. He will assist the commission with questions during deliberations and offer guidance regarding the legal sufficiency of their conclusions. Mr. Childress will not participate in any findings of the commission, so he does not vote as a member of the commission body. He just is simply there to advise them as to the sufficiency of their deliberations and answer any legal questions they have during deliberations. But he is not otherwise a decision maker in today's hearings. I'll now ask our members of the panel to introduce themselves for the record. I will remind everyone too on the call, if you're not able to hear a commission member, please go ahead and speak up now so that we can make sure we get those issues addressed as soon as possible. So from, I guess, left to right or right to left, however you want to say it, we'll start with our chair, Mr. Phil Russ.
My name is Phil Russ.
My name is Don Osborne.
My name is Tim Profit.
Mr. Philip Russ is currently serving as our chair of the commission. As chair of the Assessment Appeals Commission, Mr. Russ will be our de facto presiding member. The presiding member will oversee deliberations and concur in the final written order. Mr. Russ, are you okay being our chair today?
Yes.
All of the appeals to be heard today are to be conducted based upon the record available before the administrative law judge during the prior hearing. The Assessment Appeals Commission, that being this body today, may affirm that decision of the hearing examiner, that being the initial decision in order, or remand the case for further proceedings. The commission may reverse the decision of the administrative law judge if the commission finds that decision has been prejudicial because the administrative findings, inferences, conclusions, or decisions are either 1, in violation of constitutional or statutory provisions, that is, did the judge follow the law correctly? 2, made upon unlawful procedure, did the judge not follow some proper procedure, or is there some abuse of procedure evidenced in the record? 3, was that decision arbitrary or capricious or characterized by abuse of discretion or clearly unwarranted exercise of discretion? That one's a little more self-explanatory, but essentially, was the decision arbitrary? Or 4, was the decision unsupported by evidence that is both substantial and material in light of the entire record? So essentially, did the evidence at the administrative law judge support the decision made by that judge? However, in determining the substantiality of the evidence, the commission, you can take into account whatever in the record detracts from its weight, but you cannot substitute your judgment for that of the hearing examiner as to the weight of the evidence on questions of fact. That's a legal way of saying, essentially, was there basis in the record for the judge's decision? The commission, you may not replace your judgment for that of the judge on questions of fact, but you're not required to ignore inconsistencies in the record or evidence in the record that might suggest 2 answers. But if there is evidence that suggests 2 answers, You're not able to replace your judgment for that of the administrative law judge if he chose one versus the other. But you're not required to ignore that there might have been an inconsistency either. Additionally, if you find that the record lacks sufficient evidence, that may be cause for remanding it to the judge to have evidence on a fact. But essentially today, that means there's no new or additional facts, testimony, or documents or other evidence to be presented to the commission today. If there is a failing in the record or there is something not supported in the decision, we'll have to go back to the administrative law judge because we are not accepting any evidence or testimony today. The only thing we are hearing today is argument as to why that initial decision order was decided correctly or incorrectly. A copy of the record has previously been presented to the commission members using Microsoft OneDrive, along with any written argument submitted by the parties in each case before the commission. I also have with me a physical copy of the administrative record for each appeal to be heard. I also have a physical copy of each initial decision and order for our commission members to review. The procedure for today is we will proceed one case at a time and immediately following each one, taking breaks only as necessary. First, I will call a quick roll of the cases to make sure we have all our parties present. If you or your representative are present, please unmute yourself and let us know you are here and that the technology is working. Unless there is some sort of pressing concern, generally speaking, the order of today's appeals will be as follows. We'll begin with Charles Bikes versus Hamilton County, followed by Asbury Centers versus Hickson County, the National Health Investors versus Washington County, and we'll finish out with Jerry Bible, Leon Thomason, and Timothy Todd Thomason versus Marion County. These proceedings are informal and board members are allowed to ask questions at any time. However, once we have heard all the arguments, I will briefly describe the charge to the commission members before handing it over to the panel for deliberations. Once the commission has entered deliberations, there will be no more communications between the commission and the parties. Prior to hearing each appeal, I will read a copy of the order under review and recite the administrative record. So with that said, unless there are any pressing questions or if there are any questions, we'll start with our first appeal today. At the beginning of each appeal, I will have the parties introduce themselves for the record. And then I'll read through the administrative law judge's order. So with that order in place, I believe our first appeal for today is Mr. Charles Bikes. Mr. Bikes, I know you are on the line. We can see you on the screen in this room. Could you introduce yourself for the record?
Yes, can you hear me?
Yes.
Okay, my name is Charles Bikes.
And thank you. I apologize for mispronouncing it, Mr. Bikes. All right, we have, and then who will be representing Hamilton County today?
Michelle Noble, appraiser of residential.
All right, thank you, Ms. Noble. All right, I'm going to read some case information just to make sure we have the right appeal under review today as well. I have the caption of this case entitled "In Regard to Charles Bikes, Hamilton County, Property ID 126L G003, Appeal number 133915 for tax year 2021. The initial decision and order reads as follows. Statement of the case. The Hamilton County Board of Equalization, that is the local board, valued the subject property for tax year 2021 as follows. A land value of $112,500, an improvement value of $91,400, a total value of $203,900 for a final assessment of $50,975. Mr. Charles Bikes, hereinafter the taxpayer, timely filed an appeal with the State Board of Equalization, hereinafter State Board, for tax year 2021. The administrative judge conducted a hearing via WebEx on May 16th, 2022. The taxpayer identified himself in this manner. The assessor's office, hereinafter assessor, was represented by Mr. Randy Johnston, Director of Residential Properties for the Hamilton County Assessor, and Mr. Brian Gormley, a residential appraiser from that office. Issue for determination. The issue to be determined is whether taxpayer has proven by a preponderance of the evidence that the valuation of the subject property should be lower than that adopted by the local board. Based upon the following findings of fact and conclusions of law, it is determined that the taxpayer has not met the burden of proof and the local board valuation is affirmed. Findings of fact. 1. The subject property is a 50 by 191.7 square foot residential lot located at 1308 Dallas Road in Chattanooga, Tennessee. 2. The property is improved with a 1,371 square foot house built in approximately 1930. The house has clapboard siding, no central heating and air, and has not been updated or remodeled. Taxpayer described the neighborhood as undergoing gentrification and containing both, quote, working class and middle class, end quote, homes. 4, the taxpayer's contended value for the tract, including all improvements, is $125,000 with a land value of $90,000 and an improvement value of $35,000. 5, taxpayer based his contended value on offers to buy the property he had received. Taxpayer relied on 2 comparables, which were selected for him by a real estate agent and were located within 3 miles of the subject property. The real estate agent offered to buy taxpayer's property for $100,000. 6, neither of taxpayer's comparables was considered a reliable indicator of fair market value by assessor because one was a foreclosure property and the other had been sold as part of an estate sale. 7, assessor relied upon 5 comparables in the same or similar school zones. The comparables were properly adjusted for size and class/condition. 8, the per square foot value of the comparables utilized by the assessor based on that last sale data ranged from $146.98 to $218.29, while the assessor valued the subject at $148.72 per square foot. Note on page 2 reads, each of the comparables submitted by the taxpayer had a significantly higher per square foot valuation than the taxpayer's contended value. That is $125,000 is equal to approximately $91.17 per square foot. Even as a foreclosure sale, the Lenoka Street property sold for approximately $128,062 per square foot $128.62 per square foot in July 2020. The estate sale of the Federal Street property was for approximately $106.84 per square foot in November 2020. Continuing on page 3, number 9, taxpayer asserted that most of the comparables relied upon by the assessor were not relevant because the comparables had brick or vinyl siding and central heat and air and were more valuable than the subject. 10, both parties agreed that the 14 Trewitt Street utilized by the assessor was most similar to taxpayer's property. 11, the Trewitt property sold for a per square foot value of $146.98 in December 2018. This value supports the local board's 2021 valuation of the subject property at $203,900 or $148.72 per square foot. Applicable law. A party challenging the current assessment of a property bears the burden of proof. State Board Rule 0600-1.11 subsection 1. To meet the burden of proof, the party seeking to change the assessed value must show that a preponderance of the evidence supports that change. A preponderance of the evidence means that considering all relevant evidence, a party's contention of value is more likely than not. Pursuant to Tennessee Code Annotated Section 67-5-601 subsection A, quote, the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values, end quote. Merely disproving assumptions underlying the current valuation or pointing out, quote, the likelihood that a more accurate value is possible, end quote, without more, neither invalidates the levy or judgment under appeal, nor constitutes a prima facie case for a change. Citing Coal Creek Company, final decision and order, Anderson, Campbell, and Morgan Counties tax years 2009 through 2013, issued June 25th, 2015. Analysis and conclusions of law. Upon a thorough review of the evidence submitted in this matter, The undersigned judge finds taxpayer has not met the burden of proof to establish a more credible value than that adopted by the local board. Although taxpayer offered testimony about the condition of the house as of January 1, 2021, the age and condition of the house were considered in the assessor's valuation. A value reduction based on problems with a property must be supported by sufficient evidence to quantify the reduction. Quote, the best evidence of the present value of a residential property is generally sales of properties comparable to the subject, comparables and features relevant to value. Perfect comparability is not required, but relevant differences should be explained and accounted for by reasonable adjustments. If evidence of a sale is presented without the required analysis of compatibility, it is difficult or impossible for us to use the sale as an indicator of value, end quote. Citing E.B. Kissel Jr., final decision and order, Shelby County, tax years 1991 and 1992, issued June 29th, 1993. The comparables relied upon by assessor to support the local board valuation were properly adjusted. The Treewitt property, which was deemed most comparable by both assessor and taxpayer, supported the value of the subject property. Respectfully, the administrative judge finds the taxpayer has not met the burden of proof to reduce the valuation of the subject property. As noted in Delano Carroll, initial decision order, Washington County, tax year 2015, issued September 17, 2015, quote, when the appealing party fails to carry the burden of proof, the administrative judge simply affirms the ruling of the County Board of Equalization based upon a presumption of correctness, end quote. Determination. It is ordered that the local board values are affirmed, that being a land value of $112,500, improvement value of $91,400, a total value of $203,900, and an assessment of $50,975. Pursuant to Uniform Administrative Procedures Act, and then cites the remedies available to the parties continuing on page 5. Those remedies being either 1, appeal to this commission, which we are here for today, or 2, request for reconsideration. The judge then entered this order on June 21st, 2022. And the final page is a certificate of service to Mr. Bicus and Mr. Marty Haynes, the assessor for Hamilton. With that, that is the order to be reviewed by the commission today and the subject of our first appeal. With that said, we'll generally enter into arguments to be heard by the parties. Generally speaking, we'll start with the taxpayer appellant here. Oh, excuse me, I need to do one more thing. I'm going to recite the administrative record so we all know what we're referring to. In our notice of hearing that was issued November 3rd, 2022, on the second page, we cite the administrative record for this appeal. We have the administrative record as consisting of the appeal to the Assessment Appeals Commission, that being the final administrative record, the taxpayer's online appeal filing, the taxpayer's Assessment Appeals Commission appeal, and the taxpayer's notice of appeal. We then have the administrative record before the administrative law judge, that being the initial decision and order issued by the administrative law judge, a copy of the audio recording of that hearing, taxpayers' collective exhibits, the assessor's collective exhibits, a notice of hearing, a notice of status and scheduling, and an initial appeal filing. And the dates for that are set out on that page 2 of the notice of hearing. All right, apologize for that. We can now officially begin. Mr. Bicus, the floor is yours. Would you mind stating, I guess, what relief you are requesting? What are you asking the commission to do before proceeding with the rest of your argument?
I'm asking the commission to lower the price down to $140, which is basically the same assessment that 14 Truett Street is paying. And I'm ready to present arguments if you're ready for them.
Looking at my commission, are we ready to proceed? Yes, go ahead, Mr. Bicus.
Thank you. With the property, the one property that we found that was comparable was 14 Truett Street. The assessment on that property is $138,100. The assessment on my property is $204,000, over a $60,000 difference. They're the same property. The only difference between the two properties is mine's a little bit bigger, but the other one has central heat and air and vinyl siding. And so when you take that factor into consideration, these are equal properties. If you have two properties that are equal, why is one property paying over 200,000 on assessment and the other one's paying 138,000? It doesn't make any sense. And so during the hearing, Judge Thomas used a value of 163,000 for Truett Street, but that's not what they're being assessed at. They're being assessed at $138,100. So if you can cherry pick the price of the property, then I want the last price of my property, which was 27,000. That's what I paid for this property. So I don't agree with her decision. That's the first point. The second point is the property, if you want to consider the other comparables that the assessor presented, they don't match. In North Chattanooga, we have a working class community and we have a middle class community. I'm part of the working class community. Our property values are what Truett Street is. The other properties that they listed, they're basically middle class homes, and a lot of them are investment properties. For example, I believe either Maryland or Merriam Street, the one they presented, shows an increase in value of over $100,000 over the course of a year. Well, what happened there is they bought the house for $100,000, they pumped in about $50,000, and then they resold it for $200,000. So you see a 100% price increase, but that's not relevant to my situation. My home is just a simple home without any modifications. There's been no changes in the last 10 years in the property. That's my first point, that Truett Street's being charged $138,000 in assessment. I'm being charged over $200,000 in assessment, and that's not fair. The second point is this: if you look at the comparables, they went up from 20% all the way up to 60%. My appraisal went up 110%. 110% in 4 years. Now, how could that happen? Either one, the property was improved. The property wasn't improved during that time, so that's not an issue. That's a big zero. Two, the market value went up. Well, the market value, according to the assessor's own figures, was a 44% increase during this time. From 2017 to 2021, property values on average went up about 44%, but my assessment went up 110%. So that is outrageous. And the only way to account for it is when you have these people that are buying these middle-class investment properties, they're pumping them full of money and then they're selling them at a higher price. But that's creating the illusion that my property value has increased by whatever number they're throwing at me. If they took the original value of my property from 2017, which was 98,000, and they multiplied it by 44%, you would get a value of 140,000, which is what Truett Street is paying today. So all I'm asking for is to be treated fairly, to be charged the same price that the other house is being charged. And as far as the other comp, the other properties the assessor presented, these are not apples to apples. These are apples to oranges. These are middle-class homes, and I live in a working-class home. So that's my second point. My third and final point is this. The assessor has repeatedly acted in ways to harass me. When we had our scheduling conference in February of this year, Mr. Pope had to actually tell one of the men to calm down or he's going to throw him out the meeting. Some things have happened that have happened in front of the board. Some things have happened in the background, but the bottom line is I want to make it clear that the assessor has maliciously used this reassessment to harass me, and I would like some relief from that. And that's all I have to say on the matter.
Okay, thank you. Are there any questions from the commission at this time?
Mr. Prophet, do you have any? Mr. Osborne?
No, I don't at this time, no.
I do have, Mr. Beekes, you had mentioned, or it's in the report that people had offered you to purchase your house. Was any of that in writing, or were they just kicking the tires?
It was two real estate agents that came to the house and they made verbal offers. They didn't make a written offer.
Okay.
And let me expound on that for a second. I've got a girlfriend up in Virginia. I'm trying to move up there, so I've been trying to sell the house, but I can't get anything over 125,000 for it. That's one of the reasons I'm so upset with the situation.
Is the house currently listed with an agent?
No, sir.
Okay.
There's-
I have one question. How far away is, was it True Street? How far away is the one that, for 138,000 that you were referring to?
It's 1 mile away.
If there are no other questions, we'll have the Hamilton County. So Hamilton County, Ms. Noble, do you, have you prepared an argument for today? I just want to make sure before we proceed.
Well, we can discuss the Truett Street. That 163,000 was a sale price for the Truett Street. And the only difference really is that the land value at Truett is lower than the land value that's listed on Dallas Road. Just the difference in locations. Dallas Road is a more populated road. It's closer towards downtown, and the size of the lot's a little bit smaller in Truett than what Mr. Beekes has. So that 163,000 is why we use that comp, because that was a current sale for that similar property. And the only really difference in his house to the Truett Street is that Truett Street does have vinyl, where Mr. Beekes has wood clap siding. We do list the Truett Street as having no air conditioning, no heating and air, whereas on Dallas, he does have forced hot air.
That's not true.
So Hamilton County, I'm just going to ask the same question I asked Mr. Beekes at the beginning. What are you asking for the commission to do today? Ms. Noble?
Oh, I'm sorry.
I just want to make sure I asked you.
Yeah, we're asking that the board stays with the current value.
Okay, any questions from our commission member of Hamilton County?
No.
Is Noble, do you have Mr. Beekes as having central heat and air, or what type of air is it showing?
No, sir, we have window units. That's what we have listed, and that's what he has on his property. His window air conditioning units. I'm not sure about any type of heat, but we do know that he does have window air conditioning units.
So the one he was referring to on Truett Street doesn't have any heat or air?
We do not have anything listed for that location, sir.
Sir, they do have central heat in there. I know those people.
Is there any other questions for Hamilton County?
No.
All right, Mr. Beekes, I'll hand it back to you for a short response, if any. I know you've already made some comments, but I'm going to officially hand it back to you for any other additional arguments before we enter deliberations.
Sure. Well, the point I want to emphasize is that they're showing a list price of 163,000, but their assessment's 138,000. And that's the more current of the two. The sales price was from 2018. The assessment is from 2021. And so I don't think using the 163 is a fair number, because there's a more current number on that very property that they picked themselves. And then on the central heat and air issue, I do not have central heat and air. I have an air conditioner in my bedroom. And then Truett Street has central heat and air. I mean, it may not be listed in their forms, but you can go down and look at the property and see it. So I'm finished. Thank you.
All right, thank you. Before we enter deliberations, are there any final questions from our commission members of either party?
No, sir.
All right, hearing no more questions, we'll enter deliberations. Just as a reminder, at this time, there will be no more communications between the commission and the parties. If you have any questions, direct those either to your counsel, Mr. Childress, and or if it's a procedural issue, you're welcome to direct them towards me. With that, all other ayes handed over to our presenting member, Mr. Phil Ress, to enter deliberations.
I do have one comment, and then I'll ask from the other members. We've read over and over and over again at these meetings that differences in assessed value or appraised value from the assessor is not a basis for changing on a property tax appeal. It has to be substantiated by a sale price or something else. That because one house is appraised by the assessor for more than another is not sufficient basis to change anything. Do we have any other comments? Mr. Osborne or Mr. Prophet, either one?
I don't.
Well, I'd just like to say, it looks like there was 2 sales used by the taxpayer, which turns out to be foreclosure sales according to the paper here that we're seeing. The assessor's office shows that they used 5. I think that the property owner would have had a lot better results if he had had a wider pool and not just had foreclosure. I do think that the assessor probably needs to review, the heat and air issue. That's the only thing I see, but that's nothing that we can rule on. And so I don't see that we, because of the taxpayer's limited sales that he used, I don't think that there's anything that the administrative judge did that's out of order. I think that we should confirm his order because he didn't have enough to work with to make a change.
Okay, can I consider that a motion then?
Yes, I make that a motion.
We have a second?
A second.
Would
Okay.
you guys just repeat the motion again one more time?
To affirm the administrative judge's ruling.
And Mr. Osborne seconded the motion. Okay, we'll now vote. All those in favor, please say aye.
Aye.
Any against? None, so
Thank you. So the ayes have it. The initial decision order of the administrative law judge for in regard Charles Beekes is affirmed. That concludes our business on this appeal this morning. This is an open meeting. You guys are welcome to stay and observe. Otherwise, if we have no other business for you today, you're welcome to disconnect the call.
I've got one last question, please.
Sure, I can. What's your question?
I'm going to appeal this to civil court and I need a copy of the transcript. How do I get that?
Yeah, so I can send you more, all that information again in writing. So for our proceedings today, we're doing an audio recording. If you want to get a transcript of that recording, we can give you a copy, a digital file of the recording, and the procurement of a transcript would be at your own expense. We'll issue a final written decision within the next 90 days of today's hearing. Once they've received a copy of that written decision, it will detail the appeal procedures or the appeal remedies that are available to you. Generally speaking, for State Board of Equalization appeals, once you get that final decision order from the commission, the assessment then becomes final, and then you have 60 days from that final assessment date to appeal to Chancery Court at either the county where the property is located or I believe Nashville Chancery Court. But that information will be in writing and will be sent to you both a hard copy and via email in the final decision order issued by the commission. But again, that'll be sent to you within the next 90 days. But I can immediately follow up. A copy of this hearing will be posted on our website within 3 business days. So you can see it there. I can also send you a link to it directly. Does that answer your question, Mr. Beekes?
It does. Thank you.
All right, thank you. Okay, do any of our commission members need a break before we continue, or are we
good right now?
then if we're good, we'll proceed next. The next appeal I had on for today is kind of either or. I believe it's the same parties for both, either National Health or Asbury Centers. I guess that will. I'm going to hand out a physical copy of the initial decision order in this appeal to our commission members. Just a reminder, we're still on the record, just as everyone gets started. I'll wait for everyone to kind of settle in, and then we'll go ahead and launch into our next. Is there any? And our commission members, just give me a wave when you're ready. All right. I'm sorry, our commission members ready? Sorry.
Were you writing on that?
I was waiting on you, and then I got distracted pulling up a copy of the administrative record. I was going to re-forward this case as well, so let me finish pulling that up. All right, so our next appeal that we're starting with is in regard to NHC Healthcare, and/or I believe it's National Health Investors Healthcare is also sometimes referred to, you'll hear as. I have the case caption for this appeal as in regard to NHC Healthcare for a Washington County appeal, property ID 03I, I believe, -A-001.00, tax years 2019, 2020, and 2021. Appeal numbers 127814 and 131234. Before we get much further, I'll ask our parties to go ahead and introduce yourselves and who you're representing. So I believe we'll start, I guess, I don't know who wants to go first. Mr. Lee, you look like you're ready to stand up, so I don't know. All right, I'm going to do the same and read this initial decision in order just to make sure we're all reviewing the same thing. So this initial, I read the case caption already. We have the initial decision order. Statement of the case. The Washington County Board of Equalization, hereinafter local board, has valued the subject property for 2019 and 2020 tax purposes as follows. A land value of $1,356,300, an improvement value of $8,628,500, a total value of $9,984,800, with an assessment of $3,993,920. The taxpayer filed an appeal with the State Board of Equalization, hereinafter State Board, for tax year 2019 on August 27th, 2019, for tax years 2020 on July 24th, 2020. The taxpayer requested without objection that his appeal be amended to include tax year 2021. The undersigned administrative judge conducted a hearing on this matter on July 12th, 2021 in Jonesboro, Washington County, Tennessee. The appellant, NHC Healthcare, was represented by their tax representative, Mr. Charles Dugan, at the hearing, hereinafter the taxpayer. The Washington County Assessor of Property was represented by their attorney, Mr. Robert Lee, hereinafter the quote assessor, hereinafter the assessor's office. Summary of evidence: the testimony of the parties and the following exhibits. Testifying on behalf of the assessor's office was George Hoke of the Division of Property Assessments and Eddie Roberts, a staff appraiser with the Washington County Assessor of Properties Office, and the taxpayer's representative, Charles Dugan, testified on the taxpayer's behalf. Exhibit 1, the taxpayer's valuation analysis. Exhibit 2, the National Investment Center for Seniors Housing and Health and Care, hereinafter NIC map. Exhibit 3, the 2016 through 2020 Statement of Incomes for the subject property. Exhibit 4, the NIC Guide to Senior Property Types. Exhibit 5, the NIC Guide to Senior Housing Capitalization Rates. Exhibit 6, the layouts of units contained in the subject property. Exhibit 7, the taxpayer's estimation of demolition and rebuild costs. Exhibit 7, the taxpayer's comparable apartment units. Exhibit 9, the taxpayer's CoreLogic Swift Estimator report. Exhibit 10, the International Association of Assessing Officers glossary sheets. Exhibit 11, NHC's 2018 Form 10K filing with the United States Securities and Exchange Commission. Exhibit 12, NHC's 2019 Form 10-K filing with the United States Securities and Exchange Commission. Exhibit 13, the amendment number 5 to master lease agreement between National Health Investors Incorporated and National Healthcare Corporation. Exhibit 14, NHC corporate filing with the Tennessee Secretary of State's office. Exhibit 15, NIC investment guide. Exhibit 16, NHC reports 2018 year-end earnings. Exhibit 17, National Healthcare Corporation's corporate filing with the Tennessee Secretary of State's office. Exhibit 18, National Health Investors Incorporated corporate filing with the Tennessee Secretary of State office. Exhibit 19, Rules of the Tennessee Department of Health, Chapter 1200-08-06. Exhibit 20, Rules of the Tennessee Department of Health, Chapter 1200- Exhibit 21, the assessor's office's valuation analysis performed by the DPA. Exhibit 22, the taxpayer's 2021 tax year valuation analysis. Exhibit 23, the assessor's office's 2021 tax year valuation analysis. And Exhibit 24, a copy of page from Marshall and Valuation Services regarding bank and nursing home valuations. Findings of fact and conclusions of law continued on to page 2. The subject property in this appeal consists of 67,934 square foot nursing home facility and a 70,054 square foot assisted living facility located on 12.1 acres at 3209 Bristol Highway in Johnson City, Tennessee. The taxpayer contended that subject property should be valued at $4,494,467 for tax years 2019 and 2020. He further contended a value of $4,800,000 for tax year 2021 with a further modification using the appraisal ratio. The assessor's office has contended that the value placed on the subject property by the local board of equalization of $9,984,800 should be affirmed with a valuation of $9,657,700 be adopted for tax year 2021. In support of this position, the assessor's office introduced a valuation analysis prepared by the DPA that indicated a value of $10,322,200 for tax years 2019 and 2020. The basis of valuation is set out in Tennessee Code annotated section 67-5-601, subsection A, is that the value of all property shall be ascertained from the sound evidence of its sound intrinsic and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values, end quote. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1.11, subsection 1. At the hearing, the taxpayer's representative, Charles Dugan, testified that the subject property consists of NHC Healthcare Johnson City, a 117-room, 160 skilled nursing facility built in 1965 and 1978, containing 67,934 square feet, and Colonial Hill Retirement Center, a 63-unit assisted/independent living facility built in 1986 and 1992, containing 70,054 square feet. The taxpayer also testified that based on his own analysis under an income approach, alternative use approach, and depreciated replacement costs, the assessor's office's valuation cannot be supported. He testified that based on his analysis using the income approach, he calculated the subject property's value at $4,494,467. He further testified that the parties have agreed upon land valuations. He concluded that his testimony stating that the certificate of need that is issued by the state that allows a nursing home to be operated on the subject property was not deducted from the value of the subject property due to its difficulty in determining its value. The taxpayer's analysis treated the subject property as one unit combining the nursing home and assisted living facility. Under cross-examination, the taxpayer testified that NHC Healthcare leases the subject property from National Health Investors, and the lease was set to expire in January 2022. However, the taxpayer indicated that he was aware of no plans to replace current facility. The taxpayer also added that in his analysis that property taxes were included in his expenses. The assessor's offices had George Hoke from the Division of Property Assessment testify on his valuation analysis. Mr. Hoke testified that his valuation in support of assessor's office's valuation was supported by his cost approach analysis. Mr. Hoke also testified that under the cost approach, the certificate of need was not used because it is not possible to give it a proper valuation, and he considered it an intangible personal property. He further testified that he valued the nursing home and assisted living facility as separate buildings for valuation purposes under the cost approach. His rationale for not relying on the income approach to value nursing homes was based on the inability to place a value on the certificate of need and other intangible properties of a nursing home. With respect to the proper valuation method to use, based on a prior decision by the Assessment Appeals Commission, hereinafter AAC, the income approach is the preferred method over the assessor's office's cost approach. Citing in regard to National Health Corp. Limited Partnership Assessment Appeals Commission, DeKalb County 2016, the AAC held that the taxpayer's income approach analysis was to be accepted in determining the valuation of the subject property in that case, a nursing home. The assessor's office's counsel argued that the filed petition for review to the Chancery Court and the subsequent agreed order entered into by the parties vacates the final decision of the AAC. I disagree with counsel and believe that the AAC's commission's decision in the case submitted by the taxpayer is still controlling. The Chancery Court never had the opportunity to adjudicate the issue ruled upon by the AAC, and the AAC has not since then issued any decisions that I am aware of that changes their accepted approach in the valuation of nursing homes. In the National Health Corp. Limited Partnership case, the AAC adopted a method to determine the valuation of the subject property, a nursing home, of dividing the net operating income by the loaded capitalization rate and then deducting the land and personal property values. One major issue that separates the current case from the previously decided case by the AAC is that this case involves a nursing home that is part assisted living facility and part skilled nursing facility. The assessor's offices presented an income analysis of the assisted living part of the subject property only, so the assessor's office valuation analysis of the subject property is incomplete with respect to the preferred income valuation as determined by the AAC. Due to the incomplete income approach analysis provided by the assessor's office, the taxpayer's income approach analysis would appear to be more reliable. Further, the assessor's office's incomplete analysis taken with the taxpayer submitted past financial data and analysis using the income approach leads me to conclude the taxpayer has met his burden of proof in this matter and justifies a modification of the value of the subject property. While the taxpayer's income approach will be adopted for calculating the assessed tax values for the subject property, the values relied on by the taxpayer will need to be modified. I agree with the assessor's office that it was inappropriate for the taxpayer to include property taxes in his expenses, and those numbers must be added back into the net operating income, NOI. Further, I believe that the capitalization rate of 7.7% provided by the assessor's office, which represents the published amount from the CBRE 18 senior cap rates for B-class non-core investments, is the correct capitalization rate to use for tax year 2019 and forward. Prior decisions of the AAC and the State Board of Equalization have required statement of incomes for multiple years in order to determine the value of a business enterprise as complex as a nursing home. And based on this standard, the taxpayer submitted a 3-year average real estate values for the subject property. Based on the data provided market trend, I believe a 2-year average is appropriate. The date provided for 2017 seems too low and not a good and fair representation of how the subject property is performing currently. For the above stated reasons, the following data is adopted for tax purposes for the subject property. That includes a chart with tax year, NOI with property tax, capitalization rate, value, personal property, land value, income value, and a 2-year average. For tax year 2019, he gave it an NOI of $670,767, a capitalization rate of 7.7%, a value of $8,711,260, personal property at $894,231, land value at $1,356,300, an income value of $6,467,129. For 2018, he gave it an NOI of $590,798, capitalization rate of 7.7%, a value of $7,672,701, personal property at $709,389, land value at $1,356,300, an income value of $5,607,012, a 2-year average for both 2019 and 2018 at $6,033,871. He then ordered, following on page 7, is therefore ordered that the following values be adopted for tax years 2019 and 2020. Land value of $1,356,000, improvement value of $4,677,871 for a total value of $6,033,871. $33,871 for an assessment of $2,413,548. Further, it is ordered that the following values be adopted for tax year 2021 with the appraisal ratio of 89.93% applied to the final value. That being a land value of $1,356,000, an improvement value of $4,677,871, a total value of $5,420,226. And at footnote 1, he notes this value reflects the application of 89.983% appraisal ratio. That is $6,033,871 multiplied by 0.8983 for an assessment of $2,168,090. It then concludes on page 7 by setting the available remedies to the parties, including appeal to this body, which is why we are here today. Finally, on page 8, it concludes with the effective date of this decision being October 11th, 2021, signed by Jerome Cochran, and a certificate of service sent to the parties. That is the initial decision and order up for review by the commission today. We will then otherwise proceed to the parties. We do have a cross appeal in this setting. It's my understanding that Mr. Lee, you have filed an appeal, and that Mr. Hitchcock and or Mr. Dugan have also filed. Is that the other one? Yeah. My apologies. And so this appeal is just filed by you, Mr. Lee. All right, then we will start with you. I'm asking all the parties if they can identify what relief you are requesting from the commission today specifically, whether it's remand to the administrative law judge, affirm the decision, or otherwise reverse or some sort of reversal, and what specifically you're looking for reverse in that decision.
This is based on first off, it's important to go to the style. The style on the you may see that they may be they may be discovered taxes to the lease, but they're not the owner. This property is owned by the National Health Investment. They own it. That's a separate entity. Look at Exhibit 18. National Health Investment is a separate entity. They own the food system interest in the property. National NHC Health is a separate entity. The certain entity. 10K reports NHC, National Health Corporation, which is probably the count of all these entities. They show on their 10Ks that this property is stuck as a lease. They do not own it, it is leased. So therefore, the proper owner is National Health Investment. That's who the appeal is filed for. You see the income statement provided and the argument within the name of NHC Healthcare Johnson City. That's where the confusion is. So the style needs to be correct. Because if this was to go down to the Washington County, the trustee does not have an NHC Healthcare on the county. It is National Health Investment. So that needs to be correct. You need to understand this is these properties. It is named NHC Healthcare Johnson City. So all the income statement provided is from the list, not from the owner. The owner has a lease. That's exhibit that shows that the fifth lease, the fifth lease, that the lease was to expire January 2022. It has expired. We're not going to provide the full lease to Vasco. That's the income. There's statements in some of that they do pay that pay at a percentage of the returns. But then NHC healthcare in Johnson City pays corporate also a management. It's very complicated. So what you're doing is you're looking at income statements from a ESC to determine the value of real property owned by someone else. That is wrong. It's like taking the Walmart business and using the income generated by Walmart to value that real estate. That is wrong procedure. So that is one of the errors that we saw. This property is 12.1 acre tract in Johnson City. It's two distinct properties. One is a skilled care nursing facility consisting of 160 licensed beds. That's very important. Licensed beds. They're licensed for 160 beds. It's 67,930 square feet. It was built back in 65 and originally back in 78. Been maintained very, very well. But the licensed beds, let's talk about that. 160 licensed beds. That means the state of Tennessee is building the authority to maintain a nursing, a skilled care nursing for 160 beds. That's called a certificate. That is an intangible asset. The judge recognized in his in a business area. That's what you're looking at when you look at direct income on this type of operation. It's a business enterprise that CON has a value. It's an intangible asset. You have a skilled workforce in your employee. So the best one you get. The second facility on this property is called Colonial Field Retirement Center. It's basically a substance. It's paying for itself. It's 63 units that is rented to lessees. They use the property for Southern Airlines School. It's 70,054 built in 1986 or 1990. It operates as a mill. That, well, Mr. Hopefield valued that as to and a financial statement that before that portion of that. And he was able to use that financial statement and do an income approach value on that. But that's how it's rented to people to use as well. That's how you do it. The nursing home, the tax brackets go out on the tax brackets. You say you must use income. This commission has adopted that all nursing homes have to be valued on income. On the income approach. That is one. That is one of the rare cases where the commission used an income approach to value a nursing or healthcare facility. That was taken to Chancery Court. Chancery Court, you got the board of chancellor, and we settled on that. Not a problem. There's a strong list of cases that we decided that's used in the last inlay here. That's a long way. National Healthcare Facility of Washington. Morristown Medical Investors in Hamlin County is another. We've also cited three New Jersey cases that talk about how you value nursing. I understand in New Jersey, there's just argument cases. So New Jersey is very unique action to have a specific action. And they have maintained that to use a cost to value the skilled care nursing needs for healthcare. But you take out the employee, you take out the CON, you take out the skilled care, the skilled workforce, and everything. That's all in hand. We're not doing a business enterprise and trying to allocate that. So we think the best approach to value this type of healthcare facility that has an intangible asset, the certificate of need, is to do a cost. It takes out that for the taxpayer says should be loans and says do not do the cost. But it takes out Wilson County and says do not do the cost. What's loans is going to do bond. And it's totally different. There's no CON. There's no intangible. Wilson County cases of warehouses are income producing property. Generally don't use the cost. The reason we should use the cost is you're looking at the sticks and bricks. You're looking at the real property, that the building. And we can start looking at the income, because it might be the income from the owner, but the income from that state, the business. Then you are looking at the steel, you look at the steel, I believe the tax credit Asia, testified he was on a continuous basis. And he took a 75% adjustment off the income for services. He said that that's a national average. Where did that come from? The most important. 75% of the income, the total income of the department was services. Again, with no evidence in the record as to what the actual debt was for the real estate. You know, National Health Investors owns the property they leased the NXC healthcare license for X amount, and plus a rent that plus rent based on the income of the property. So that's why we think we should use the cost. We're going to take two of our arguments. The judge also he stated that the commission has found you have to use a income. We think that's Buchanan County is a very rare case, and that was the only argument. It's not. So, but the income was submit that was a wrong decision. And when you look at the income approach, the income approach that the judge used is unlimited. He takes the NOI, which is approximately the tax rate. He takes the NOI. He takes out the property. You argue that, and I see it all forward, as you agree, that you take the property tax out of the expenses, low tax. So he took the NOI, he adjusted it with the property tax that had been deducted, and he used the capital to cut. If you agree with that, he comes up with an income tax of $8,711,260. Okay. He subtracts personal property, which we understand that adjustment. Okay, income goes to real and personal property. So you do the adjustment for personal property. That's personal property is from the record. It's what they reported, it's what they assessed value, and it's valued under the state board of education taxes as the personal property. So the adjustment for that really because when he adjusted the land, which the taxpayer had really, instead of doing analysis, they're looking at the county's land value. He subtracts that from the income approach back to come out with an income value of $6,460,749. Well, income, if you do a calculate income approach, the income approach is the land opportunity. He has subtracted the land value from that, which will allow that an income value of $6,460,749. Then for that, he allocates an procedure, straightforward. He allocates the land or he allocates the land value back out of that value of $1,256,000 to land, and what's left over is the true value of $4,677,871 to come back to his income value, that's land value, of $6,033,071. That's fundamentally wrong. That is not how an income approach is defined. We understand that that's what the question was. But you do not object land. The income approach value includes land and building. Allocated, that's one thing. Basically back down. So our argument that we talked about is administrative judge on page 6 of our administrative the area that produces has determined income flows with the profit corporate, and the only that's basically what the tax rate is. We're bound by the income tax. We understand the economy being based on the income, but the skilled care nurses is again, the error to that, we decided the Tennessee cases on page 7, decided the New Jersey cases. We understand that's common on the name, but that's common fact. Cases, you don't have a decision specifically on the that talks about the cost of those. We thought this language was very relevant. They said, you know, it's got a lot of intent. And that's what care, EA Ripley, National Care, Rocktown, and the Morristown Medical also. It's best to use it. Number 2, the judge used the income from the list, not the owner. He used the income from generated from business, not from the property. And your income flow, with the income from the property together. There is a link. You don't know what it is. You never whether or not it's market. It is intertwined. So that's error number 2. Error number 3 on page 9. Error by not adopting down in the statement. The whole error analysis off the code. Income. He came up with a value higher than what the county had on. He did not ask for the county. He did not ask for the increase. Certified by the county. And then error number 4 is the methodology. Even if the income methodology of adjusting the standby from a capitalized value to arrive at an income value we raise that issue. We ask that the commission find that the appropriate method value skilled care nurses associated should be the cost. And then also overturn the administrative judge. Correct the error first, who is the owner. Find that the cost of posting is appropriate methodology. And then also correct the judge's misunderstanding. Misunderstanding from the judge, when you read the decision of that county, it talks about, you look at the page. Besides national health care, the ECC is about evaluation of dividing that off of the income, daily tax income. They do adjusted land and personal property. Don't adjust land, adjust personal property. You might have to allocate because of that. So I think that's a misunderstanding. When you read the case itself, he says the environmental improvement value of X. And then they, in the certification in the final order, they force that the land value and the improvement value come out of the code. So we think that the judges will be solved, and number of values certified by the county organization, 9,984,800.
Are there any questions from our commission members of Mr. Lee at this time?
Can we make comments or do we just have to ask questions?
You can do whatever you want.
Okay.
If it goes a little off the rails, I'll pull you back.
Okay,
and just-
that's fine.
Yeah, go for it.
For First of all, regarding the certificate of need, I would agree that it is an intangible personal property. And if the property were sold, that would probably might or might not be accounted for. If it's sold, the assessors, Mr. Hoke's highest and best use was at a nursing home. If a nursing home, if it indeed is a nursing home, is the highest and best use, it's got to have a certificate of need. So if it's sold, nobody's going to buy it without the certificate of need. So trying to come up with the value of that, even in an income approach, I think it's appropriate, but I don't know how you would do it. So I don't think that not having it in the income approach is necessary. Because if it doesn't have it, they're not going to buy it. I looked through this several times, and I found the cost approach pretty confusing. I didn't find a real good description of what the property is, the age, the number of units. It did have that, but you had to really kind of search to find that. And there wasn't a real good discussion of depreciation. Just used whatever Marshall and Swift had to say. I didn't see any information as to the basis for the income and where he did apply that. The cap rate's not loaded. They just took the property taxes out of expenses and put them in the NOI, and that's not really appropriate. It should be eliminated completely and use only a loaded tax rate, because the property taxes themselves depend on what you're trying to value. So it's kind of circular that way if you do it that way. So you need to, the NOI here, it deducts 5% to reflect the lease payments. So I didn't quite understand why that was done. I do think I agree with what you said about correcting the fee simple value of the property. It should be under the property owner, and that's an issue that does need to be corrected. Certainly, subtracting the land value from the property value that's direct capitalization result indicates is incorrect. What happened in the Cobb County case, and I'll look back on that because I happened to be on that commission that decided that case. I can't remember exactly, but I'm pretty sure that the land value was stipulated or agreed to beforehand, and so that was added back in, but it happened to be a little bit different land value than might have come up. But anyway, it is correct that that definitely needs to be corrected. I do think that, well, that I won't talk about right now. But I had enough problems with just using the income approach the cost approach on this. I think you would have to use an income approach. I still believe that that's correct. Otherwise, why would they build it? If they didn't think they were going to get some income out of this property, out of the real estate, the main income is going to come from the nursing facility. But those values have to be deducted from the NOI. And when the taxpayer talks about that, I had some questions about that, which I can go into. Mr. Osborne or Mr. Profit?
I've just got a couple of questions. I've looked over the decision here fairly closely, and I've got some concerns with the income model that was used by the ALJ. And there's definitely a concern with the land value being deducted once the net income had been capped. And what you're doing, in essence, you're just ignoring the land value of this property. The value that's calculated by the income approach here, that only represents the building value to me. But one of the major concerns I've got is that this property was heard by the ALJ back on July the 12th of 2021. Was there ever a concern about asking for a reconsideration of the decision from the taxpayer? I mean, from the assessor's office?
Yeah, reconsideration's not required as
Oh, I
a step
realize
before
that.
getting here, yeah, so it's a,
I realize that. The valuation process itself, we all are aware that there's three different approaches. You've got cost approach, income approach, sales comparison approach. And appraisers utilize whatever best suits that type of property. And it may be multiple approaches that you use. So being restricted to any particular approach is something that I've got a concern with. And as long as you can support your estimate based on whatever approach you use, I think that meets the criteria. But my major concern I've got with what we've looked at thus far is the calculation of the income from the ALJ.
Mr. Prophet?
Well, you all mentioned all three of my concerns. So, I wanted, of course, we're not debating right now, but so we need to hear from the taxpayer. But I would like to ask a legal issue from Matthew. Owners, do these folks have the right to appeal not being the owner? The owners are the ones that own the actual property. The lease, the folks that have the lease are the ones that are appealing. Do they have the right to appeal?
I don't believe that my understanding of what the clear is by property party. I don't think the improper party action.
Okay.
Is that correct?
Okay.
Let's see, can we usually have it in this, well, let's see, can I, if that's stable with you, let's clarify. Let's see if he's. To clarify, we need more than that, we need to get the word correct for the proper name of the success.
I was wondering, because, a lease is as strong usually, if not stronger than ownership sometimes in different issues.
if there are any other questions from the commission for Mr. Lee?
I don't have any. Does anyone else? Can we take a short recess before we hear the,
Sure, yeah, we'll take a short recess. We'll come back at 10, you want to do 10:20? Or sorry, it's 10:20 currently. Let's come back at 10:30.
That's it.
No,
Oh,
sorry
1
about
minute. A 1 minute recess.
Just advisory to everyone too. It's we'll keep the recording going and we'll edit it afterwards, just so it doesn't accidentally stop or something like that. We have any issues later. But I will mute the room. I'll say yeah. Otherwise, we're ready to get back on the record. We can do that. All right, so we last left off. We're back on the record. It's now 10:25. We last left off with the agreement from Mr. Lee on behalf of the appellant, that being Washington County in this case. We'll hand it over to taxpayer Mr. Hitchcock, I believe, or is it Mr. Duke? Who's going to be speaking? Are both of you speaking on behalf of the taxpayer here? Or? So generally speaking, we usually do a argument, respond and then reply, basically. So it's really, you'll have, again, have an opportunity to, get the last word here. Are there any issues with splitting up this argument? It sounds like you're, is there-
Sir, could you speak up just a bit, please?
I'm fine with, I think it's fine with both of you. We don't really have much rules in this forum, I will say, for the Assessment Appeals Commission. The only rules we usually have are about the admission of documents, things like that. It's pretty informal proceedings here. Mr. Dugan is an agent registered with the State Board of Equalization to represent taxpayers in appeals for the State Board of Equalization. So however you guys want to do it, it's really fine unless the commission has any questions. Yeah. Agreed. And if you guys are, looks like Mr. Hitchcock shaking his head. If you guys do start covering the same issues twice, I'll cut you off. Mr. Lee, feel free to object if you think they're covering the same grounds twice. It's my understanding that the argument's going to be mostly Mr. Dugan presenting on the appraisal issues in the initial decision order, and Mr. Hitchcock identifying any legal issues, I suppose. I know this is a weird forum in the sense that sometimes the appraisal issues are the legal issues to a certain extent. So if there is any duplication of efforts, we'll cut you off. But I'm fine for having you both go. We don't have much rules on it here. Yeah, just one moment. I want to make sure. I'm going to freely admit here, just for briefly, Mr. Lee, I apologize. It did not come to my attention until I was having trouble hearing you guys just now. I don't have a microphone for both of you, and I want to make sure that we do get a full audio recording of this. Mr. Lee, I fully, frankly, acknowledge that I failed to do that for you. We will have your reply, get you before a microphone, make sure we get that audio recorded. I'm going to point that out to the record, and we can make a note of it. I do apologize for the inconsistency. Wasn't used to that. Obviously, people on telephone were recorded as part of the WebEx presentation. Give me just a quick moment to make sure we get that sorted. There's a couple different options, but I don't want to cause a reverb and things with our audio. Yeah. Yeah, if you guys don't mind passing the mic from back and forth, just make sure you're speaking to the microphone. And we'll go from there. If that makes sense, Mr. Lee. I know I apologize for that. That's not great. All right, so whoever wants to go first, Mr. Dugan.
Okay. First of all, a couple of issues I have with the testimony from
Hey, Mr.
County.
Dugan, if you mind just pulling it towards you. Yeah.
Okay. Is that better? A couple things in rebuttal to correct some of the issues that were raised by the county. The lease is a master lease. There are 45 properties from 1991. NHI, NHC, and NHR, National Health Realty, were all part of the same outfit back in the 90s. And the SEC, they're public companies. The SEC required that they split out. They had the same board members, same staff, same office space, same telephone number. So they split up. And when they did so, they put a master lease together that calls for a $33,700,000 payment over 45 properties. And that information actually is in the record under the master lease. And the payments that are made are finance payments for amortization, debt, what have you, and they're listed on each year's income statements. There's nothing there that contributes to a fee simple fair market value analysis. The taxpayer is responsible. Obviously, the operator, NHC, is responsible for the property tax payments. There are two buildings on the property. One's an assisted living, one is a nursing home. The difference is the level of care. And I thought it was interesting that the assessor's report used a cap rate for the assisted living portion that was derived from a CBRE, Senior Housing Report, in conjunction with the National Investment Center,
for Seniors Housing known as the NIC, which I'm a member. That report does list those cap rates that were used by Mr. Hoke. It lists the cap rates that were used by us in our report. However, they used a 7.7% assisted living cap rate that was adopted by the administrative law judge. The administrative law judge should have used a blended rate because half of the property is skilled nursing facility, and that cap rate is 12.8% for a B property and 14.3% for a C property. We would contend this is a C property because it was built in 1965. It's older, it doesn't contribute large amount of income. It's generally obsolete, looks great. NHC always takes care of their properties because they have people living there. Old people living there, and sometimes their own parents are living there, and they're going to take care of the property. It's going to be in good shape. That doesn't mean that it's making a lot of money. What bothers me is that in that same CBRE seniors housing report, on the next page, it lists the percentage of income that's derived not from rent, but from food and nursing care and assisted living services. And that's in the exhibits that we provided. It's in the AAC record. It's senior housing cap rates. Next page, senior housing property types. And it lists percent revenue from services, independent living 45%, assisted living 65%, nursing care 75%. And that's the detail that we use to delineate the business income from the rent. Now that still leaves rent of over $2,000 per month, which is way high, but we're acceptive of that, as we are the CON value. Clearly, the income approach not delineating a value for the CON overstates the value of the property. We're not arguing that because we don't know how to value it. I've looked and looked over across the entire United States. I've been to numerous seminars with ASHA, the American Senior Housing Association, the National Investment Center for Senior Housing, Urban Land Institute. I've spoken at Urban Land Institute meetings. There is not a generally accepted method to value a CON, a certificate of need. So we did not try to do it. But clearly that overstates the value. We're acceptive of that. But again, cap rates that the county used from the CBRE report that are in the exhibits. And on the next page, it lists the percentage of income that's derived from non-rental, non-realty sources. So we have a problem with the cases that were cited by the county from 91 and 95 and what have you. Couple of things there. The case that the judge did rely on was the DeKalb County NHC appeal that we had. Judge Aaron at the administrative law judge level corrected the value substantially. We took it to the AAC where it was corrected further. Both of those courts used the income approach exclusively. Those decisions were well written. They have standing. When we got the decision from the AAC, the county appealed to Chancery Court. The assessor's wife worked at the facility. The assessor went to the administrator for NHC and said, this is in the record.
Can you point out to where it is in the
It's
record?
in the verbal, it's in the argument. Yep.
What?
And that's why it settled afterwards. They said, hey, will you take this 2.2 instead of 1.8? We said, in the spirit of good corporate citizenship, fine, we'll do it. It was a fine correction. We didn't
Are we
want to.
still talking about the appraisal here? Because if it, I have to agree with Mr. Lee. I don't know how this is relevant to the appraisal deficiencies in the initial
Okay,
decision order.
because Mr. Lee said that the decision that the AAC didn't have standing because it was taken to Chancery Court and settled. And he has mentioned in several appeals, including this one, including just a moment ago, that the AAC's decision didn't have standing for that reason. We disagree with that, and we wrote a letter from Brett Carter, which is in the record here, that I have a copy of, where he said very vehemently, this decision was not overturned. It was not removed or anything else, vacated. It's still standing and that's in the record.
Okay, I think you've made that point, then you need to move on from
Okay.
that. Mr. Lee, well, otherwise, I guess sustain your objection on that. I think we've heard the basis of what Mr. Dugan was talking about.
Okay.
On that specific point. I do know what letter you're referring to. I do believe that we have it on our index in the administrative record.
It is.
Um,
So those are the main points that we have to refute what the county is saying. The one piece that's left out is the county has raised several cases that they say indicate that the AAC or the ALJ prefers a cost approach. We disagree with that, and Mr. Hitchcock can explain why.
Mr. Lee cites, in addition to some New Jersey cases that are decided presumably under New Jersey's Constitution and New Jersey statute, and not under Tennessee's Constitution or Tennessee statute. Those are not relevant. In fact, the leading case has been questioned by a later bankruptcy court decision that indicated that it didn't say what Mr. Lee indicated. But that's not relevant because those authorities are not relevant. What is relevant, in our view, is the previous decisions of this commission. And the previous decisions of this commission, the single decision that has addressed the preference of methods, income versus cost, is the one that we focus on, the DeKalb County case. There are 4 cases that Mr. Lee has cited. None of those express a preference for cost approach over income approach. In the Karen Ripley decision out of Lauderdale County, there was not, both the assessor and the taxpayer presented income and cost approaches, and the AAC decision gave more weight to the cost approach because the income approaches used by the 2 of them were not supported by sufficient evidence. That's the Karen Ripley out of Lauderdale County. There was not a statement in that decision that income approach is disfavored in comparison to cost. There was a flaw in the approach that was taken by the 2 parties in their income approaches. The 835 Union Street case, which is out of Bedford County, in fact, the word income doesn't appear in either the AJC or the commission decision because both parties stipulated to the use of the cost approach. There was no decision made by this commission or by the ALJ that one method or another was appropriate. That doesn't stand for anything other than the parties can stipulate to the use of a method if they think it appropriate. In the NHC out of White County, the 1992 tax year and 1995 decision stated that the cost approach was generally preferable to the income approach in valuing a hospital. However, the taxpayer, that was based upon the fact that economic obsolescence was used in that particular income approach that was submitted. Economic obsolescence is not a feature that is used in an income approach. And this commission said that, therefore, that the income approach that was submitted using this concept inappropriately of income obsolescence, of economic obsolescence was not an appropriate method to be used. And then finally, in the Morristown Medical Investors, again, it did not state that the cost approach was preferable. In fact, the taxpayer's appraisal relied on the cost approach, while the appraisal presented a valuation that used flawed sales and income approaches. And what the AAC did in that situation was reject those flawed sales and income approaches and approve the taxpayer's use in that case of the cost approach that addressed appropriately the obsolescence or the economic appreciation matter. The 4 decisions that Mr. Lee cited do not, in collectively or individually, say that the cost approach is preferred over the income approach. And for all the reasons that were set forth in the DeKalb County case and that have been discussed here today, in fact, the income approach is the preferred method where a nursing home property is involved, as is the case here.
In summary, just to close, I believe there are two mistakes in this IDO, primary mistakes. Number one is the land shouldn't have been subtracted, should be added back. I think the judge misread the decision from DeKalb County, so we agree with that. And the cap rate should have been loaded with the property tax. And that will be in benefit to the taxpayer. The land value being added back will be in benefit to the county. We believe that any prudent investor is going to want to know what return on investment is going to be when they buy a nursing home. We provided multitude of detail outlining what those numbers are, and we believe the judge made the right decision in using the income approach to value the property. Thank you.
And just for clarity's sake, I think I forgot to ask the same question I asked Mr. Lee at the beginning of his argument, which is what is specifically you're asking for the commission to do today? And reminder, those options are either to affirm the decision of the administrative law judge, to remand it for further proceedings in order to correct some error in the initial decision in order, and or reverse it in some manner. So if you identify, I don't know, Mr. Dugan or Mr. Hitchcock, if you want to identify specifically what relief you are asking from the commission today.
We would ask that the AAC affirm the decision.
Okay. And then I will hand it off to our commission members for any further questions of Taxpayers Council.
Okay. I had a question about the cap rate that you used in your analysis. You said it was a blended rate of 8%. And I'm looking at what you presented to the administrative law judge. And you have two analyses here. And the one on the second page, the second analysis shows different cap rates for the different sections from the CBRE chart that you had, which makes sense. And I'm just wondering if that was incorporated in the previous page where you used an 8% cap rate. The previous page does show where you have deducted the expenses for care and for non-realty type expenses. So I understood that, and I think that's correct, but I was wondering about that cap rate. Now, it doesn't do your benefit to have it this way, but it's not, it seems more like, was it blended using the rates from that other page? Or would it have been more appropriate perhaps to use a weighted cap rate?
I just want to clarify too, you're not asking for a factual question, you're just asking if it was identified in the record?
I guess I was asking for a procedural question about the cap rate that he used rather than.
Okay, I just want to clarify, you're not testifying today, so we're not receiving any new evidence. So if your question is not answered through the record, we'll have to leave it.
He's asking about what we provided, which would be in the record.
Okay.
And the answer to the question is, believe it or not, we try to get to the fair value, to the right number. We got plenty of work. We don't have to go looking for stuff to throw mud at the wall. But if you're using total income for a skilled nursing facility, an assisted living facility, or an independent living facility, then you would use the cap rates that CBRE recommends, as Mr. Hope did. But because all industry standards in valuation determine that you need to delineate between service income and rental income, when you get down to a pure rental number, then I don't think it's fair to use a 14.3% cap rate. So we used an 8% cap rate, which is a little bit higher than what Mr. Hoke used, because he went with a B class, we went with a C class. Does that answer your question?
Well, I was wondering, no, you wouldn't want to use the 14% cap rate, but you had some of the income attributable at a 8.5% cap rate. Was there any thought
That would be
to loading it based on the amount of revenue from each one or anything like that?
Well, I feel like we did that in our second page analysis. And that's where our numbers come from. If you look, we delineate between the skilled and the assisted, and you get down to a raw real estate number, NOI, and cap that at 8%.
Thank you. Mr. Osborne?
I don't think I have any questions at this time. We have touched on the income situation and how you agree that the land should be added back, so I'm in agreement with that, so I don't have any other questions.
Mr. Prophet?
I don't have any questions. I think both sides did a great job bringing out their points, and some of the points it looks like they may agree on.
Okay, I'll hand it over to Mr. Lee for brief fire argument. Yeah, if you won't mind handing that, passing the microphone over, make sure we get that on the recording.
It's heavier than it looks. Thank you. Couple of things. As Mr. Hitchcock stated, their argument that the cases we cited for the commission does not put a nail in that cost approach has to be used. We agree with that. It's what we submitted is the cost approach has been used. And when you look at the national, the Cobb County case, the same is there too. The language of the DeKalb County case was basically for the purpose of this hearing, we're going to use the cost approach. It did not say, the judge has interpreted that to mean that the Assessment Appeals Commission has said we have to use a income approach. That's not the case. We think a cost approach is better to be used for skilled care and for nursing facilities, healthcare, because there's so much of this CON. You've heard the taxpayer admit they don't know how to value a CON. Nobody. It's very strange. We've searched the country over too, and there's a lot of out there about doing nursing homes. Most of those are for transactional work. They're not for property tax issues. A lot of states, New Jersey being an example through those decisions that we provide, use the cost approach for these because it takes the intangibles out of it. And you look at the cost approach. The apartment complex is clear. That should be a income approach. That's easy to do. I don't think the taxpayer made that two indications. They put everything in one and use the income of the lessee of the business instead of the owner of the property. And we understand this is convoluted. It's different players. That's why we don't know if that rent is indicative of market rent or not, but we do know it's leased. And we don't know the true amount for this property. So that's the issues. And the taxpayers ask that the EAC affirm the decision, but yet they admit that it's flawed with the land values not being adjusted and stuff. The cap rates, I think, I can't remember, to be honest with you, if Mr. Hoke he loaded the cap rate on the one property because his formula does that automatically. And I was thinking he did not do an income approach on the skilled care because his position cost approach was the best indication of value. So that's our rebuttal to the taxpayers' arguments and stuff. We again ask that the decision be overturned, and with that, the value certified by the county board will be the value that should be adopted on the weight of the evidence. The taxpayer provided not sufficient evidence at the administrative judge. So they had the burden of proof. They did not prove anything. So therefore the county board's number in our position should be affirmed.
Mr. Russ, any final questions from the commission? From you as the commission of
No.
either party?
No, I don't have any further questions. Mr. Osborne, Mr. Prophet? Yeah.
No.
Okay.
Right, we'll officially enter into deliberations. So at this time, there'll be no more questions between the commission and the parties, no more comments from the parties to the commission. The commission, if you do have questions or a legal question about the sufficiency of your deliberations, Mr. Matthew Childress is here to advise you counsel as to those deliberations. I will just kind of remind you briefly of the standard of review and your options as the commission as you enter deliberations. So generally speaking, we're looking for, did the administrative law judge misapply the law cited in this case, or otherwise, in this case, the law in this forum being essentially the law of appraisal. So did the judge apply the law correctly? Did the judge otherwise act outside of the scope of his authority? And or was the decision supported by evidence that was both substantial and material in light of the entire record? So once again, reading from the statute, your options are generally going to be, you may affirm the decision of the hearing examiner, or you can remand the case back to the administrative law judge for further proceedings if you think the judge was deficient on some aspect of their decision. You also may reverse the decision. You may reverse and remand the decision, perhaps, if you wanted to reverse on some issues and remand to the judge for further proceedings on those issues. You can also, we've also had the commission reverse the decision entirely and uphold the county board value. So you have several options available to you. The only things you cannot do is decide or disagree on questions of fact of the administrative law judge. But if you find that the judge's decision was lacking support, you can remand and have the judge identify what supported the factual determination in that case. Generally speaking, those are your options. If you've got further questions about your options, you can also ask Matthew Childress during your deliberations. With that, I'll hand it off to Mr. Ress as our chair to head deliberations.
Okay. Y'all can disagree with me or that, whatever. I would agree to, or I think we should remand this to the administrative law judge to correct the issue about subtracting the land value from the indicated value. I think that's one thing. I think from just an administrative and clerical standpoint, the ownership or how it's going to be reflected in the trustee's record and who actually is the property owner and not necessarily the taxpayer, that ought to be corrected, but I think that's more of an administrative issue. I would like to see the way that the cap rate is done loaded, but that's going way back into things way more complicated than I think we need to get into on that. But those two things do need to be corrected. If they are corrected, then I would want to affirm the administrative law judge's decision.
So do we have a motion on that, or is that just the?
Well,
okay.
If any of the, if Mr. Prophet or Mr. Osborne have questions or their opinions.
How would we do the motion? Because we're, in one way, we're sending it back. And so we can't really affirm.
If everyone agrees that the way the administrative law judge has handled the land value is incorrect. So but we haven't had any real discussion here as to whether the rest of it is incorrect. So if that portion is corrected, then we can affirm the administrative law judge's decision. So if I can reword it, I don't think as chair, can I make a motion?
Sure. So I will say just maybe for procedural clarity, how it works within the State Board of Equalization appeals levels are strictly speaking under the statute, the administrative law judges act as hearing examiners for this commission and the State Board of Equalization. So if it were to go back to an administrative law judge to correct the errors that you've pointed out and or to apply the law correctly, as it were, in this forum, you wouldn't have to affirm that judge, because if you would have applied it correctly, then those issues would have been resolved. And or if the parties believe that the administrative law judge does not follow this commission's ruling correctly, a subsequent reappeal to this body would be permissible. And so you wouldn't necessarily have to affirm it. The way it actually works is the hearing examiners make a decision. If there's no appeal of that decision, this body tacitly affirms it, essentially. So we're only here to hear decisions where the parties have not agreed to that decision of the administrative law judge. I know it can be kind of confusing, but basically, hearing examiner acts on behalf of this body, makes a decision. If there is no appeal, it goes through kind of a waterfall effect through the commission, state board, and becomes final decision of the agency. We only meet if there is an appeal of that decision, and then the commission has to decide if, no, we do affirmatively agree with the administrative law judge, or we disagree. And so that's kind of why we're here today. It's because there has been an appeal filed. So if you made it back to the administrative law judge to correct those errors, the judge corrects those errors, there's no if there's no, again, a subsequent appeal of that decision, then becomes an affirmal of, the action essentially. So you don't have to remand and then affirm. You have to decide what needs to be corrected, and then it will be done.
Okay, then I would make a motion that we remand the case to the administrative law judge to first correct from an administrative standpoint, that the property owner is the person who should be cited in the case. And number two, that the issue of the land value and how that has been handled in the income approach, if that's corrected. Because it is not handled correctly now.
I agree. Should we have him look at the cap rate as well while?
I really don't think so, because I think that becomes a matter of opinion, and we can't really do that. I think the cap rate should have been loaded, but the way they've done it, the property taxes are taken out. It's kind of a minor error, or that should have been done differently and load the cap rate, but it hasn't been. So that does become I think a matter of opinion.
I agree with your motion. So I second.
Okay, so all those in favor, say aye.
Aye.
Aye. Any opposed?
Right, and the motion carries. So effectively what will happen from here is you'll receive a written order remanding this case to administrative law judge within the next 90 days. We do have one more appeal, since I am here, as well as we would have to then reschedule that hearing before an administrative law judge. If everyone has their calendar, we can go ahead and knock out one step and go ahead and get you a status conference with me to get that hearing date. Are all of you make a note of that? Are you guys prepared to do that now, or do we need to come back towards the end of the next appeal? It's a robust procedure. That's correct. And if you guys end up agreeing as to those issues, you can, that's your own style. I just need to make sure we have an accountability date for when we can come back, to make sure that appeal proceeds forward at the ALJ level. So we do our status conferences on Friday, usually either 9 a.m., particularly trying to do 9 a.m. in 2023. Almost, I used to say any Friday you wanted, except for typically in 2023, we've moved it to where, since this is a Washington County property, we could do Friday, February 10th, I believe, Friday, March 10th, Friday, March 17th, May 12th, I believe. Just a status conference, just to make sure we get you a date. I guess 90 days from today would be okay. If you guys don't mind, let's do Friday, March, excuse me. Let's do Friday, March 10th. That way we'll make sure we'll have that order to you before we meet again. And we will send you a notice 30 days, at least 30 days ahead of time, for how to get into that status conference. Okay. Moving along, our next appeal this morning is for Asbury Center, the same. I'm going to get you both a microphone so we don't have to do that anymore. No, I got to get you one. It's okay. We got to test. Oh, it works, right? You can hear this? Okay, good. Our next appeal, this still morning, is for in regard to Asbury Centers Incorporated. This is a Hawkins County, two properties are in this appeal, I believe, excuse me, yeah, two properties. We have property ID 022-077000 for tax year 2021, appeal number 131146. We then have the property ID, same 022-077, but special interest 001 for tax year 2021. The initial decision in order. We begin with a statement of the case. The Hawkins County Board of Equalization, hereinafter the local board, has valued the subject property for 2020 tax purposes as follows. The land value of $2,064,600, an improvement value of $10,996,500, total value of $13,061,100 for an assessment of $5,224,440. The Hawkins County Assessor of Property has valued the subject property for 2021 tax purposes as follows. Land value, $2,540,000, improvement value of $10,487,300, total value of $13,027,300 for an assessment of $5,210,920. The taxpayer filed an appeal with the State Board of Equalization hereinafter the State Board for tax year 2020 on July 22nd, 2020. The taxpayer requested without objection that his appeal be amended to include tax year 2021. The undersigned administrative judge conducted a hearing on this matter on February 9th, 2020 in Greenville, Greene County, Tennessee. The appellant, NHC Healthcare, hereinafter the taxpayer, was represented by its attorney, Frederick Hitchcock, at the hearing. The Hawkins County Assessor of Property, hereinafter the Assessor's Office, was represented by its attorney, Robert Lee. Summary of evidence. The evidence considered in preparation of this order includes the testimony of the parties and the exhibits as listed below. Testifying on behalf of the Assessor's Office was George Hoke from the Division of Property Assessments and Dave Pearson, the Assessor of Property for Hawkins County. And the taxpayer representative, Charles Dugan, testified on behalf of the taxpayer's behalf. Exhibit 1, the taxpayer's valuation analysis. Exhibit 2, the statement of operations from Asbury Place, Baymont. Exhibit 3, the statement of operations from Asbury Place Apartments. Exhibit 4, the taxpayer's capitalization rate chart. Exhibit 5, the taxpayer's recent rent rolls. Exhibit 6, the taxpayer's property tax receipts. Exhibit 7, the taxpayer's cost approach analysis. Exhibit 8, National Investment Center report on skilled nursing home care. Exhibit 9, the taxpayer's independent living unit comparable properties. Exhibit 10, State Board of Equalization decisions. Exhibit 11, equalization ratio chart. Exhibit 12, Asbury Center brochure. Exhibit 13, Asbury Center residency agreement. Exhibit 14, CBRE appendix. Exhibit 15, the Assessor's Office's valuation analysis. Exhibit 16, the Asbury Center daily room calculation. And Exhibit 17, the Asbury Center's expenses without taxes calculation. Findings of fact and conclusions of law. The subject of property in this appeal consists of 3 buildings housing 86 independent living apartments and 2 skilled nursing buildings with 67 units located on 9.5 acres at 100 Netherland Inn Lane in Kingsport, Tennessee. Building 1 is called the Baymont and was built in 1982, containing 86 units. Building 2 is the Health Center skilled nursing building and was built in 1982, containing 45 exempt units. Building 3 was built in 2018 and is another skilled nursing building containing 22 units. The taxpayer contended that subject property should be valued at $5,718,700 for tax years 2020 and 2021 based on their valuation analysis. The Assessor's Office contended that the value based on the subject property by the local Board of Equalization of $13,061,100 for tax year 2020 and the Assessor's Office or $13,027,300 for tax year 2021 should be affirmed. In support of this position, the Assessor's Office has introduced a valuation analysis prepared by the Division of Property Assessments, hereinafter DPA, that indicated a reconciled value of $13,271,100 for tax year 2020 and a reconciled value of $14,463,500 for tax year 2021. The basis of valuation is set out in Tennessee Code Annotated, section 67-5-601, subsection A, is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values, end quote. As the party seeking to change the current assessment of such a property, the appellant has the burden of proof in the administrative proceeding. State Board of Equalization Rule 0600-1-.11 subsection 1. At the hearing, the taxpayer's representative, Charles Dugan, testified that the subject property has been less profitable over the past years due to occupancy issues, which led to the reduction in the net operating income. Under his income approach, Mr. Dugan testified that based upon his blended capitalization rate of 9.5%, the total expenses, including property taxes and net operating income of these factors over the last 3 years, supports his contended value for the subject property. Mr. Dugan testified that his 3-year average under the income approach concluded a value of $5,718,700 for the subject property. He further testified that his approach was more reliable than the values reached under the cost approach or the alternative use approach. Mr. Dugan also testified regarding the value of the land submitted comparable sales of nearby properties to support his contention that the value of the land was worth $1,869,600. Under cross-examination, Mr. Dugan testified that the exempt units in Building 2 were included in his income analysis due to him being unable to delineate exempt from non-exempt services and income within the subject property. He further testified that inclusion of the exempt property was the reason for the blended capitalization rate and was to the benefit of the assessor's office as it increased the overall value of the subject property. He further testified under cross-examination that the occupancy rate used under his income approach included the non-exempt units. With respect to the capitalization rate used under cross-examination, Mr. Dugan testified that CBRE ratings the building was a Class C property due to its low occupancy and low income production. He also testified that its location was more rural and an older property. Dave Pearson, the assessor of property for Hawkins County, testified that a new nursing home was built in Hawkins County in 2015, and that a new addition was built onto the subject property in 2018. However, there is still a need for more nursing home beds. He further testified that the subject property's location is the most commercially developed area in the county and that there is a scarcity of commercial land in the area, which is near the city of Kingsport. George Hoke from the Division of Property Assessments testified that on his evaluation analysis on behalf of the assessor's office, Mr. Hoke testified that his valuation in support of the assessor's office valuation was support by a combination of the cost approach and the income approach. Mr. Hoke's valuation analysis stated that the cost approach was the best approach to value the skilled nursing structure of the subject property. He further testified that the cost approach was most reliable approach to value the skilled nursing structure due to it having a certificate of need attached to the structure that cannot be valued by the income approach and has no influence on the cost approach. He also favored the cost approach due to the building being a special use property with an unreliable income stream. Mr. Hoke testified that under his cost approach, the value of the independent living structure and land for tax year 2020 is $3,218,500. For tax year 2021 is $3,677,500. He testified that both values were adjusted by the sales ratio. He also testified that there was no obsolescence He also testified that there was no obsolescence to factor in due to the building being new. For the independent living structure, Mr. Hoke testified that the income approach was income information derived from the subject operations and CBRE published factors was most reliable. He further testified that he was not comfortable with the allocation of expenses as provided by the taxpayer, so he relied on a 65% expense ratio and a capitalization rate for a Class B structure. He also testified that under his income approach, the effective gross income was already taken into account by the subject property's occupancy, and the net operating income relied on a CBRE aggregate due to his belief of the unreliability of the taxpayer's expenses. Based on Mr. Hoke's analysis, he determined that the value of the independent living structure for tax year 2020 is $10,052,500, and for tax year 2021 is $10,786,000. Under cross-examination, Mr. Hoke testified that he believed the expenses presented by the taxpayer were unreliable, but he did not do an investigation into the expenses presented by the taxpayer. He further testified that he believed that the certificate of need would increase property values under the income approach, despite the fact that the certificate of need cannot be valued. He also testified under cross-examination that external obsolescence was factored in his approach due to the building only being 2 or 3 years old, and that there had been no study to support economic obsolescence. With respect to the proper valuation method to use, based on a prior decision by the Assessment Appeals Commission, AAC, the administrative law judge, he then cites in a footnote, NHC Healthcare Washington County, the appeal we just heard previously. The income approach is the preferred method over the assessor's office valuation. The insights in regard to National Health Corps Limited Partnership, Assessment Appeals Commission, DeKalb County, 2016. The AAC held that the taxpayer's income approach analysis was to be accepted in determining the valuation of the subject property in that case, a nursing home. The assessor's office's witness, Mr. Hoke, testified that due to this being a special use facility with a certificate of need, that the aforementioned case is not applicable. I disagree and believe that the AAC Commission's decision in that case is still controlling. The AAC did not create a special use caveat or exception in their decision, and the AAC has not since then issued any decisions that I'm aware of that changes their accepted approach in the valuation of nursing homes. I would note that in a prior case involving a nursing home, he then puts at footnote 2, NHC Healthcare, Anderson County, appeal number 131176. I allowed the parties to introduce a cost approach analysis due to an agreement between the parties that this was the preferred method of each, and that they had reached similar valuations with respect to the value of the property at issue, along with the value of the land. In this case, no such agreement is present, and I believe the AAC's prior decision would be controlling regarding the proper valuation approach. In the National Health Corps Limited Partnership case, the AAC adopted a method to determine valuation of the subject property nursing home of dividing their net operating income by the loaded capitalization rate and then deducting the land and personal property values. One major issue that separates the current case from the previously decided case by the AAC is that this case involves a nursing home that is part independent living facility or apartments and part skilled nursing facility. The assessor's office presented an income analysis of the independent living part of the subject property only, so the assessor's office valuation analysis of the subject property is incomplete with respect to the preferred income valuation as determined by the AAC. Due to the incomplete income approach analysis provided by the assessor's office, the taxpayer's income approach analysis for the entire subject property would appear to be more reliable. Further, the assessor's office's incomplete analysis taken with the taxpayer submitted past financial data and analysis using the income approach leads me to conclude that the taxpayer has met his burden of proof in this matter and justifies the modification of the value of the subject property. While the taxpayer's income approach will be adopted for calculating the assessed tax values of the subject property, the values relied on by the taxpayer will need to be modified. I believe that it was inappropriate for the taxpayer to include property taxes in his expenses, and those numbers must be added back into the net operating income, NOI. Further, I believe that the capitalization rate of 8.198% provided by the assessor's office, which represents the published amount from the CBRE 18 senior cap rates for B-class non-core investment, is the correct capitalization rate to use for tax year 2020. And forward, based on the new buildings and the testimony regarding the current condition of the older buildings. Further, I agree with the taxpayer regarding the difficulty in delineating between the services and incomes between the exempt and non-exempt units, and will adopt for the purposes of this order treating the subject property as non-exempt. Prior decisions of the AAC and the State Board of Equalization have required statement of incomes for multiple years in order to determine the value of a business enterprise as complex as a nursing home, and based on this standard, the taxpayer submitted a 3-year average of real estate values for the subject property. Based on the data provided market trend, I believe a 3-year average is appropriate and find the data provided by the taxpayer to be reliable. With respect to the valuation of the land, I adopt the values as provided by the assessor's office. The taxpayer's use of property sales prices of nearby properties is not a reliable indicator of property values, as the values they rely on fail to make adjustments in values when compared to the subject property. Factors such as age, time of sale, topography, size, etc., were not taken into account in the comparable sales listed in their evidence. So these comparable values are not a reliable indicator of what the property values are compared to the subject property. The Assessment Appeals Commission has said that for the comparable sales to be relevant, they must be properly adjusted. In E.B. Kissel Jr., Shelby County Tax Year 1991-1992, the commission said, the block quotes here, the best evidence of the present value of a residential property is generally sales of properties comparable to the subject. Comparable in features relevant to value. Perfect comparability is not required, but relevant differences should be explained and accounted for by reasonable adjustments. If evidence of a sale is presented without the required analysis of comparability, it is difficult or impossible for us to use the sale as an indicator of value. Final decision order at 2. The assessor's office provided adjusted comparable sales that will be adopting their valuation of $2,064,600 for tax year 2020 and $2,540,000 for tax year 2021. The above stated reasons, the following data averages are adopted for tax purposes for the subject property. He then identifies its tax years 2018 through 2020 for a net operating income average with property taxes of $985,280, capitalization rate of 8.918%, a value average of $11,048,217, personal property average of $1,050,709, a land value average of $2,302,300, an income value average of $7,695,208. With respect to the sales ratio, I find it appropriate to carry forward that value through the rest of the reappraisal cycle. The administrative judge respectively declines to apply the sales ratio absent evidence of the fair market value of the subject property as of the sales ratio year lien date in question. For a recent comprehensive discussion of equalization board duties in the context of the appeals process, see Tennessee Attorney General Opinion Number 20-10, May 20th, 2020. I missed a footnote, but somewhere you said it a footnote since the only data regarding land value submitted by the assessor's office was for tax year 2020 and 2021. The average of the 2 years was adopted. Continuing on page 9, he then provides a link, hyperlink to that Attorney General position. See also Arcade Company Incorporated corrected initial decision order, Davidson County tax years 2017 to 2020, issued March 11th, 2021, applying sales ratio only where the taxpayer established value as a sales ratio year assessment date. Order. It is therefore ordered that the following values be adopted for tax years 2020 and 2021. A land value of $2,540,000, an improvement value of $5,155,208, a total value of $7,695,208 for an assessment value of $3,078,083. He then continues by citing the available remedies to the parties, including appeal to this commission, which is why we are here today, and concludes on page 10, issuing this order on March 28th, 2020, and providing a certificate of service as being sent to the parties. That is the initial decision order up for review by the commission today. We also previously provided a copy of the administrative record. I'm going to read from our notice of hearing. It's a several-page document. On page 1 is the notice of hearing citing the case to be heard and when and where and who that issue was issued to. We then have the appeal to the Assessment Appeals Commission. We had, I believe, some additional filed documents from this notice of hearing, including written argument from the parties. Let me just check this. So we have additional documents essentially were not listed on this notice of hearing that were accepted on in preparation for this appeal. I have the taxpayer Asbury's written argument. I have the taxpayer Asbury appendix of authorities. I have the Hawkins County AAC brief. I have the Hawkins County AAC appendix of authorities. And then continuing on with everything else that would have been on here, we have the continuance order continuing this appeal to today's date. I have the previous notice of hearing. I have the acknowledgement and admin record that was sent to the parties identifying the admin record as of that date. We have the taxpayer's initial appeal filing. We also have the assessor's initial appeal filings to this commission. We then have 2 pages identifying all the documents, including a copy of the hearing recording. In this case, going on from page 2 to page 3 of the notice of hearing for today, identifying all the applicable exhibits. I have not otherwise received comment from the parties that there are any exhibits discrepancies or missing from that list. That said, we will enter into arguments unless we need any other break or questions from the commission before we begin. Just let me know when you're guys are ready to go. All right, looking ready. This is appealed. I believe we have a cross appeal from both parties have appealed this decision to the Assessment Appeals Commission. I think we did originally get our appeal from Washington County, Mr. Lee first. So we'll probably still follow the same procedures we did in our last case. Mr. Lee, I'll let you go first. Mr. Dugan and Mr. Hitchcock, I'll allow you guys to go, and then Mr. Lee will have you a brief response. As we enter, again, same thing. If you could just identify as you begin, I'll just say it for both of you too, Mr. Hitchcock and Mr. Dugan, just as you get ready to present, please specifically identify what relief you are asking from the commission very specifically. We're asking them to affirm the decision, reverse the decision, or if you're only asking them to reverse parts of the decision, which parts you're specifically asking them to reverse, and or if you're otherwise asking them to reverse the entire decision. just identify specifically what you are asking the commission to do on your appeal as you begin your arguments. Other than that, I will hand it off to Mr. Lee for your arguments. In this case, Mr. Lee, I'm going to make sure our audio is working as you begin. I'll stop you if I can't hear you.
Okay, can you, thank you again. This is a little bit more complicated case. We thought the last one was complicated. This was more complicated. There's really two partials, but only one partial has been appealed. There's three structures. Three structures on the parent partial, and then you have the special interest. But there's three structures on this complex, this facility. First off, you have on the taxable partial. Part of this property is exempt from taxation. The State Board of Equalization entered an order in in 2000. Let me see, get my dates right. May 21st of 1993, they exempted the skilled care nursing facilities that was there in May 20th, 1993. There was some improvements made to that, and the exemption had to be renewed. It had to be amended to include new part, and that was exempted in July 7th, 1998. This property is Asbury Centers, which is part of the Methodist Church. It is owned by the Methodist Church. It is a progressive community, similar to McKendrick here in Davidson County, where there's homes that have not been appealed. Then there's assisted living, independent living. Then there's skilled care. So you could transition from one to the other. The skilled care facility, which was built in the 1990s, was exempted by the State Board of Equalization. It's a 45-unit complex, and the land underneath it, which came to 0.3 acres, was exempted. It's 40 beds, 45 units, 40 beds. This was built in 1982. It was exempted by the State Board of Equalization. Has not been on the tax roll since then. The independent living facility, which was built in 1982, contains 86 apartments. That was still subject to taxation. The State Board denied the exemption for that. They basically modified the exemption, granted partial exemption to this property. The independent living was found that it's more of an apartment complex. It did not provide a gift that the State Board requires for the exemption. It's very similar to the McKendrick here in Davidson County, if you're familiar with that. So part of this property was exempt and part of it was taxable. There's 9.5 acres that was taxable along with that independent living facility. So that was on the parent, on the partial that has been appealed. Map 22, partial 77, and then special interest 000. In 2018, they built a new skilled care facility down the road. It's still on the same partial, but down the road a little bit. That facility built in 2018, brand new facility, built then, consists of trying to get my beds. 22 beds, 22 licensed beds with a separate CON. That exemption was never applied for. It has never been applied for to the State Board of Equalization. Therefore, that facility became taxable. That property, again, was built in 2018. So that is consisting of 12,769 square feet. So what we're talking about, what was appealed to the State Board, was the partial with the skilled care facility built in 2018, brand new facility. And then the independent living facility, the apartments, that was appealed. The exemption property was never appealed. No reason to appeal. It's never been assessed. The exemption has never been revoked by the State Board of Equalization. You will see in our argument, in our presentation, the only entity that can revoke an exemption is the State Board of Equalization through a revocation hearing. That's it. So that property is exempt from taxation. The taxpayer is aware of that now. When the appeal was originally filed, they did not realize a portion of this property was exempt. The agent did not. So they do now. And they argued before the administrative judge, well, it's irrelevant. We can't separate the income. The income's all convoluted, but we'll let it all be used. And the judge, in his decision, basically said, for the purpose of this decision, we're going to treat it as non-exempt. Well, I know authority that allows the administrative judge, without a revocation hearing, to revoke an exemption, to treat property taxable that's not taxable. So that's one issue we have, is that's why it's so convoluted in this property. The taxpayer has argued, and the administrative judge has determined that the Assessment Appeals Commission in the Cobb County case decided that the income approach to value is the best approach to use for this. And it's the taxpayer submits it's the only approach to use. You could just use income. We heard Mr. Osborne in the previous case identify there's 3 approaches to value: sales, income, and cost. This is a special use property. The other case that you just heard, you decided that on the income approach. We submit that is why the cost approach is very, very crucial to these type of properties, the special use properties. And this commission has held in specialized properties, in the Kimberly Clark case and the A.E. Staley take law case in Loudoun County, that when you have specialized properties, the cost approach should be used, because it takes all the nuances out of that specialization. The specialization of this is the CON and the working force. So that's why the cost approach, we rely on those decisions. And I know the taxpayers could say, well, those decisions don't mandate that you use the cost approach. The DeKalb County decision does not mandate that you use the income approach. It was the last decision on a nursing home, and it used the income approach based on the facts of that case. So Mr. Hoke on this one, he did a cost approach on the taxable 2018 structure. And as Mr. Pope read in the record, he said that he did not find any functional obsolescence because it's brand new. It was only 2 years old at the date of the assessment. There was no functional obsolescence in that property. They had designed it, built it to their specifications. Very new. He relied on the cost approach. On the apartment complex, he relied on the income approach, which he should have. On the exempt property, he did a value because it's not taxable. Why would the assessor value that property and argue them for a value? Now, the taxpayer in their position said, well, we're just going to use the total income. We can't divide it out. We're okay. We put forth a lower value and a reduction, but it's okay with us. Well, that's revoking an exemption that's been granted by the State Board of Equalization. That is administratively concerning. That this commission should be concerned about that. We would like to ask that you find that the cost approach is the best approach for the skilled care facility, and that the income approach should be used for the independent living. That's what Mr. Hoke did. Mr. Hoke's value was less than what was actually assessed. I think his value on those two pieces was only 10 point something million. Again, the administrative judge made the error, the fatal flaw of subtracting the land value of 2 point something million from his income value. If you add that back to the total value that he had, it comes to Mr. Hoke's analysis. But again, Mr. Hoke did not attempt to value the exempt property because it's exempt from taxation. He did a cost approach, and we asked that this body recognize the cost approach of these specialized properties, especially when it's new, when it's a 2018 facility. We understand these properties, they build them because of the income stream. The same can be true for Lowe's. They build Lowe's because of the income stream that they're going to get from the business. Everything's built to produce an income in commercial property, whether it's a warehouse, whether it's a shopping center, whether it's a manufacturing facility, they're going to produce income. But the mere fact that this is so specialized property, it is skilled care, it's got all these intangibles, this body, this commission needs to recognize that the cost approach has relevance. And the cost approach should be considered in these. The apartment complex, we agree, the income approach is the best value, is the best indication of value. You have to not limit the appraisers to one approach of these properties, to only one approach. But in a specialized unit building, we should go towards a cost approach. That's, again, I know it's argument, it's statute. It's argument on case law from New Jersey, but they've recognized that. And in the other decisions, when you read the Assessment Appeals Commission, no, they didn't say we're mandating a cost approach for all these. They said that a cost approach is relevant and a cost approach should be considered. And in some instances, the cost approach is the best indication of value. Now, I think I've covered all my positions. The main thing is the exemption should not be revoked. You are penalizing them, and the taxpayer's agent is saying, well, we're okay with that. But I don't know if the taxpayer can waive that, I guess, but if the taxpayer wants to waive the exemption, the Hawkins County assessor would be more than happy to put it back on taxpayers. But that exemption was granted because the state board found that a part of that property was charitable. It was charitable to the Methodist Church because of their mission and stuff. This is not similar to the next one. The last case, which was a purely for-profit company. This is a nonprofit company, but the state board struck a test there to tax and to assess the apartment complexes because there's no charitable gift there. But the nursing home, there was a charitable gift. The new property has not been applied for. If they want to apply for exemption, it'd be interesting to see what the state board decided on that. At this time, the assessor is mandated to assess that property. And again, it was built in 2018. It'd be interesting to see what the total cost was on that property. But we do not have that in the record. It was not provided. So again, there's the flaw in the methodology, but we ask that the administrative judge's decision cannot stand. It is full of flaws, and we ask that you reverse it and bring it back to the County Board of Equalization value. Thank you.
Mr. Russ, any questions from the commission?
I had only one question here. If Mr. Hawk did not include a cost approach for the exempt portion of the property, correct?
He did not.
Okay. How did he handle the land value on that? Do you know?
Well, the land value is 0.3 acres. And so on the property record card, and the exemption from the state board granted the exemption to the structure of the land underneath the building. The building takes up 0.3 acres. So the total land has been adjusted to recognize that 0.3 acres is exempt.
Okay, thank you. Mr. Osborne? Mr. Prophet?
I was wondering like you were.
Okay.
Okay. Mr. Dugan, Mr. Hitchcock, however you guys want to, just make sure you're talking to the mic.
Okay. First of all, the reason why we were not aware that a portion of the property was exempt is because the assessor's records don't reflect that. We have a property record card that's in the record for the property. It's in both the taxpayer and the county's record or exhibit. It shows special interest 002, and it shows 0 square footage, 0 land market value, and 0 assessment. So we didn't pay any attention to it. As a practical matter, well, this was not in the record. It doesn't make any money. But what happened here is in 2012, the company decided that since they were hemorrhaging money on this thing, it's partially assisted living, partially skilled nursing facility, a little bit like the other property we talked about earlier. There's no independent living facility on this property at all. It's on several other parcels. They had shared rooms in the skilled rooms. They call them semi-private. So you have 2 residents in each room. And they thought, we need to build a new facility, split these out, and the private rooms surely will rent better. Well, they haven't. Those things were finished in 2015. It's a good-looking building. It's built in the style of today. It's a home-looking facility till you get inside and see that it's nursing facilities. But bottom line is, they spent a lot of money on that thing, and it has tons of economic external obsolescence, even though it's only 5 years old. So it doesn't have functional obsolescence. It does have external obsolescence because it's not generating the income. So a proper cost approach would include recognition of a property's ability to make money. I mean, if you're going to use a cost approach as a prudent investor to value a property or to derive a purchase price, and you see that it's going to cost more to build it than you're going to make on income, you're not going to do it. It's not feasible, and you're going to adjust your depreciated replacement cost approach, especially on older facilities, for the ability to generate income. Now, the administrative law judge did know that there was a piece of this that was exempt, and he said, for the purposes, and I'm reading from his order, it says, for the purposes of this order, he would treat that property as non-exempt, because when you take the entire income stream for that whole parcel, the old nursing, the new nursing, and all the assisted living facility, it doesn't generate enough income to even get you to halfway of what the assessor's number is. And that's where our income approach comes in. You heard the testimony earlier about the cases that had been cited by the county and our opinion as to whether they apply or not. I don't know whether that needs to be put in the record or not for this second hearing.
What?
The cases that the county cited, stating that the cost approach was the better approach to use for these properties.
They filed on a list of exhibits. If they're just making references to prior cases, there's something to really enter there.
Okay, I'm trying to save some time here.
Okay.
I don't think we need to repeat that. I think that there's a reference in the record and go somewhere else that argument can be made.
Yeah, could you just again, maybe like, maybe I'm interjecting a little bit too much here, but so your arguments about what's wrong with the administrative law judge's order here?
I'm pointing out that the county's cases, their citations of the 4 cases that they brought up, saying that the administrative law judge should have used a cost approach instead of the income approach because of these 4 cases they cite in New Jersey and elsewhere. We don't believe those say that at all. We disagree with that contention from the county that those cases mean anything in this regard. Again, the property doesn't generate income that is substantial enough to support the county's value, and we believe that the administrative law judge made the correct decision in using the income approach. However, he made 2 calculation errors. First of all, the judge added real estate taxes twice to his income approach. And if you look at the numbers, you'll see where he did that. He said specifically that I believe it was inappropriate for the taxpayer to include property taxes in his expenses, and those numbers must be added back into the NOI. If you look at our report, our income approach clearly subtracts $231,040. This is on page 3 of our exhibit given to the administrative law judge under our income approach. It's $231,040 for 2020 and 2019. It's $235,000 for $481 for 2018. So the judge took the NOI off our analysis, averaged it for 3 years. We had already deducted property tax to get to that NOI, and he added it in his model. So effectively, we have $232,520 in NOI in the judge's income model that is included twice. The second mistake that needs to be corrected in the calculations that he made, he did not apply the assessment ratio for year 2020. That number is 89.76%. It's in Exhibit 11 for the 2020 appraisal ratios that we provided, and that ratio needs to be applied to the 2020 value in his decision order. So those two mistakes we think need to be corrected, and we ask that the decision be reversed or remanded for correction of those two errors.
Anything else from Mr. Hitchcock on this?
No, nothing else.
Any questions from the commission members this time?
Yes. In the Washington County case that we just heard, you applied the business interest or the non-realty items, and you deducted the expenses attributable to that. And in your analysis here, that doesn't show up that way. Is there a reason for that?
The reason we didn't do that is because the income on this property was so low already that it would have taken the property to a point where it would have been completely obsolete and probably not its highest and best use. So whether it's scientific or perfect to do it that way, I don't know. There are tons of service income here, just like the other property, but try to keep these things as simple as possible. And for the administrative law judge, and I didn't take that extra step in this one because the income as it was before you deduct for the service income, which is 75% for skilled and 65% for assisted, according to the CBRE evidence that's in the record on both sides, we just chose not to deduct that. Technically, you could argue it should have been deducted, and NOI could be a whole lot lower.
Just a reminder, this is not for testimony or finding of fact today. We're talking about references to the record, or Mr. Dugan, you referenced parts that were before the administrative law judge, that's what you're referring to. Is that correct? Like, we're not
Yes.
taking testimony today.
That's correct.
Right.
Mr. Dugan is referring to items that are in the record.
Okay. And one other thing that I think your tax rate didn't include one of the property taxes. I can't remember whether it was, or it doesn't reflect what the taxes were for Hawkins County and the city of Kingsport.
Any other questions?
Mr. Prophet or Mr. Osborne?
I really don't have any questions. I do have a concern that we're trying to value some exempt property here that I think needs to be addressed.
Okay.
We can talk about that a little later if you like, but that's one of my concerns. And then the situation with land value being deducted again, so we can address that.
All right, Mr. Lee, back to you.
Thank you. Mr. Russ, one of the reasons the income, there might not be an adjustment is this is a nonprofit. This is not a for-profit company. Their income, to qualify as a nonprofit, they have to show that there's a gift. And that's for the Board of Equalization to grant an exemption. So therefore, the income, this property is not profit-driven. It is charitable. And so therefore, that's why they enjoy the exemption for their portion of the property. Therefore, the incomes are, the income statements for this property is not for a for-profit company that will come in and buy this property and say, hey, we can make money on this. So that's one of the concerns about using the actual incomes when part of the property is exempt and it's a nonprofit organization. So the incomes are not relevant to market. It's not driven. It's not market driven. That's our argument. That's why the concerns, and we asked this board to say that to overturn the administrative judge misgivings that you have to use the income approach for these properties. It should be considered. It might be considered, but the cost approach is one that gets away from the intangibles, gets away from things, especially when the building is so new. You have more relevance as to the cost. So that's our concern there. Then the property not being, and taxing property or valuing property. The taxpayer's rep is wrong. This was identified. There is a property record card out there. No, it does not have the square footage. It does not have things on it. That's common for assessors not to measure, list exempt properties, churches, and other things. They don't value it, so the value would have been irrelevant. But it is noted that the property is exempt, and the taxpayer has in its official records of the taxpayer, of the owner, the exemptions from the State Board of Equalization. So they do know that this property is exempt. There was an attorney up in the Kingsport area. It's in the record, the exemptions, the applications that filed for those exemptions, and it was granted by Mr. Forrest Norval, and then a subsequent administrative designee that this portion of this property is exempt. And there's the concern about the land value also in the income approach. So we're asking the commission to overturn the administrative law judge's decision and basically correct his determination that the income approach is the only value, the only approach to use on these properties. We think that's not true. There's a history of cost approach being used on these. This one in DeKalb County was an income approach. We get that. But that case does not say that that's the only methodology either. We think the taxpayer and the administrative judge is reading too much into that decision that it's a nail that you have to use the income approach to these properties.
Any final questions?
I have a question, if I can refer back to Mr. Dugan, just for clarification on my own part. The 2015, 2018 building, there's a discretion, I guess, that's put on the record, 2018, whatever. You said the building looks very house-like, very homey, but I've kind of got a little gray area. Is that a nursing home or apartments?
Skilled facilities. There are no apartments on the property. There are assisted living rooms, and then there are nursing care rooms. This is a nursing building only.
But it kind of
22.
looks like an apartment.
Yeah, it's a pretty building. The inside doesn't have kitchens in the rooms, doesn't have full bathrooms, so it's extremely expensive to try and refit that for apartments. If you start to spend that kind of money, you're underwater.
Okay, I just wanted to clear up for my own, what exactly this is.
Mr. Pope, if I could point to the record, Mr. Hoke's analysis, which I believe was Exhibit 15, has pictures and a diagram, and also, I think this is called the Baymont House, is what it's called. And so there's a picture on page 54 of the administrative record of what this skilled care looks like and everything. So just for pointing
Yeah,
to the record.
if any of the commission members want to view that part of the record, I'm more than happy to pull it up on the screen and highlight it.
Could you repeat that, please? I'm sorry.
If you want to see any portions of the administrative record, I can either pull it out of our physical copy or highlight it on our screen for the members as well.
Hang on just.
I had reviewed it, from what you had sent, but I was just in testimony, just wanted to make sure I was clear. What I'm talking about.
Yeah, any other questions, commission members, either Mr. West or?
I don't have any.
If there are no other questions, we'll enter deliberations. So from here, there will be no more discussions between the parties and the commission members. Commission members, you are free to ask Matthew Childress, your counsel over here, any questions you have, legal questions about either exemptions and things like that. He is an exemption attorney with the State Board of Equalization. I'll briefly read example again, just a reminder of the charge for the commission members. Did the administrative law judge misapply or incorrectly apply the law or the law of appraisal to the facts of this case? the administrative law judge act outside of the scope of his authority? And was the administrative law judge's decision otherwise supported by substantial and material evidence? You have pretty, still relatively broad discretion to form your decision in this case. If you do define that the judge, one of the rights of the parties was prejudice for one of those several reasons, either in violation of constitutional statutory provisions, did not follow the law of appraisal correctly in this case, or unsupported by evidence that was both substantial and material in light of the entire record. You can remand to the administrative law judge to correct those deficiencies or otherwise reverse the decision of the judge as to those specific parts and remand to the judge for further consideration. You can reverse the decision in its entirety or otherwise affirm the decision in its entirety. You've got some pretty broad discretion, but if you do have faults with the decision, just identify what those faults are, how they should be corrected, what the administrative law judge needs to do to correct those mistakes, and then we can otherwise remand it back. But so those are your kind of options. You got some pretty broad authority. I'll hand it over to Mr. Russ to preside over deliberations.
Okay. Just for us to discuss, I think there are three things that definitely need to be corrected. One, the administrative law judge in his analysis did double penalize the property or the property taxes. It was added back to the NOI, and then the cap rate was a loaded cap rate, which accounts for, so it's either one or the other, but that has to be corrected. The land value subtraction from the same as the other in Washington County, that needs to be corrected. And there's another one that I picked up on that on page 8 of the decision, the judge has averaged the land value for 2 years, but then if you go over to page 9, it's the land value is for the second year. So that decision, that needs to be corrected. Now, those three things do need to be corrected unless I've missed some that y'all have. But we had some question, Mr. Alford, about the.
Yeah, the exemption portion of it needs to be addressed. It doesn't need to be valued at all. And whether it's included or excluded from this, it just needs to be addressed.
Well, if we remanded the whole thing back because of the income approach was incorrect in using that, then that would change everything. We'd have to just remand the whole thing, which I'm not. We're saying if we do that, then we're saying that in this instance only because of the mistakes in here, then you'd have to depend on the cost approach or go back and get just the income attributable to those 22 units and not consider either the income or the expenses attributable to those 2 units. So I'm open to whatever y'all think on that.
It gets very complex going from the exempt, and that's why, just personally, I think since they are a nonprofit, it could clear things up going more with the cost approach. It's going to take care of the exempt. I don't know. There's just so much fog in this. If you pull out, put back in, I mean, since it is basically one functioning unit, yet parts are exempt, they would be much better off filing for exemption for the other, in the future. But right now, it's what we're having to deal with. It appears, the only thing I see that's halfway clear, it's not even that clear, is the cost approach. And I don't really like that idea.
I don't either, and I don't think it's very good, probably.
I
you
don't
know.
like that idea, but I'm just trying to find a path, and that's the only path that I can see that may work, but I'm open to suggestion.
Um, what do you think?
It's a situation where it needs to be addressed. That there's a portion of the value that's out there that's not taxable.
Yeah, that's dependent on a non-taxable property.
Yes.
I can understand why the taxpayer did that,
Mhm.
and that probably makes sense. But I like the income approach, but it's really cloudy here. And I don't like the cost approach because I don't have a lot of confidence in it, quite honestly.
Right.
Um,
It's got to go back. We basically agree on that.
yes,
There has to be an action other than what was taken. And if it does go back, it's going to take some extensive and cost approach, not in cost approach, but income approach. It's going to take some extensive filtering, I guess maybe the proper or improper term, and some extensive work to clear up the issues that have been shown to us.
okay. I'm trying to think of a common sense way to do this, and it's escaping me.
Mr. Ruff? I think you could always use the income approach and then you could take out the exempt portion. You'd probably need to remand to get the ALJ to actually value the exempt portion, but then.
Right, I understand that, and that's what we should do. I'm thinking that if I'm correct in this, the testimony of Mr. Dugan said that they, both in the record here and just, that you couldn't really do that. I mean, that it was melded in there. I don't know whether it's by unit number or whatever, and then applying the expenses to that specifically. Whether that would make
Sure.
any clearer picture of what we've got, particularly in regards to the expenses. So, I regret doing this, but I think because of those problems, and also one other thing that the taxpayer said today, if they didn't put those in there in his income approach or in their income approach, that the whole thing would be a negative. So, and that would apply to the 22 units that are taxable and probably to the other where you're combining the whole thing. So, because of that, I guess we would have to go with the cost approach if we've got problems with the cost approach. I haven't gone through it enough other than that it's confusing, as most of the exhibits that I've looked at on this are very confusing and not. I think that's probably what we ought to do out of default. Y'all.
Should we have the administrative judge review the cost approach to make sure that the exempt values are adequate? The percentage, because the ones that's exempt is in another building, correct?
Well, the skilled nursing facility is in two parts. You've got 45 units, I think, that are tax exempt. And then you've got the 22 new units that are taxable.
Right.
So, and then I think it's 85 or 86 units, 87, something like that, that are in the assisted living. that are taxable.
Mhm.
So what the taxpayer has done with the income approach is included all of that income and all of the expenses together. But the testimony today, and is if they took that non-taxable out, that everything would be negative. But you could take the revenue out, I think, pretty easy, but taking the expenses out, unless you just did it on a pro rata basis per square foot. That might be the only way that probably do it that way, or per unit. And then,
Again, back to cost approach.
yeah, I don't know what the result would be on that, but,
I guess my question is would we just go back to the assessor's cost approach? Or would we have
that's,
back to what the county
what the county
appeals
board did.
board did, yes.
I think it has to be, we'd either have to affirm this or
Send it back.
send. Well, would it go, it would be either approve the county's, the County Board of Equalization's decision, or remand it, or go with what what the taxpayer has done. And from what we've discussed now, what the taxpayer, if we did accept that, it includes income and expenses that are attributable to non-taxable areas. So that puts the whole thing kind of in a cloud. If we did remand it, we could specify exactly what we wanted done, and see what that did. But based on what the taxpayer said today, the whole thing would be negative, and that would certainly be appealed again, obviously.
There's no more communications between the parties and the commission. Just pointing that out. If you want to reopen the record and ask questions, you can. In regards to your broad discretion to do things.
I just wanted to offer that there is a clarification that perhaps could be made that is in the record, but I recognize that that's not proper while you're in deliberations. I was raising the point of whether it would be appropriate to permit that issue to go out of deliberations momentarily to permit that issue to be clarified.
That, I personally wouldn't mind having some additional help or thought on
Yep,
this.
if you have more questions, you get open to split up. If you want to ask more, particularly from the parties, what sort of relief they're looking for, you can do that. You just have to exit deliberations and then reopen to hear more from the parties.
Okay, yeah, I would like to exit our deliberations for right now.
So we're just gonna do it in a motion. So we've
Yeah.
got a motion from Mr. Russ. Any second?
Second.
So all those in favor of, okay. Now, what,
This is still only on the record. You have to point out any corrections, some part of the record. Since we're back on the record between the parties, Mr. Hitchcock.
Well, the clarification is that the property wouldn't be negative by recognizing the exempt bids. It would be negative, well, not negative, but it would be very low if we recognize the percentage of income that's attributable to services and food and care. So there might have been.
Yeah, so we're not getting into testimony. I'm not really sure where, this sounds like Mr. Lee has an objection, and I will maybe agree with him. That doesn't sound, you're getting into dangerous testimony grounds right now, it sounds like. We're not taking testimony, we're seeing oral argument as to it. Is copy of the exemption in the record anywhere? In a form of what? I will, let me point out, so we have the summary of the evidence on page 2 of the initial decision of the decision order of administrative law judge.
Mr. Pope,
I don't see a copy of those exemption records in there.
it's in Mr. Hawks' appraisal.
Okay,
And I can't remember his, but it's in there somewhere, I think.
To avoid the procedural concern, we'll withdraw the comment about that explanation. There's
Okay.
another point that Mr. Dugan wanted to make for the record.
In our exhibit that was provided to the administrative law judge, we do have a cost approach for the property that includes economic external obsolescence, and that number comes to $4,757,018, to which you would add land. I don't know if you want to. Consider that or not.
sure, Mr. So we're one at a time. So you, Mr. Lee, go ahead. Yeah. I think I'm gonna go back to the commission. So what questions do we have for the parties?
I just wanted to, Mr. Hitchcock wanted to clarify something, I think, and so I wanted to hear a clarification if we might have misunderstood something. So that was,
So
And the clarification was simply this. I think, Mr. Chairman, that you had spoken of adopting the appraiser's cost value. I just want to make the point that there are two different cost methods that are included in the evidence, in the record. And were you to remand it for the administrative law judge to consider a cost method, then I would suggest, y'all, when you deliberate, that you consider permitting the administrative law judge to consider whatever evidence on the cost method that you deemed appropriate.
okay.
Maybe we'll summarize this again real quick. I'm just gonna, again, maybe ask the parties to identify specifically what relief you are asking from the commission today.
From the taxpayer standpoint, we ask that the administrative law judge's initial decision order be approved, except as to two issues, two errors that were made. The first was the real estate taxes being added effectively in twice. And the second was the not applying a sales ratio of 89.76 for tax year 2020, so the equalization ratio. Those were the two errors that we asked that it be remanded to correct, but otherwise affirmed.
And Mr. Lee?
He doesn't have a mic.
Oh, yeah, Mr. Lee, let's pass the microphone back to you. Apologize.
Thank you. We asked the commission to find that the administrative judges are not limited to income approach on these types of properties. That's the one thing. And doing that, they're going to, we request that the administrative law judge's initial decision were to be overturned and that the value established by the County Board of Equalization be upheld. To address the taxpayers ratio application, the administrative law judge noted in his decision why he did not apply that, and we think his decision and his position is adequate and in line with policies and procedures of the State Board of Equalization and the Attorney General's opinion.
Any other questions from the commission regarding what actions or any, you want any more definitive statements as to errors that need to be corrected or any other questions from the commission before we re-enter deliberations?
I don't have any, dude. Y'all. Can I ask Mr. Childress a question?
Yep, we're gonna go into deliberations. Mr. Childress, you can ask him questions.
The comment just then that Mr. Hitchcock made. Could we remand this to the administrative law judge, asking him specifically to look at the two cost approaches that were in the record and to take another look at those and just relook at the whole case. I think that's probably the best thing, but can we do that?
Yes, sir. Yeah, you can do that.
Okay. I think that's probably the best thing is in just remanding the whole issue to, and I don't like to kick the can down the road like this, but there are too many questions here that among the three of us that we're not answering adequately. I personally think that the county board's values are too high. I mean, it just doesn't make sense to me that they're that high. But I'm not sure that what the administrative law judge has based his income approach on is correct. And there are a number of issues that in terms of the property tax that that needs to be corrected in any event, and the land value analysis needs to be corrected in any event. And that the land value, if the judge had said he averaged it and then put in a different one, that needs to be corrected. So I think that there are three issues that definitely need to be corrected in any event, and to look at the whole thing again. And we're not responsible for applying the sales ratio. We haven't done that before, have we? I guess, Mr. Childers, you would answer that. I mean, typically it's whatever the property value is, and then the sales ratio is secondary. Because if you're using this as to another county or whatever, the sales ratios are different, I'm sure, in every county.
Sure. Yeah, that's correct.
Okay. So in answer to that question, it would just be the value before any sales ratio.
I guess in our motion, we just need to, when we send it back to the administrative judge, to have him fix the things that you're worried about, or make the decision to go back to cost approach. He would have either option.
I think the whole thing needs to be remanded, and to look at all of the information again. But in any event, those errors need to be corrected.
Yes.
That if
in our motion, we just need to.
Yeah, so I'll make that in motion. We remand the case to the administrative law judge with the following corrections that need to be made in any event, whichever approach or decision comes to, that if the cost approach is used, that the property taxes cannot be added back into the income, and the land value is subtracted from the total value from the income approach only for allocation purposes. But it has to be included and then also to be consistent with the land value from one part to the other. And also to look at the entire record again.
See, you referred to the exempt issue, right?
I don't know. Yes. And in looking at the income approach again, to look specifically at the validity of including income and expenses from the from the exempt portion of the property. All right, we need a second.
Second.
Okay. Okay, all in favor, say aye.
Aye.
Any opposed?
Okay, so just for my clarification, you aren't specifying which type of approach the ALJ you want to use. You're just saying open it up to what's previously been presented, is in the record, and then make a decision.
That's correct. And to make the corrections to any income approach when they look at the income, or when he or she looks at the income approach again.
Okay, so if using the income approach, make sure
Right.
it's consistent. Sure. Okay. Thank you.
Okay, we'll issue an order within 90 days. We'll put you on that same March 10th conference date for follow-up. All right, I know it's, we just hit 12:16. We'll take a break. Let's go ahead and get our last parties up. I believe it's the same taxpayer representative and county for our last 4 appeals for today, if you guys don't mind. Then we can take a break. That's okay.
Take a break now.
Oh, we'll get our parties switched out. We got a couple of preliminary issues we got to
okay.
address in these next appeals. And then we can go from there.
Thank you all very much.
We're going to take about a
And,
10 or 15 minute break.
Yeah, let's go ahead and do. Yeah, I'm sorry, you guys are right. Let's go ahead and take a 15-minute break. Let's get parties switched out, and we'll come back at 12:30. Just to address some preliminary issues. All right, I know it's 4 minutes till. I guess I see Ms. Bible, you're here, ready to go. Mr. Pittman, if you're on the phone, just let us know. We can get ready as soon as you are.
Yes, I'm here.
Okay. So we are still on the record. We're entering our last, I believe it's 4 different appeal numbers for this afternoon. We do have some preliminary issues we have to get through. So I will say, so you got Miss Bible here, so I guess introduce yourself for our commission members.
I'm actually Sarah Willis.
Oh, Sarah Willis, okay.
Willis. I'd leave that Bible
Okay.
in there because it's Bible and Bible, so I'll leave that middle name in there, but it's actually Sarah Willis, but I answer to either. I am a member of the Marion County Bar. I am here representing 4 different appeals, which I will pose that question to the commission, how you would prefer me to present it. They are all 4 different parcels that are relatively close together. When I say relatively, they are less than a mile away. Essentially, it's off of family property. It's all family members, and they all have relatively the same issues that I'm going to be presenting. So I don't want to take more than necessary. So I can present them in such a way to preserve the record that I take each appeal and parcels totally separate and go back over each thing, or I can combine them together. However is more efficient and y'all would prefer, that makes more sense to you guys.
So I'm going to answer some of those questions just because my role here is just to make sure we preside over the hearing, we have a clean record. So we can do, we are relatively flexible. I will advise the commission that you will need to have separate deliberation on each initial decision and order that you are reviewing. However, you as the parties are welcome to incorporate your arguments by reference if they're largely identical for all 4 appeal numbers. But I will go through the steps and read through the initial decision orders on each case and essentially convene them separately. But we have had parties before where their arguments are identical, and so they incorporate their arguments by reference. And then if there is something unique about a specific parcel number, initial decision order, they will kind of announce that, walk through that one issue specifically when we get to it. Does that kind of answer all your questions for that?
So.
Okay. And the commission, that's kind of the general procedure for how we do that. All right, and then for Marion County, can you introduce yourself on the phone?
Daryl Pittman, assessor.
So we have Mr. Pittman and Miss Willis. Okay. So one preliminary issue. I got your email that you sent Miss Kwana Barbie on our staff about some issues with the administrative record for these appeals. Before we begin, we do need to clean up those administrative appeal issues. So I'm going to kind of go through what you have. I printed off copies so we can go all on the same page. I don't know if you have your copies with you. Okay.
And I have a complete extra copy if that's more to.
Okay, yeah, that works. No, all right, so I'm just gonna go through it, and for our commission members, because I know I previously shared a copy of it. We didn't get this until last week, so we didn't have a chance to correct our administrative record before the hearing today. So we're just gonna go through the issues that Ms. Willis has identified, see if we can go about correcting them today. Ms. Willis, you will have to decide if that is sufficient for purposes of your appeal, or if you want to continue these hearings until June. So that's kind of how it's going to have to go through. For our first, no particular order, I was just gonna start with the Jerry Bible appeals. I know there's 2 appeal numbers on those. I have a,
Should be. I'm unclear whether the panel has received and
Yes.
reviewed. Okay, so,
they received the OneDrive file that we shared with you.
okay,
We obviously did not get your corrections until last week.
okay.
So we will need to correct that administrative record moving forward. I will then give the option to you. We can correct those deficiencies of the administrative record, point out what those incorrections were to our commission body, make sure we get that digital file fully updated so that we have a full and complete administrative record for these appeals. And then the choices for you, either we can, spend the time in doing that today and then proceed with arguments accordingly, assuming the commission will also be fine receiving those documents today. Or we can fix those issues and then come back before a new hearing before the Assessment Appeals Commission to make sure that we've given the commission adequate time to review a complete record before the hearing. So I don't know if you've got a preference. If you want to continue the hearings until our next available commission hearing date, so that we have time to correct the record, go ahead and release our commission members. We can do that just today, or we can do it at a different time if you'd like. If you are ready to otherwise proceed, we still do need to go through the individual records and make sure we've got a complete access for them. So not to put you on the spot, but I don't know which one you want to do on that.
I say proceed if there's something that, obviously if the commissioner thinks that they need more time to review it, we can address that then, but we can go through it and see if there's an issue.
Yeah, sounds good. All right, so Mr. Pittman, I know you were on a phone line. I don't know if you can see our shared screen. Do my best to dictate kind of where we're at with everything. So again, no particular order. I picked up in regard to Jerry Bible, record appeal number 133920. I got an email from Ms. Bible with several attachments identifying deficiencies in the 4 administrative records that we have for consideration today. This being, again, appeal number 133920. Ms. Willis, I keep calling you Ms. Bible, I apologize for that too. All right, Ms. Willis, I have, you identified that Exhibit 1 appears that file has been corrupted. We were not able to open it. I'm not able to open it on my computer. Do you have a copy of that Exhibit 1?
I do, Your Honor. I'm sorry, I'm going to default to
You
Your
can
Honor
call
too,
me
just
Your
out of.
Honor. It's fine. Yeah,
Let me pull from, yeah.
it's a big administrative and little judge. And I guess Mr. Pittman, I know you were not here. I don't know if you have any objections to supplementing the record here. We've got an Exhibit 1. It appears to be a printout of the Constitution of the State of Tennessee that's been, it's not otherwise annotated or anything like that. Mr. Pittman, do you have any objection to us correcting the record using this exhibit?
No, I don't.
And Ms. Willis, if you don't mind, I'm going to keep this in our pile, put that together.
And that will be, that's the only question kind of just before we get diving into these. That will be the same for all 4
Okay, yeah,
ones. So.
we can use this for all.
Okay.
Yeah. Exhibit 1. We then go through, no issue with, excuse me, item number 2 in the administrative record. I believe this is a reference to Exhibit 2. Is that correct?
Correct.
That being a document labeled History of Equalization, Tennessee. Is that correct?
Yes.
No issue with that one. Moving on to Exhibit 3. You said correct, but Exhibit is in there 2 times.
Yes, it appeared to be scanned in there twice. It was the same thing. It was just duplicated in there.
Okay.
Which was fine from it just wanted to point out it's in there twice.
And I have this as a 19-page document.
I have it as pages count. I don't have that pulled up.
Session also 12:30, and Ms. Wilson says she's fine proceeding. Just want to make sure you're.
Want to go ahead?
Just want to make sure before I or steamroll everyone over. Skipping that.
File. It wasn't that it made it at the end, it in separate PDFs.
But
No, they have. May have just been from my screen. The PDF appears
Okay.
to be correct.
Okay.
It appeared to be in that list. Exhibit 3 was listed twice as two. They were identical, but listed separate PDF.
We had Exhibit 4 listed on ours as Exhibit 4, Land Trust newspaper article, being a PDF document that's 2 pages, including the cover page. So there's no issue with that one. My messaging. Need the VCC to display the room. Give me a second. I'm trying to make this thing. You can go to the podium and switch it to the click to share. Okay. See the screen behind you? I know it's a little bit inconvenient to crane your neck. I have this as Exhibit 4, a cover page, and then a one-page land trust buyers market. I have on here that you said this is the correct exhibit number for this. Is that? Next one being Exhibit 5, Tennessee River Gorge warranty deed. Down. Have a 10-page document. No cover page. The second warranty deed in the packet is cut off and not the entire document. Is the page you're referring to that's cut off? Page.
That whole one had extra, because I was actually done.
Yeah.
And
if
what I
you've got
sent,
a
so I
complete
have
copy.
multiple copies.
Take one. Down to- This is the corrected Exhibit 5. Part of it was cut off, I believe. First, want to make sure this is the same Exhibit 5. This is only a partial exhibit. Do you have the full exhibit?
The first, there's two separate warranty deeds in there, and the first warranty deed wasn't cut off, so wasn't any issue with it. It was just the second warranty deed. But I have an extra copy here if you want to present it, if you want a full copy of the exhibit.
Yes, if you have a full copy.
Some there was, some there wasn't, just.
Okay, I've got an 11-page document, including the exhibit, yellow exhibit cover page. Mr. Pittman, do you need a copy of this, or do you otherwise object to us correcting Exhibit 5 with the copy Ms. Willis has provided?
That's the Tennessee River Gorge warranty deed,
Correct.
number 5. No, that's fine.
Exhibit 6, you notice that the cover page was missing, but otherwise correct. I have this parcel map 105001. It's a 12-page document. See, some of these are upside down. Is this the correct 12 pages? Moving on to exhibit 7, parcel map 104.013.02. 6-page document. Does this appear to be the same?
Yes.
I have a Mullins Cove Road 4190. Exhibit number 8, we have an issue with identified, no cover exhibit page, cuts off the bottom of the third photo. So in our OneDrive, this is what it appears to be, a scanned in copy, a one-page document that cuts off the bottom of the third photo. Do you have a corrected exhibit or a copy of that third photo? Thank you. Well, Matthew, do you mind passing out a copy of the photo to our commission members? Third one. Off some gravel. That being exhibit 8. All right, I have on here that you listed no issue with exhibit 9, but an issue with, it says number 10, I believe that's exhibit 10, Little Cedar Mountain newspaper article. That up here is what we have listed as exhibit 10. I have an 11-page document. You said there's an issue with an article. Like an article in here as Thunder Enterprises acquires 2,400 acres for another mountaintop development. Is that correct?
That is not, I've got a corrected one. It would be an article on updated TW pricing. Mountains.
This is a copy of the article. Exhibit 10. If you've got do you have a copy of the correct?
No, I don't have an extra.
That's okay. I'm gonna ask you,
We might have some other copies. Oh,
keep that
Are you
together.
sure?
I will need a copy. I will need that back.
are you sure it's not in?
So we had no issue, substantive issue with number 11 being exhibit 11. Number 12, 13, 14, 15, 16, 17, moving on to what I believe is exhibit 18. Cover page says exhibit 8, should say 18. Photos are correct. There are 2 duplicate files of exhibit 18. This is what I have listed as exhibit 18. See, it is, the cover page says exhibit 8. I've got 1, 2, 4, 5, 7 photos in here. No issue with these 7 photos.
Yes, no issue with that.
And so your comment that there are 2 duplicate files of exhibit 18, are you saying exhibit 18 is listed in your file twice, or?
I don't.
When you pull it up on what we were shared, it shows exhibit 18, but the sheet shows exhibit 8.
Yeah, we pointed that
Okay.
out. Okay.
They're not here.
Okay. Exhibit 19 is correct. Exhibit 20 is otherwise correct, minus the exhibit cover page. Exhibit 21 That's off the bottom photo of the first page, but has all photos there. Okay. So exhibit 21, photos. Copy of that
I
photo that's
do.
cut off. Okay. You can see that. No issue with exhibit 22 other than the cover page is missing, and then exhibit 23 I have as the subject property tax card. This is not presented at the hearing. You know if this was included with the initial appeal filing?
It's never,
Now we'll strike it from the record unless Mr. Pittman, you have any objection?
On which part? On 23?
Yeah, the property record card. Ms. Willis says that it was never officially entered as an exhibit and should be stricken from the record.
Okay. I mean, that's fine.
It's from I believe that corrects our issues with the administrative record for Jerry B. Bible, record 133920. We want to go ahead and go through this appeal first and then all the records and then
I can do either way. That one, they will be identical, just on this, identical to what we just went through.
okay, it's the same exact exhibits and everything else.
Yes,
Okay.
yes. Because it's the two Mr. Bible's property.
We have done is corrected the administrative record for the missing or incomplete exhibits for in regard to Jerry Bible appeal number 133920. Willis has identified the exact same corrections apply to Jerry Bible record 133921. Otherwise, skip that step. It's either going to be Leon Thomason or Timothy Todd Thompson.
We can do Mr. Leon Thomas.
Leon. The virtual link. So now we're going to correct the record for Leon Thomason. Is there all right, I have notes that 1, 2, 3, 4, 5, excuse me, 1 through 4 are correct. Number 5, is that Exhibit 5, the Tennessee River Gorge warranty deed?
Yes, and that's going to be the same. Presented. exhibit, but I've got an additional copy.
And so commission members, this is just an updated copy of that warranty deed that had it was cut off at the bottom for our other appeals. That. Number 6, page, but correct. Number 7, no exhibit, page exhibit, but correct. Number 8, correct but not correct, combines multiple Bible exhibits incorrectly. So I'm going to pull up a copy of what we have as. It's referring to Exhibit 8. Exhibit 8 as an aerial map with several photos. I have the same, got a 14-page document in here. Got some aerial photos on the screen. Said it combines multiple Bible exhibits incorrectly. I'm not sure.
It was because part rated by reference. So it should. Aerial photo, and it shouldn't be there. And photos of geese and geese.
Okay, so it should be these 1, 2, 3, 4 photos, 5 photos, including the dock, 6, including 7. It shouldn't include these aerial photos.
These aren't aerial photos. That's aerial.
So this should be included or not included?
Be in it. That should be Exhibit 9, part of Exhibit 9, yes.
I have a photo, Exhibit 9 listed as taxpayer Exhibit 9, photos of the river. So on my screen, I have Exhibit 9. It's got that same photo.
Yes, it
And a
should,
dark page.
it should just be 2 aerial photos. Got copies of them here. I can have the vegetation there.
Have complete exhibits for Exhibit 8 and 9.
No, I don't. It. Presented as a set. Have one of these.
I'm trying to clean up this record. I have an administrative law judge order that only says the exhibits are Exhibit 8, photo of birds of the subject property, and so you're saying that those are not the incorrect exhibits that are on the OneDrive. Okay, so do you have a? Do you have a correct copy of the exhibits for?
I do not have a complete of it again because we had a note in there, so we could just put a note with it that by reference it.
Bible.
Yes.
Okay.
So that's why it has, and that's why actually in ours, or what was submitted to the administrative judge. Oh, I'm sorry.
understand it's the Exhibit 18 from the Jerry Bible. Oh, perfect. Okay. Yeah, I'm tracking now. I'm tracking. Oh, do not supervise the administrative judge. Update exhibits. Mr. Pittman, if you're still with us, I'm assuming there's no objection. Same exhibit, the photos. I guess we're in the OneDrive. They've just been corrected. Size it correctly. Exhibit 11, I have as the subject property tax record card. You're saying that should be.
So was I sent these corrections? I don't, that's got me messed up.
So. What I understand, it's the same, it's photos that were already in the record in other places. They simply were mislabeled as either Exhibit 8 or Exhibit 9. So Ms. Willis has updated those photos to restrict to the correct exhibit number, as it were. But they otherwise were included at the hearing or otherwise part of the Jerry Bible appeals at the administrative law judge level. It's all the same photos. It's nothing new. It's no new photos that were not otherwise in the record. Is my understanding. It's just clarifying which ones were Exhibit 8 versus 9 versus.
And I believe he was emailed a copy. Judge Cocker. I believe he was copied. His emails may have an actual PDF of these in his email that may be even better than shared.
I don't have. Yeah, I don't have access to that. So I guess I will point out, maybe for clarity for everyone's purposes, just to understand kind of what happens.
Well, that's what was sent to in correction. I just forwarded Judge Cochran's the emails where I sent them to him to make it part of the exhibits. I emailed it to Ms. Barbary. So that's what I just forwarded on. So it was actually what was submitted to Judge Cochran. I just forwarded the emails directly to Ms. Barbary. So, and I believe.
I did not get a copy of those exhibits.
Oh, okay. But I think Mr. Pittman was originally when Mr.
Yes,
Cochran.
I see a May 3rd, 2022 email. Jerome Cochran copying D. Pittman 2 at MarionCountyTennessee.net. And a couple of other email addresses saying, I have sent the following emails, Bible exhibits 1 through 7. Email contains exhibits 8 through 14. Yeah, I see what you're talking through back in May. Last one, Leon Thomason. Not Leon Thomason.
Mr. Timothy Thomas, he is up here for just record.
Okay. Admin record, I've got labels 1 through 14. Assuming that relates to exhibits 1 through. Correct. 5, correct, but the second warranty deed in the packet is cut off. It would be the same.
It would.
Make a note.
I've got where I can hand you another one that
That'd be great.
help that.
Commissioner, this is the same warranty deed. We're just correcting the record for the specific appeal. 7 are correct, minus the missing cover exhibit page. Exhibit 8 is correct. Exhibit 9 combines multiple photos. Bible exhibits incorrectly. I have here listed as Exhibit 9, page document with 1, 2, 3, 4, 5, 6, 7 photos in it. But we were saying these photos are the incorrect ones for Timothy Todd Thomason.
Be on top.
So if this is the same exhibit.
That's gonna be the same
Exhibit
as
18 from the Jerry Bible.
yes. And I don't have another copy on that last one.
And 10, exhibit 10, appears we've got an issue. So I have my exhibit 10 as exhibit 10 in the Timothy Todd Thomason folder. I have listed as photos of the river. I have, when I open the document, I have a 15-page document. Does this look correct or incorrect?
I know it's what I have notes, but I have those.
Okay, yeah. So Mr. Pittman, I realize today, if you would like, we can scan these and send you a copy of an issue. Large.
Okay, I've got them here. I found them where she was talking about, she sent them to me. It's the original pictures, it's just everything got labeled wrong,
Yes.
correct?
Yes, I
Okay.
think that is correct.
I think in the record though, it's missing the FEMA
missing the
flood
large
map.
ones.
Yeah, it's missing part of it that were scanned in separately.
I'll maybe point out that the administrative judges charged with completing a record for hearings. They have previously using different software. They've changed their software. They are using compilation of the administrative record. That did not occur at the time of your hearing. You have Exhibit 12, which I believe is probably, again, the property record card should be stricken from. That Exhibit 13 was not presented. I have that as, again, photo duplicate. Okay, we've just corrected, I believe that was Exhibit.
Yes.
Yeah, so I will delete this one. Administrative law judge's decision on page. So this is where we get a little bit tricky scenario. Administrative law judge pointed out on Timothy Todd Thomason, Exhibit 13 that had photos of the river, but you're saying there was not an Exhibit 13 at this hearing?
That one is a duplicate of
Mr. Childress, can you also just, I'm going to try and make a note here as well. Just Ian is, that Willis is stating was not actually at the hearing. Otherwise, a duplicate of the previous Exhibit 9, so therefore I'm going to delete it from the administrative law, from the administrative record OneDrive file. And then you said the same thing for Exhibit 14, which is again photos of the river. I think these were, at least it was part of somebody else's. Was this a?
Oh, no, I'm sorry. It's part of Bible.
Same thing for exhibit 14. Judicial notice, I guess, for lack of a better word.
There should be another duplicate like what I have here that was hand delivered to the Judge Cochran's office. So there's another
We
one
don't
of
have
these
that.
floating around somewhere.
Yeah, they did not.
Just
Um,
both in case they're, track that down.
I
somewhere.
wish. Okay, I do believe that corrects administrative record issue. With any of these appeals. Number 13392. I will read the case caption so we can exactly which. And I will again read it quite quickly into the administrative record for all of us to go through. I have a physical copy for all our commissioners.
Okay, the phone's getting to where it's breaking up and I can't hear half of what you are saying.
Thank you, Mr. Pittman. I was not saying anything particularly important. I was passing out copies of the initial decision and order for Jerry Bible. The case caption in regard to Jerry Bible B, property ID 104, parcel 1302, special interest 000, Marion County, tax year 2021, appeal number 133920. I'm not going to read this administrative law judge's decision real quickly. Give it a initial decision order. Statement of the case. The Marion County Board of Equalization, hereinafter the local board, has valued the subject property for tax purposes as follows. Land value $216,800, improvement value of $285,700, total value of $502,500 for an assessment of $125,625. Taxpayer filed an appeal with the State Board of Equalization, hereinafter the State Board, on July 29th, 2021. The Interstate Administrative Law Judge conducted a telephonic hearing of this matter on May 4th. The appellant, Jerry Bible, represented himself at the hearing, hereinafter of the taxpayer. The Marion County Assessor of Property was represented by the Assessor of Property, Daryl Pittman, hereinafter the Assessor's Office. Summary of the evidence. The taxpayer testified on his own behalf and the Assessor of Property testified on behalf of the Assessor's Office. The following exhibits were introduced. Exhibit 1, the Tennessee State Constitution. Exhibit 2, History of Equalization in Tennessee. Exhibit 3, list of members of the Marion County Board of Equalization. Exhibit 4, Land Trust newspaper article. Exhibit 5, the Tennessee River Gorge warranty deed. Exhibit 6, parcel map 105, 001. Exhibit 7, parcel map control map 104, parcel 1302, exhibit 8, river photos, exhibit 9, parcel map 146, 001.00, exhibit 10, Little Cedar Mountain newspaper article, exhibit 11, parcel map 104, 001.06, exhibit 12, division of water resources notes, exhibit 13, photos of attached solarium, exhibit 14, photos of house and support pole, exhibit 15, photos of the door seal, exhibit 16, photos of the underside of the roof, exhibit 17, photos of the driveway, exhibit 18, photos of the topography of the subject property, exhibit 19, water depth chart, exhibit 20, photos of the river, exhibit 21, photos of flooding on the subject property with attached flood zone map, exhibit 22, parcel map 123.017.00, and exhibit 23, the subject property's tax card. Findings of fact. The subject property in this appeal consists of a house on approximately 10.84 acres built in 1983 at 4070 Mullins Cove Road in Whitwell, Tennessee. The taxpayer contended the subject property should be valued at $405,400. The assessor's office requested the local board's decision of $502,500 be affirmed. The taxpayer raised the following issues to support his contention that the local board's valuation of the subject property is incorrect and that his proposed value should be adopted. 1. Surrounding properties that are in substantially better condition than the subject property are valued lower with favoritism to state-owned properties. 2, the assessor's office has offered no comparable properties or proof to support the value placed on the subject property. 3, the local board was biased in the valuation of the subject property. Number 4, the subject property has not been modified since previous assessment and is in need of upgrades and repairs. The assessor's office provided no valuation analysis to support the value affirmed by the local board. Continuing on page 3, applicable law. The basis of valuation set out in Tennessee Code Annotated Section 67-5-601 subsection A is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1-.11 subsection 1. Determination. Based on a review of the testimony and evidence, the taxpayer failed to meet his burden of proof in this matter, and therefore the local board's valuation of the subject property is affirmed. The taxpayer testified that the assessed value of their property had increased at a higher percentage than another nearby property. However, the Assessment Appeals Commission has repeatedly rejected arguments based on the amount by which an appraisal has increased as a consequence of reappraisal. For example, the Commission rejected such an argument in E.B. Kissel Jr., Shelby County Tax Years 1991-1992, reasoning in pertinent part as follows. The rate of increase in the assessment of the subject property since the last reappraisal, or even last year, may be alarming, but is not evidence that the value is wrong. It is conceivable that values may change dramatically for some properties even over so short of time as a year. Final decision order at 2. It is further noted that as the assessor's office testified that state-owned property is not taxable. With respect to the structural issues of the house, merely reciting factors that could cause a diminution in value does not establish the current appraisal exceeds market value. The Assessment Appeals Commission has ruled on numerous occasions that one must quantify the loss. In value, one contends has not been adequately considered. That is Fred and Ann Ruth Honeycutt, Carter County, Tax Years 1995, wherein the Assessment Appeals Commission ruled that the taxpayer introduced insufficient evidence to quantify the loss in value from the stigma associated with a gasoline spill. The Commission stated in pertinent part, the assessor conceded that the gasoline spill affected the value of the property, but he asserted that his valuation already reflects a deduction of 15% for the effects of the spill. The administrative judge rejected Mr. Honeycutt's claim for an additional reduction in the taxable value, noting that he had not produced evidence by which to quantify the effect of the, quote, stigma, end quote. The commission finds itself in the same position, conceding that the marketability of a property may be affected by contamination of a neighboring property. We must have proof that allows us to quantify the loss in value, such as sales of comparable properties. Absent this proof, here we must accept as sufficient the assessor's attempts to reflect environmental conditions in the present value of the property. Then cites that as final decision order at 1 and 2. Similarly, in Kenneth R. and Rebecca L. Adams, Shelby County Tax Year 1998, the commission ruled in relevant part, quote, the taxpayer also claimed that the land value set by the assessing authorities was too high. In support of that position, she claimed that the use of surrounding property detracted from the value of their property. As to the assertion the use of properties has a detrimental effect on the value of the subject property, that assertion, without some valid method of quantifying the same, is meaningless. Final decision order at 2. The taxpayer also alleged biasness in the local board, however, provided no proof to support this allegation. The assessor's office provided no proof to support the valuation affirmed by the local board, and the taxpayer contends that this fact should weigh in favor of their contended valuation. However, as stated earlier in this order, the burden of proof in this matter rests with the taxpayer. The assessor's office has no requirement to present any evidence to support their valuation or that of the local board. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. The taxpayer has failed to meet their burden of proof in this matter, and the local board's valuation of the subject property is affirmed. Order. It is therefore ordered that the following values be adopted for tax year 2021. Land value, $216,800, improvement value of $285,700, and total value of $502,500 for an assessment of $125,625. Then continues on page 5 with available remedies, including appeal to this current body, which is why we are here today. Followed by on page 6, entry of the order on May 19th, 2022 by Administrative Judge Jerome Cochran and a certificate of service noting that the decision was sent to the parties on May 19th, 2022. that is the decision we are here to review. To summarize where we are at, we went through the administrative record and corrected the deficiencies that we had on this appeal, noted by Ms. Willis before we began. We then corrected that and handed out copies to the commission for their review. We are otherwise not hearing any testimony today. We are not we're not receiving any new documents or evidence. We just corrected the evidence that was presented to the administrative law judge. We're otherwise here only your arguments. Same standards we had for all our cases. With that, I'll hand it over to Ms. Willis for oral arguments. If you would like to refer to any documents in the administrative record, I can help facilitate that by pulling them up on the screen, but other than that, floor is yours.
And I already introduced myself, but I'm Sarah Willis. I'm here representing Mr. Jerry Bible and Miss Deborah Bible, who are here present with me today.
Excuse me, ma'am, could you use the microphone, please?
Yes, I've
Thank
never
you.
been told not that people couldn't hear me, so they would say I'm too loud, so. I'm here representing Mr. Jerry Bible, Miss Deborah Bible, who are here present with me today. I would ask that you keep in mind we're addressing appeal number 133920. However, please take notice that a lot of these facts will overlap with all four cases, but specifically 133921, which is in regards to Mr. and Ms. Bible's property as well. It is our position that the administrative judge's decision regarding the assessment of Mr. and Ms. Bible's real property should be remanded, reversed, and/or modified because Mr. and Mr. Bible's rights have been prejudiced. The administrative judge's decision is all of these: A, in violation of constitutional and statutory provisions; B, made upon unlawful procedure; C, arbitrary and capricious, an abuse of discretion and clearly unwarranted exercise of discretion; and D, unsupported by the evidence that is both substantial and material in light of the entire record. The administrative judge's initial decision and order states multiple times that the burden of proof in this matter rests with the taxpayer. We recognize that the case law states that the burden is on the taxpayer to prove that the tax assessment is erroneous. However, the administrative judge failed to acknowledge and apply the standard held by the Tennessee Court of Appeals, which is taxation statutes must be liberally construed in favor of the taxpayer and strictly construed against the taxing authority. That's found in Tennessee Court of Appeals, or the Tennessee Court of Appeals of Knoxville has found that. That's in a decision that was dated November 5th, 2021. As a result, the administrative judge applied an incorrect standard review in this matter, which was detrimental to Mr. and Mr. Bible. Further, the administrative judge erred in finding Mr. and Mrs. Bible did not meet their burden as their position is supported by substantial and material evidence. You've already seen we have a whole record of exhibits that would support their position. Nothing was presented in support of the tax assessor's valuation. They didn't present any exhibits and didn't even present any comparable properties to compare to this and what their valuation was based off of. The actions of the state and county boards of equalization are in violation of the constitutional and statutory provisions and an exercise of unlawful procedure. Further, the actions of the state and county boards of equalization were arbitrary, capricious, and unwarranted exercises of discretion and in violation of the Tennessee Constitution, specifically Article 2, Section 28, and further case law. Exhibit 1 was the Tennessee Constitution.
I'm sorry, are you making constitutional arguments?
Yes.
So I have to direct the commission that we do not have authority for certain constitutional arguments. As an administrative body, some of those arguments you will have to bring to Chancery Court. Specifically, we can't decide any of the laws are unconstitutional. There is some discretion to decide if they're the basis of the appeal was are we getting in trouble for that? We can't do Christian constitutional. It's more of like, was it as applied, not whether the law or the decisions are unconstitutional themselves, but are they constitutional as applied? So I just will make that sort of brief sort of explanatory statement.
And just to clarify, in the notice of hearing, it states as one of the factors that the commissioners can use to reverse, modify, any of these decisions, A, is stated that, or I think it's number one listed on that notice of hearing, in violation of constitutional and/or statutory provisions. That's one factor you guys can look at here. It's stated in the notice of hearing.
Correct. Sorry. Yeah. You're absolutely correct. She's correct. I just wanted to clarify. It's just you don't have authority to decide a law is unconstitutional, but it's whether it was held within constitutional standards. So just to clarify that one little piece. But yes, you are absolutely correct. I just wanted to clarify that for our commission members because there's some limitations in their authority when it comes to certain constitutional issues. I apologize for that, but please continue.
The Tennessee State Constitution states that in accordance with the following provisions, all property, real, personal, or mixed, shall be subject to taxation. Then exhibit number 2 you have, which is a article, and it's titled History of Equalization in Tennessee. It's prepared by the State of Tennessee Comptroller of the Treasury Office of General Counsel, and it's published November of 2020. And it breaks down several of these factors and gives a more intensive background as to each of these things and what can be, what needs to be assessed. The Tennessee Constitution further provides that the ratio of assessment to value of property in each class or subclass shall be equal and uniform throughout the state. The value and definition of property in each class or subclass to be ascertained in such manner as the legislation shall direct. Case law supports that the Tennessee courts have consistently ruled that all property must be valued at 100% of market value. This includes real property owned by the state of Tennessee and the Tennessee River Gorge. That's the reason you guys were presented with a copy of the deeds as far as the state of Tennessee and the Tennessee River Gorge. These properties are currently not being assessed at 100% of their market value. The state of Tennessee and the Tennessee River Gorge properties are prime real properties valued at less than $2,000 an acre. $2,000 an acre. We recognize the state of Tennessee has certain immunities to lawsuits and other actions, but they are not immune from being appraised at 100% of their market value. This leaves the Bible family and other landowners to bear the brunt of the tax burden for payment of real property taxes in those areas. Guys, since I'm dealing with 4 properties as well, and we're bringing in the Tennessee, this is just a demonstrative to give an idea as far as the property. I'm not submitting it as an exhibit, just for you guys to have an idea. I'm bringing into this the state of Tennessee and the Tennessee River Gorge. I think it kind of have an idea where. I can do it. No. Are. Property that you saw where you saw it.
Did I lose y'all?
Oh yeah. Sorry, Miss Bible. You can pull that microphone out if you wanted to. Sorry, Mr. Pittman, Miss Willis had stepped away from her microphone to stand, and so she now has that microphone back with her. So,
And
sorry
Mr.
about
Pittman, just to give you an idea of what I'm doing, I've just got a blown up printout of around Mullins Cove, just the layout, so they have an idea of where the state property is, where the Tennessee River Gorge is in relation to all of these properties. And I know you're very familiar with knowing what the surrounding properties are. So that's all I'm doing is giving some context here.
Okay, I just want to make sure I didn't lose you.
So you have the state of Tennessee over here, and this property, being the state of Tennessee, it is set at $1,600 per acre. It's got all this riverfront property, the bluff view that you saw up on the screen earlier that was
State-owned land.
that's state-owned land by the state of Tennessee. Then you've got the Tennessee River Gorge, which is set up as a Tennessee River Gorge Trust, which effectively at some point it will probably roll into the state of Tennessee, but at this time it's set up, it's being used basically for the same purpose as the state of Tennessee. Then you've even got Prentice Cooper that's farther up here, just to give you some perspective. It doesn't go up that high, but it would be up here.
This Prentice.
It's the same as like the Tennessee River Gorge. It's a state forest. It allows hunting on there. Have scheduled, have hiking trails, campsites. They've got all the
State-owned land.
yes, yes. And then you've got their properties down here. This one's set at $1,600 per acre. Tennessee River Gorge, it's set at $1,889.89 per acre. Down here, and it's got some riverfront property as well right here that it comes down. Then you've got Mr. Bibles. This piece of property set at $20,000 per acre. This piece of property is set at, and it's 3.12. It comes into the other appeal number that we've got listed next, and it's 3.12 acres. It's set at $58,012.82 per acre. And then you've got a piece of property over here, which is currently in the process of being appealed in 2000 and this property's been owned by Mr. Bible for quite some time now. He purchased a piece of property between his and the county road there, which effectively became his whole property there. And it is 1.6 acres there. There was, in 2021, there was a boundary line survey that was created by a surveyor. Quite frankly, it was in anticipation of conveying property to myself. I'm their daughter. Nothing ever happened. There's restrictions there per the survey that there's restrictions there. There's also other problems with drainage. There's a wet water spring. There's problems with building there. When the surveyor, without unknown to Mr. Bible, that survey was filed with the registrar's office. No transfer of property, no sale of property. None of these properties have been sold or been owned, family owned by Mr. and Ms. Bible for probably over 40 years now. With the exception of the small piece that went up to the road right here. When that boundary survey was filed in 2021, that property value, I'll get into that, but just filing the boundary line survey, that property value went up for no reason whatsoever. It reduced acreage from this lot, but this property value didn't change. And the price per acre did not change. Even though it took property from here, placed it here, and this went up a lot, which I'll get into the specifics of that. But just to give you relation, then you've got over here, to go ahead and point out, you've got Mr. Leon Thomason's property here and Mr. Todd Thomason's property here, and then the ones beside there that will become relevant, but I'll get to those ones.
Let me ask you, does those properties join the water?
Yes.
They do, okay.
Which properties are you referring to?
Your properties.
Yes, they are
Okay.
riverfront, but the state of Tennessee's is also riverfront
Sure.
property as well.
All right.
So all three of those, including the one that was split out, are in the same ownership's name.
Yes. They have not changed, with the exception of a small piece of property that went up to the road. There has been no change of ownership, no sale, nothing.
What's the total acreage of all three combined?
Approximately 15 acres total.
Are y'all just talking about the three properties under appeal?
I'm
Or
sorry.
is that just the,
I'm sorry.
is that just the, right now we are initial
Yes,
decision
the-
order for,
Just to explain, there's only two
Yeah.
pieces of property that are under appeal at this stage. The other one, where the boundary line survey was filed with the registrar's office, that one we presented at the administrative level. We were told we could not proceed. It's relevant as to the property values and comparative property values. We could not proceed arguing with it, and trying to set that value aside. It needed to go through the tax assessor's office. Nothing has happened to change that value. The tax assessors will notice that we plan to, but it wasn't a reassessment period, so there's not a formal, you automatically can go ahead and appeal, so we've got to go through that route with it, so.
Ms. Willis, that one has been changed. I don't know what tax card you've got.
yeah, so I'm just gonna maybe refocus all our focus. So again, we're only here oral argument about why the administrative law
Right.
judge's decision was correct or incorrect. So I know
Okay.
we had a
I'll get
demonstrative
that.
exhibit.
Okay.
So yeah, sorry, Mr. Pittman, I didn't mean to necessarily cut you off on that, but with regards to
No,
the
that's
other
fine.
ones
I'm
that
just
are,
saying, I'll get with her or Mr. Bible on that one later on and explain what's happened on that.
okay, that sounds good.
Okay.
But it's
So-
still relevant where it arbitrarily and capriciously changes the values of these for no reason, with no comparative valuations to support any of those findings of what those, and they're all different. And you'll see through Mr. Timothy Thomason's and Mr. Leon Thomason's, their property values similarly situated, same type properties, totally different price per acres. And we're just talking about the land. We're not even talking about structures on the land, improvements. We're just talking about the land here and how different they are in valuations. Moving on though, the Tennessee and Marion County, I'm sorry.
Property that was pulled out, excuse me, the property that was pulled out and surveyed, is that area, you said not subtracted from one of the others that we're talking about today?
Yes, that is correct. It has not been, the acreage hasn't been subtracted and the valuation hasn't been, it hasn't been changed at all.
Has there ever been a formal subdivision?
No. I have a copy, I don't know what, if I can present that. I have a copy of the survey from that.
But-
I don't have, I mean, it wasn't presented as an exhibit. The restrictions were presented as an exhibit to building on that piece of property, and what issues you would have with it. But no, it has not, there's no subdivision there. It's just family-owned property.
So I guess what I'm asking then is, and maybe I'm getting ahead of myself, the two properties that we're talking about includes that property that has been surveyed right now?
Correct.
Okay.
Correct.
Okay, thank you.
Yes, the property surveyed reduces, let me make sure if it's this appeal or if it's the next appeal. Let me make sure by the
So
track.
this is for, so the one that we were reviewing right now currently, the administrative law judge notes on page 2, it's for 4070 Mullins Cove Road. I don't know if the street
Yes.
address helps.
Yes,
Okay.
and that's the thing, the 4070 Mullins Cove Road, that.
Okay.
Actually, the one that was changed, Miss Willis, was the 4190.
That is correct. It was changed. The 4190, which would be the technically the next appeal. The 4190, they did reduce the value on it. And they just took it back to the 2020 assessed value.
You're saying the county board or the,
County board did.
Okay.
The county board took it back to the 2020 assessed value. Problem is, that was before property was taken off of it for that, where the survey was done. And they added it onto here, took it off of here, and there's been no change to the value at all.
I'm kind of confused as to what we're looking at.
yeah, I don't, so again, we're, so the.
I might
I don't mean to butt in,
I'm
but we're
sorry.
talking about the wrong properties. We're switching back
I'm
and
gonna-
forth from 4070 to 4190. We need to stay
Yeah,
on
agreed.
47.
let's stay a little bit focused. So again, we are reviewing, we're going to have the commission deliberate separately for each decision that's up for review. So right now, let's focus only on, in regard to Jerry Bible, property ID 104-01302, that being noted on the initial decision order as the street address being 4070 Mullins Cove Road. As a reminder, we are only here to know why this administrative law judge's decision was decided correctly or incorrectly. The commission has no ability to change the findings of facts done by the administrative judge. So if you're contending, I heard you listed all four of bases for why the decision, your rights have been prejudiced under this. Perhaps we would start with that. Again, how was this decision decided in violation of statutory law, or what parts of this decision were unsupported by evidence in the record? We're reviewing this decision, not the assessment.
Okay. Going back to those factors, as I stated, the A, B, C, and D. The Board of Equalization of the Marion County Property Assessors have shown obvious favoritism and prejudicial attitude towards the real properties owned by the state of Tennessee and the Tennessee River Gorge. The state of Tennessee shows favoritism and prejudicial attitude to both its own property and to the properties of the Tennessee River Gorge Trust, as the state of Tennessee has in the past received real properties from them. Because of this past relationship of receiving properties from the Tennessee River Gorge, the state of Tennessee expects over time to take ownership of the trust's real property and therefore treats the Tennessee River Gorge differently from other taxpayers. The state of Tennessee Board of Equalization, because of this relationship, is biased, conflicted, and prejudicial in favor of properties owned by the state of Tennessee and the Tennessee River Gorge. The Marion County Board is further biased and conflicted and compromised in dealing with the appraisals of the real property because of the makeup of the local board. One of the Marion County Board members has in the past.
Ms. Bible, I'm sorry. What part of the decision are you agreeing?
Oh, I'm sorry.
with?
I'm arguing that at this point that it's arbitrary and capricious is what I'm arguing at this point, that the administrative law's decision was arbitrary and capricious. In supporting.
What part of the judge's decision?
Where he states that there was no proof, the taxpayer also alleged biasness in the local board, however, provided no proof to support this allegation. If you will see in exhibit number 3, collective exhibit number 3 of the Marion County Board of Equalization, it has a list of the Marion County Board of Equalization board members, and it has information about each of the board members and would support the bias of them. One of the Marion County board members has in the past served as the deputy tax assessor in the Marion County office. 3 out of the 5 members of the Marion County Board have worked professionally at buying and selling real property. 2 of the members are real estate agents, and a third has been the owner of a property management company which bought and sold real properties for profit. Each of these members have a vested interest and would stand to profit from higher appraised property values. 2 out of the 5 members of the Marion County Board were not even present for the hearing before the Marion County Board. Out of the members who were present, one other was an alternate board member. Only 2 out of the 5 members would not have profited. Only 2 out of the 5 members would not have profited from raising the assessed values. The Marion County Board presented even at the Marion County Board stage, they presented no comparative property values. At no stage has there been anything to support what their valuation is. The Marion County Board presented no comparative properties to show a basis of how to establish the appraisal for our properties, and the Marion County Board still to this day has not offered any proof. Even at the administrative law proceeding in front of Judge Cochran, Mr. Darrell Pittman presented no evidence in support of comparative, and at the local stage, we were even able to ask questions and ask those. None have ever been presented. We have presented sufficient evidence and proof to show that the conclusion reached by the Marion County Board of Assessors and now upheld by the administrative law judge regarding these properties are an error and incorrect. the burden of proof on the landowner for this type of proceeding is not overly high. Case law has said that it's not overly high to meet the burden to set these aside or to reassess it. And we've presented proof and evidence that has rose far beyond the preponderance of the evidence. So we must surmise without the supporting materials, the state board and the county boards acted without a basis for its action, therefore is acted, and with that, the administrative law judge therefore acted unreasonably, arbitrarily, and capriciously and violated the Tennessee Constitution. Further, this would address the issues with violation of constitutional and statutory provisions. And also that would be unlawful procedure as well. The fact that the administrative judge found that there was not enough proof supported by Mr. and Ms. Bible at the administrative law stage, that you've seen, that you saw there's 20-something exhibits. There is proof to support their stage. As far as the arbitrary and capricious and abuse of discretion and clearly unwarranted exercise of power, and I want to point out you have several articles in the exhibits that address the Tennessee River Gorge. They address the state of Tennessee. You've even got articles in there that address properties purchased by Thunder Thornton, the new Etna Mountain development that he's done. The reason that I know I keep pointing out about the state of Tennessee and the Tennessee River Gorge, the problem that those are concerning on your individual landowners, those properties, for instance, the Etna Mountain, I'm sorry, going back, you have one in there about the Rarity Club as well in it. When TVA purchased the Etna Mountain from an individual landowner, they made that purchase. The intent of purchasing that was TVA owns some riverfront property. The whole plan was to swap those purchases for no profit whatsoever. There was no
article.
I'm sorry.
Are you reading from an article? Is this what?
Yes,
Is this an exhibit?
there's an exhibit. Yes, there's.
Land
I'm
Trust
sorry.
newspaper
I'm sorry,
article?
and I stated the wrong. It was Cedar Mountain, and that would be exhibit. I'm sorry, exhibit number 10. I'm kind of referencing 9 and 10, those exhibits. The Little Cedar Mountain project. I'm sorry, I was misspeaking. It's not the Etna Mountain. Little Cedar Mountain, back many years ago, it was TVA purchased it from an individual landowner, and this is in the Marion County area. And TVA purchased it with the full intent that they were going to transfer the property to a developer to develop the Rarity Club. It was going to be a single home development on the riverfront, so gated community. They did this. TVA purchased that property with the intent to then transfer it to an individual developer. It was just a straight trade. There was no no money changed hands with it. That's the problem you get into with pointing out that these state properties, and they're assessed at $2,000 or less than $2,000 an acre. It becomes important because that's happening all over our area, that you've got individuals that are coming in and purchasing property, or there's trades going on, and you've got individual landowners who their property taxes are rising and rising, and they're supporting these state properties, but then they're just going to individual purchasers for developments. If you then also reference exhibit number 9, it goes into that as well, those articles. And these boards, meaning the state comptroller, the state of Tennessee, the local boards. These boards ignore the fact that the undervalued state and trust real properties join private landowners' properties that have the same soil type evaluation and have the same proximity and access to fields, streams, roads, and highways. The Tennessee River Gorge purchased 750 acres of real property to the west and north, $1.35 million. The purchase, when reported December 10th, 2002, in the Chattanooga Times Free Press, you have that article as an exhibit, quoted present Marion County Equalization Board member Tommy Stanfield, who is a realtor and then owner of Century 21 in Jasper, Tennessee. He's glad the land will be preserved. I like to see some development, and we have a shortage of that here, but I have no problem at all with it being brought up in trust. And then Marion County Executive Hal Moss said the trust will continue to pay the property taxes on the land. Marion County's property tax rate is 1.73 per $100 of assessed property, which means the trust would pay $1,730 annually on a $100,000 piece of property. By Marion County Executive Hal Moss calculations on the purchase price alone, the Tennessee River Gorge should have paid $23,355 a year in property taxes in the tax year of 2002 and thereafter. The 750 acres that were purchased for $1.35 million were purchased roughly for $1,830 an acre in 2002 and has apparently never increased in value since. That's the Tennessee River Gorge. It is still assessed, and that is Mr. and Ms. Fievel's adjoining property owners is assessed at $1,830 per acre. And that's Exhibit 4, and that's where the collective Exhibit 5 with the deeds, and you received a full copy of the deeds today.
How many
That's what they-
acres is that talking about?
The Tennessee River Gorge, 750 acres. And it was purchased for $1.35 million. So, and it works out to be roughly $1,830 an acre.
Is that a tax exempt property, or do you know? Or is it, excuse me, is that a tax exempt entity that owns the property?
The Tennessee River Gorge should not be, no. They should. Oh, I'm sorry, it's been transferred to the state now. It should have been generating back then when it was still owned by the Tennessee River Gorge, but it's been transferred to the state of Tennessee now. So
Okay.
it would fall into that exemption now.
Okay.
But we've still got it assessed at the same value from 2002, and it was owned by the Tennessee River Gorge for many years after.
Part of your pleading to the administrative judge was state property should be paying tax.
No, that is not. Per the Tennessee, that's where the Tennessee Constitution comes in. And that article on the equalization, that's that exhibit number 2. I'm not saying that exempt properties have to pay taxes, but the Constitution says they should be assessed for their fair market value. And all property should be assessed for its fair market value. To say that one, Mr. and Ms. Bible's property who's beside there is assessed at part of it is $20,000 an acre. Another part is $52,212 an acre. And then another piece is $29,000 an acre. When theirs is assessed at less than $2,000 an acre, it should be assessed. And there's reasons why. When you have these where you've got trades being done by TVA, by the state of Tennessee, Tennessee River Gorge, and they're making trades with private developers.
Do you have any comparables of acreage the same size as Bible's property?
Yes.
I mean, in your pleading.
Yes, and that's where too it would overlap with Mr. Thomason, who's also here present, and Mr. Leon Thomason's. It overlaps with theirs. We're saying that you've got a piece of property that's beside them, which is less than a mile. It's just right around the corner there. We would argue that it's better property than any of these 4 appeals before the commissioners today. It has 2 creeks on its property. It has, and the importance of part of those creeks, with it, all of these are riverfront pieces of property as well. the creek, you've got issues you'll see from the exhibits. There's vegetation issues, there's milfoil, there's weeds. They just overtake the whole cove. There's photos of that. They overtake the whole cove where you can't use a boat, you can't fish off your dock. It's getting all tangled up in there. Your rudder's going to be completely covered in milfoil just going 2 seconds from your dock. The importance of the creek and it's Mr. Charles Dameron's property. The importance of that is that the creek dredges out because it runs off the mountain. There's water going through it. It dredges out into the river. There's deeper water in front of Mr. Dameron's property than there is any of these other properties that I'm arguing today. It is assessed at $13,818.18 per acre.
How many acres?
It is 2.75 acres.
And it is a superior site than.
Yes, and this
Your
is talking
property.
just the land value. None of these I'm sorry.
You said it has 2 creeks going through.
Yes.
So you've got 2.75 acres split up by 2 creeks.
The creeks are more on the sides of the property, on each side of it. It's not the boundary line of it, but they're more on the sides of it. So, yes. And they're smaller creeks with that. They're more wet weather creeks than they are just constantly running with that.
Do you have any comparable sales from one party to another completely as it's defined in the a willing buyer and a willing seller? And when you look at the state of Tennessee or TVA, they might be independent, but they've also got in their back pocket the right of eminent domain. So if they want that property, they're going to get it. So to look at those transfer prices don't necessarily reflect market value. And I was called on the carpet on that many times doing condemnation work. So if they've kept their assessment at almost what they paid for the other party, River Gorge or the state, 15 or 20 years ago, it really doesn't make any difference. They wouldn't be comparable sales to begin with. And also, you look at the date of the sales, when they might have happened. You couldn't use those in the assessment. If that doesn't change, you really need to look at comparable sales. We can't just look at what the assessed value is from one property to another.
And the problem is that probably the most comparable, because these are mostly family properties, they're not getting sold and bought up like on the regular market. That's the problem you run into. Mr. Miss Bible owned this property my entire life. Mr. Leon Thomason's my grandfather. Mr. Timothy Thomason's my uncle. They've owned these properties. Mr. Timothy Thomason, I mean, he's lived there his entire life, basically. That's the problem. So we would argue that the Tennessee River Gorge is probably the most comparable to compare it to. That was purchased in 2012. I'm sorry, 2002. Then that would be one to compare it to. The lot that was purchased by Mr. Bible, it was purchased from the Tennessee River Gorge. What happened with that, since it butted up with Mr. Bible's property, he worked with the Tennessee River Gorge in doing the legal work with it, and what they wound up doing, because they were going to have it decide it was such old boundary lines, what the boundary line was.
What year did he?
While she's looking that up, to tell you when it was purchased. That's why this boundary line is so straight. They just cut it from the road down to the, as part of, basically, Mr. Bible purchased that property. Property went off. So they did an agreement to set that one property from. And there is the title, title insurance is one of your exhibits as to that, which shows the value that even the title company put on that. Okay, it was from Tennessee River Gorge, and McLaughlin was the owners. McBriar.
Ms.
Eh, eh.
Willis, I looked through the file and remember, because we looked through so many, I don't remember seeing any other comparables outside this cove and talking about the Tennessee. Is there any comparables in other sloughs or coves similar that was in your pleadings?
No, and the reason why there's really not comparable is because when you get into these other, they're even developing, the problem is that even just on the other side of the river, you've got Highway 41 on the other side of the river, they have riverfront property. Problem is they're not comparable to these properties. These properties, until recently, didn't even have high-speed internet. It's out in the middle of nowhere. The road constantly has problems. It's one of the, you ask the road commissioner, it is one of the worst roads in Marion County. He has made that statement before. I believe it's even in newspaper articles when there was a slide that shut down the whole road for several months, and they had to go 45 minutes out of their way just to get to Jasper to work. And they had to go all the way through towards Chattanooga, over Suck Creek Mountain, and go around. There's no fire. There's no water. Everything is septic tanks. There's no sewer. That's your problem. There's not really comparables, is the problem. Anything else is either on the other side of the river where they've got EPB, electric and internet and cable. These don't, like I said, until
So
recently.
there's no electric?
No, they have electric. That's hit or miss though. If a tree falls and it takes, they've been without power for 24 hours just from a rain, not snow.
So I'm just gonna cut off here a little bit because if it's not in the record, again, we're not receiving testimony today. It's limited to argument.
This is in the record.
Okay,
This-
where is it?
This was
the
part of Mr. Bible's argument at
testimony?
the administrative stage, yes.
If you want to talk about, if you know, I'm usually references and things are okay. When it starts to get very robust, if you want to highlight that, I have a copy of the recording. We can play it. For the
I'm going off of his script that he read into the record essentially, and there's added into it and all, but it's essentially the same, hitting
Okay,
all the same
I'll listen
points.
to the transcript.
Okay.
Go ahead, I'm sorry.
Okay. And you were asking as far as the warranty deeds, those would be, like we said, would be comparable properties.
It's been more than 2 years ago, I would probably,
Okay, it would have been more than two, I can,
yeah, I don't need to know if it's,
okay. And that's the thing, there's not anything else, like I said, has been, there's arguments why it would be a better property that are comparable in there. And again, I'll point out that in at every stage of this, we have asked tax assessor, Mr. Darrell Pittman, or the local board, give us some comparatives. They have presented none. They've based it on nothing. Mr. Pittman even, testified at the administrative court hearing that he just based it, I mean, he reported what the state sent down, with no, comparatives, no support to show where that, and like I said, you've got all these properties that have totally different valuations. Moving on.
Well, first of all, this is a learning experience for me, and I was under the
Well-
understanding I couldn't add anything to it, so that's the reason I did.
Yeah, so I kind of agree. I'm not really sure where we're at. Also, at some point, we do need to give it over for Mr. Pittman to make his arguments. So I guess I will try to remind everyone once again that we are not accepting testimony today. We're largely, the point is if you want to highlight parts of the record, my role here today is to help facilitate you doing that. We previously corrected the administrative record at the top of this hearing. Generally speaking, if people are referring to parts of the record, I will kind of let them do that freely. If you were looking to recite portions of the record or otherwise go through documents one by one, I'm not going to stop you from doing that. I may ask the relevancy of it as to how it relates to the administrative law judge's decision, which is what we are here to review. Mr. Osborne, do you have a question not
I did
related
have
to a factual question?
When did you realize this change in your property? Was it within the last couple of years, or does it date back sometime?
What do you mean?
Yeah, I don't,
Well,
and again,
Are
are
you?
we asking for, if you may ask her to cite what part of the record is identified that from?
No, you're not gonna find it in the record.
Then,
You're not
then,
gonna
then
find it
I'm
in-
gonna,
It is, Mr. and Ms. Bible have challenged it every single time that there's been an assessment. This is the first time they've taken it this far because we do not believe it, based on the surrounding property values, we do not believe that the values as they are now. We think they should be reduced. We understand that the commission may not, y'all would send it back down. An administrative judge may not even be able to reduce it down below the 2020 assessment, but we believe it should be less than that though, but that's why we're here today.
any questions from the commission at this time that are not a factual question?
I'm not finished with my hitting the things though.
Okay.
Okay.
No questions from the commission. Feel free to rejoin your argument.
Okay.
Mr. Pittman, I will give you time to make your arguments as well. I will just remind everyone it is 2:00. We do have 3 other appeals to get through. I know most of it will probably be referenced to the arguments you're making now. But just do keep your time on your mind. I do have to give Mr. Pittman equal time to respond.
I believe when we were asked, I think I even said 3 hours is what I expected.
Yep,
when we were
go
asked,
for it.
so. Okay.
Take a break.
Yeah, we can take a break.
Yeah, it's been over.
All right, we'll come back at 2:50. I'll give you 6 minutes. We seem to be getting our breaks quicker. 2:15, we'll come back.
Okay.
2:16. Mr. Rest, you're good though, but as soon as you're ready, we'll get back on that. I think we're ready, Ms. Willis.
Determining the value of real property, the following factors are considered. 1, location, 2, current use, 3, whether income bearing or non-income bearing, 4, zoning restrictions on use, 5, legal restrictions on use, 6, availability of water, electricity, gas, sewers, street lighting, and other municipal services, 7, inundated wetlands, 8, natural productivity of the soil, and 9, all other factors and evidence of value generally recognized by bearing sound intrinsic and immediate economic value of the time of assessment. This matter has now had a hearing in front of the local county board and an administrative hearing. There has not been a single fact, statement, or proof whatsoever made during those proceedings supporting the assessed value by the local board of the Marion County Tax Assessor. I have reviewed the memorandum posted on the Tennessee Comptroller's website regarding changes to the conduct of hearings before the Assessment Appeals Commission, which would be this commission. This memorandum states that AAC may also take remedial action where the ALJ's decision is arbitrary and capricious. A decision is arbitrary and capricious when it is unsupported by the evidence that is both substantial and material in the context of the entire record. Substantial and material evidence must be more than a glimmer or scintilla of evidence, but may be less than a preponderance of the evidence. In reviewing this issue, I don't see how you can affirm the administrative judge's decision when the local board and the Marion County tax assessor have failed at every stage of these proceedings to produce any evidence in support of its valuation. ECA section 7-5-1506 states, the State Board of Equalization or the Assessment Appeals Commission may reverse or modify the decision if the rights of the petitioner have been prejudiced because the administrative findings, inferences, conclusion, or decision are unsupported by evidence that is both substantial and material in light of the entire record. The assessed value is clearly unsupported by the evidence that there has been no evidence presented by the local board of the Marion County tax assessor. The fact that the statute states that the commission can reverse or modify the administrative judge's decision if it is unsupported by the evidence would show that the local board and or the Marion County tax assessor is required to present at least some evidence in support of the assessed values. The local board nor the Marion County tax assessor have not presented any evidence or exhibits at any stage of these proceedings to support the assessed values. Marion County tax assessor has at all stages simply relied on the state computer-generated values alone. In answering your earlier question, I know you said that it wasn't, it was more than 2 years ago, but the 1.5 acre tract that we're referring to, it was purchased for $4,000. Payment was made by providing $4,000 of legal fees or legal services. Marion County appraisal.
I'm just going to ask again, what exhibit, and hold it up so we can follow you along.
That's gonna be exhibit 12. Based on the
I have
title.
exhibit 12. Let me make sure I'm in the right administrative record. 133920, exhibit 12, Division of Water Resources.
Title.
I have a
Tyler Tricks.
13-page document.
Gonna be one of the last.
And what are you reading from for recitation?
I'm making argument based of that document.
What is, okay. Proceed.
Yeah, actually, if you look to that's showing the and this is the warranty deed where Mr. Bible purchased the property from the McBriars. I'm sorry, not the McLaughlins, but McBriars. I think I misstated earlier. And if you look, since it was done for in service legal fees, it's on there for $1, the consideration. However, if you go down to the consideration where the actual consideration is, it's valued at $4,000. And that was for purchasing.
Are we still talking about 4070 Mullins Cove?
Let me,
Yes, 'cause we're making
correct.
it comparable.
That has nothing to do with it.
And it was, that was purchased is $4,000 and it was 1.51 acres.
When was that, please, ma'am?
That was
2016.
purchased in 2015. February 25th, 2015, and that's exhibit number, it's exhibit number 12, towards the end of it.
That,
Um,
when it was registered, 20.
So it's, so I have exhibit 12, this being the last few pages of that exhibit. Page 11 of this exhibit being a warranty deed for Jerry Bill Bible and wife Deborah Same Thomason Bible for 4070 Mullins Cove. I have this deed, as I believe it's a warranty deed. It was executed on February 25th, 2015.
So you're saying this was not a relative and this was an open market sale where it was advertised and sold on the open market and it was advertised?
It was not. Oh, sorry, I'm sorry, it was advertised, I'm sorry, misspoke there. That's the thing, it was advertised for the whole tract. At that time, the Tennessee River Gorge wound up being out, purchasing, any other individual owners. The River Gorge bought it, and Mr. Bible purchased from the original owners, McBriar's, purchased that piece of property on the other side of the road that would have been land joined, to Tennessee River Gorge. And it is still, it came off that same track that I was pointing out of the Tennessee River Gorge, and their value has not changed. Their assessed value has not changed, and there's a $1,800 approximately. It was $1,889 per acre, and that has not changed in value. However, because there was that boundary survey done and filed, that piece of property has been skyrocketed. It has gone up.
But again, what are we referring to now?
Comparative property values, it is increased.
Which
47.
exhibit?
We are still addressing exhibit number 12. It's also would be referencing the tax card that would be.
Moved as an exhibit.
Sorry?
Talking about 3, the property tax card?
No, I'm talking,
Okay.
I'm sorry, the, not tax card, the data assessment, printout that would be exhibit number 7. So it's addressing the values based on that. And that was the only one that would buy that property was the Tennessee River Gorge. Nobody else, made me with purchase. And I won't dive into y'all seen photos of the goose droppings, y'all heard from the past record, all the cosmetic problems. The big thing I've been focusing on here is the value per acre of the land, but there are various other things. But I want to end on this just as argument's sake with it. Even the Marion County courts, they have taken judicial notice that that the Marion County tax assessor's values are inflated. Even recently, the court has even put in an order entered October 20th, 2022, the Marion County Chancery Court, in a order for the sale of some property through a probate case that was placed in the order. Although the purchase price is significantly lower than the total value of the property assigned by the Marion County assessor, all parties and the administrator agree that the assessor's value is inflated and said purchase price reflects the fair market value of the property. And this was a sale that just took place in October.
Do you have a copy of this order for entry?
I do. I didn't know if I could.
If it's a court order, it's just a list of authorities, so
Okay.
yeah.
Is this something new?
It's a judicial opinion, and as essentially it carries the weight of law or otherwise be a cited authority for her argument. And so I'm going to review a copy she's going to provide, and we'll decide from there. But essentially, you can, court orders and public documents, things like.
I'm just trying to stay in order with you. I didn't see that, so.
Okay,
Know you're familiar with the Marion County area. It would be the Robert McVeigh property that just sold recently. It'd be map parcel 119, and it was 2 tracks, map parcel 119-011.00, and it was 4.61 acres. And again, just for clarity, this is located in the city of Jasper. It's very different. However, even the court has taken judicial notice that the prices are inflated. So that's why I'm giving this as relevance here. And it states in there the purchase price. The purchase price was both tracks sold for $155,000 for both tracks. One of the tracks was located at 119-1011.00. It was assessed at $91,500, and it was 4.61 acres. The other track is located at map and parcel 119-011.10, and it was valued at $101. And sorry,
what purpose are you using this for?
to show that the prices are inflated and that it should be
Yeah,
set
no,
aside.
we're
based
not
on-
entering new evidence. If you're citing the legal authority of this or sort of judicial opinion aspect of it.
I am for the judicial opinion that the prices are inflated,
No.
and we argued that at the lower level.
I'm not going to put this in the record. You're entering it for its factual weight. We don't accept facts here at the commission. There was a legal principle you're trying to extrapolate from this decision. I would want to get it because make sure we have a copy of that authority. But if you're trying to enter this for its factual significance, we are not going to do that today. So
Even though the local courts are taking judicial notice that the prices
we
are
are not going
inflated.
to enter this as a factual exhibit before the commission. We do not accept factual exhibits here.
Okay.
If this was running for its judicial authority or for legal principle that you're trying to extrapolate from, one of the legal arguments you're making today, we could admit it and or take judicial notice of it, but not for its factual weight.
Okay. But that property,
You will need to move on, Ms. Willis, from,
even though I'm
yes.
okay.
We were not accepting factual testimony as to the evidence today.
That would conclude the argument on, 13392, that our argument this time.
Mr. Pittman, are you still on the line?
Yes.
Could you, so we'll proceed with your argument for today. And again, we are focusing only on 133920, that being the 4070 Mullins Cove Road. As you start your argument, could you please state for the commission what relief you are requesting from them today, and then proceed with the rest of your argument?
I guess the only argument I have today, I mean, I know it's not an excuse. I am a new assessor. This is all new to me. And from what I was understood, as far as having evidence, that I didn't need anything because it was a Board of Equalization decision. That's the reason I didn't turn anything in. That's my fault. That's really the only thing that I have today. And I do have sales that's close to that area, which I know it's too late to turn those in, but that's all I have
Oh,
at this
Mr.
time.
Mr. Pittman, you are correct. We are not receiving new testimony. You're welcome to highlight portions of the administrative record. Any exhibits that were previously submitted to the administrative law judge, you can highlight from and to help facilitate your argument as to why that decision was correct or incorrect. I can facilitate the presentation of any of those exhibits that were previously in the record. But correct, we are not accepting anything new today.
Yes, sir.
If no other arguments, I'll ask the commission members if there's any questions at this time.
I don't have any questions. Osborne?
I don't think I have any.
Mr. Prophet?
Ms. Willis, I would
No, I haven't.
normally ask if you had any brief reply, but since Mr. Pittman didn't really have any argument, I would assume the answer is no. Okay. We're gonna enter deliberations at this time, so I'm gonna hand it over to our presiding member, Mr. Phil Rest. I'm asking you those same questions I asked previously. All are your charge today. Did the administrative law judge misapply the law cited in this case or otherwise not follow constitutional or statutory provisions? The administrative law judge act outside the scope of his authority, and was the decision supported by substantial and material evidence? Like I've said before, you've got pretty broad discretion in what you'd like to do. You can affirm the decision in whole, reverse it in whole, reverse it in part, and remand it for further instructions, or otherwise, as you see fit. But again, you are not to reweigh questions of fact as determined by the administrative judge at the lower level. I think I've said it before, so there you go.
We have been told over and over and over again that this commission and various members and all of us that sat on the commission at different times and different other members of the commission can't accept the assessment as a comparable sale. We need to have comparable sales, and as such, we have seen none. Because of that, I would affirm the administrative law judge's decision in this matter.
On further discussion, show what I'm talking about is we have two problems. Sides. We have an assessor that bring evidence to the administrative judge, and in that respect, the appeal is correct. There wasn't any proof there. But when you read TCA 67-5-601A, it's on the appellant to prove that with comparables. And I think that would have been probably more work, but by saying these people were biased because they have experience in real estate and stuff like that, that doesn't apply to these appeals. Whether they were biased or they weren't, or you just like them, whatever, they didn't like you. What gets you through these appeals is this law, that you use comparables. Unfortunately, it was on the appellant, according to this law, to prove that. If I feel the assessor should have had those, and of course, him being a new assessor has never been through this process, it doesn't sound like. And I think that there's nothing we can do. I just hope in the future, both sides, if they look at this any further and other steps, that they will understand when they go to court, whether it's administrative judge or it's further on up, that they need to follow this in order to be successful. And I agree, there, make a second, if that was a motion.
Okay.
That stand by the administrative decision.
Mr. Osborne?
I'll take and echo comments that being made here. It's unfortunate that we are put ourselves in this position to where you're not giving accurate information as to how the value of your property came about. And fortunately, the administrative law judge believes that the assessor doesn't have that responsibility of providing you that information. And it's incumbent upon you, since you're filing the appeal, to bring forth evidence and information that supports your conclusion. The absence of that not being done, I have to agree with fellow commissioners that
We have a motion and a second. Any other discussion? Sure.
Charles going.
Oh, no.
Okay, that's.
Decision.
Okay. All those in favor, please say aye.
Aye.
Any opposed? I'd like to say one more thing. I'm sure you would want to bring this up again, probably. Get one or two independent appraisers. This is a tough piece of property to appraise. And they might have to go pretty far afield to find a similar property with waterfront and limited to no utilities, flowage easement and everything else. But it's probably a pretty good piece of property from looking at the maps and the aerial photographs. And it would probably be worth your while to find someone, or probably two people, to get some independent appraisers to back up what you're contesting.
Y'all know, I mean, they know the property, the owners of the property better.
Yeah.
They know what drainage problems are and everything else. That needs to be brung out through an appraiser that can find comparable properties, show these minuses to that, get a true market value. So, but these other issues just really, which took up the time, but they're understandable. Individual never dealt with government or anything. But for us to act, this is what has to happen. Changes have happened. This is what has to happen. Comparables.
Reading between the lines.
So the decision is affirmed. We'll issue a written copy of the decision in the next 90 days. I'll pass out a copy of the next one, Jerry Bible, Jerry B, appeal number 133921. This is Jerry Bible B, property ID 104-01300, Marion County, tax year 2021, appeal number 133921. Initial decision in order. The Marion County Board of Equalization, the local board valued the subject property as follows: land value of $162,900, an improvement value of $212,100, a total value of $375,000, for an assessment of $93,750. Taxpayer filed an appeal with the State Board of Equalization, hereafter State Board, on July 29th, 2021. The undersigned administrative judge conducted a telephonic hearing of this matter on May 4th, 2022. The appellant, Jerry Bible, represented himself at the hearing. Hereinafter, the taxpayer, the Marion County Assessor of Property, was represented by the Assessor of Property, Daryl Pittman, hereinafter the Assessor's Office. The taxpayer testified, and at footnote 1, the judge notes the taxpayer requested that his testimony from case number 133920 be incorporated into this case. On his own behalf, and the Assessor of Property testified on behalf of the Assessor's Office. The following exhibits were introduced: Exhibit 1, the Tennessee State Constitution; Exhibit 2, History of Equalization in Tennessee; Exhibit 3, list of members of the Marion County Board of Equalization; Exhibit 4, Land Trust newspaper article; Exhibit 5, the Tennessee River Gorge warranty deed; Exhibit 6, parcel map 105.001.00; Exhibit 7, parcel map 104.013.02; Exhibit 8, river photos; Exhibit 9, parcel map 146.001.00; Exhibit 10, Little Cedar Mountain newspaper article. Exhibit 11, parcel map 104,001.06. Exhibit 12, Division of Water Resources and Notes. Exhibit 13, photos of attached solarium. Exhibit 14, photo of house and support pole. Exhibit 15, photo of the door seal. Exhibit 16, photo of the underside of the roof. Exhibit 17, excuse me, the order I will state notes on page 2. Exhibit 17, photos of the driveway. Exhibit 18, photos of the topography of the subject property. Exhibit 19, water depth chart. Exhibit 20, photos of the lake. Exhibit 21, photos of flooding on the subject property with attached flood zone map. Exhibit 22, parcel map 123.017.00. Exhibit 23, the subject property's tax card. Findings of fact. The subject property in this appeal consists of a house on approximately 3.12 acres, built in 1970 at 14190 Mullins Cove Road in Whitwell, Tennessee. The taxpayer contended that the subject property should be valued at $315,000. The assessor's office requested that the local board's decision of $375,000 be affirmed. The taxpayer raised the following issues to support his contention that the local board's valuation of the subject property is incorrect and that his proposed value should be adopted. 1. Surrounding properties that are in substantially better condition than the subject property are valued lower with favoritism to state-owned properties. 2. The assessor's offices has offered no comparable properties or proof to support the value placed on the subject property. 3. The local board was biased in the valuation of the subject property. 4. The subject property has not been modified since previous assessment and is in need of upgrades and repairs. The assessor's offices provided no valuation analysis to support the value affirmed by the local board. 3. Applicable law. The basis of valuation set out in Tennessee Code Annotated Section 67-5-601 subsection A is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1-.11 subsection 1. Determination. Based on a review of the testimony and the evidence, the taxpayer failed to meet his burden of proof in this matter, and therefore the local board's valuation of the subject property is affirmed. The taxpayers testified that the assessed value of their property had increased at a higher percentage than other nearby properties. However, the Assessment Appeals Commission has repeatedly rejected arguments based on the amount by which an appraisal has increased as a consequence of reappraisal. For example, the Commission rejected such an argument in E.B. Kissel Jr., Shelby County Tax Years 1991-1992, reasoning in pertinent part as follows. The rate of increase in the assessment of the subject property since the last reappraisal or even last year may be alarming, but is not evidence that the value is wrong. It is conceivable that properties may change dramatically for some properties even over so short of time as a year. Final decision order at 2. It is further noted that at the assessor's office testified that state-owned property is not taxable. With respect to the structural issue of the house, merely reciting factors that could cause a diminution in value does not establish the current appraisal exceeds market value. The Assessment Appeals Commission has ruled on numerous occasions that one must quantify the loss in value one contends has not been adequately considered. See, that is Fred and Ann Ruth Honeycutt, Carter County, tax year 1995, where the Assessment Appeals Commission ruled that the taxpayer introduced insufficient evidence to quantify the loss in value from the stigma associated with a gasoline spill. The commission stated in pertinent part, the assessor conceded that the gasoline spill affected the value of the property, but he asserted that his valuation already reflects a deduction of 15% of the effects of the spill. The administrative judge rejected Mr. Honeycutt's claim for an additional reduction in taxable value, noting that he had not produced evidence by which to quantify the effect of the stigma. The commission finds itself in the same position, conceding that the marketability of the property may be affected by a contamination of the neighboring property. We must have proof that allows us to quantify the loss in value, such as sales of comparable properties. Absent this proof, here we must accept as sufficient the assessor's attempts to reflect environmental conditions in the present value of the property. Final decision order at 1 and 2. Similarly, Kenneth and R. and Rebecca L. Adams, Shelby County, tax year 1998. The commission ruled in relevant part. The taxpayer also claimed that the land value set by the assessing authorities was too high. In support of that position, she claimed that the use of surrounding property detracted from the value of their property. As to the assertion the use of properties has a detrimental effect on the value of the subject property, that assertion without some valid method of quantifying the same is meaningless. Final decision at 2. The taxpayer also alleged biasness in the local board, however, provided no proof to support this allegation. The assessor's office provided no proof to support the valuation affirmed by the local board, and the taxpayer contends that this fact should weigh in favor of their contended valuation. However, as stated earlier in this order, the burden of proof in this matter rests with the taxpayer. The assessor's office has no requirement to present any evidence to support their valuation or that of the local board. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. The taxpayer has failed to meet their burden of proof in this matter, and the local board's valuation of the subject property is affirmed. It is therefore ordered that the following values be adopted for tax year 2020 and 2021. Land value of $162,900, improvement value of $212,100, for a total value of $375,000, and an assessment of $93,750. And then continues on page 5 by listing the available remedies, including appeal to this body, which is why we are at this appeal today. Concludes on page 6, entering this order on May 19th, 2022, signed Jerome Cochran with a certificate of service, noting that the order was sent to the parties on the same date. That is the decision that we are reviewing today. I understand that it's substantially similar to the decision that we just heard, but I do recite it every time to focus on the fact that this is the decision that we are under review. Again, that being the property for 4190 Mullins Cove Road, as evidenced on page 2 of the order. With that, I'll hand it over to Ms. Willis. As Ms. Willis, as you probably noticed too, on the even in this administrative order, he notes that on subsection 1, the testimony and otherwise argument was incorporated. We would basically can do the same thing for this order as well. To the extent you would like to do that, you can, and that's how we would mark it just for visual purposes. I'll hand it to you for your argument as to why this initial decision and order was otherwise decided incorrectly.
Y'all want me to go all back through all that, right? I'm just kidding. I would like to incorporate the argument in appeal number 133920. I'd like to incorporate that by reference, and this is 133921. Are there any questions at that time about the reference or anything? Okay. With that said, I'd like to really zone in on just the numbers. I know I hit on it already quite a bit.
This is the one with the house.
Yes, there's a house on the, we just did the 4070.
Is this the house with the greenhouse attachment?
Yes, yes. 4070 is, that had the photo solarium and all.
That's going bad.
Yes.
It goes into the sewers.
Yes, that's the only, those are of the house. There is actually 4090, that's going to be this property. All of this is owned by Mr. and Ms. Bible. There's a house on this property, and there's actually a house on this property as well. There aren't any pictures. It's in the same, essentially, as the 70 house.
There's some rot around the seals.
Sorry?
The door seals are with.
Yes, the house located here is actually much older.
Okay.
It was built about in the 1970s. This one was built in the 1980s.
I was just wanting to make sure I had the right property. In
Yes,
mind.
and it's not rental. It's my brother lives there. It's so there's wouldn't come in as far as so what I touched on there, and we moved on and focused more on the 4070. This, if you recall, this is the property that up here along this, the yellow's the road. That's the piece of property that was purchased for $4,000 is right here. That boundary survey cuts somewhere down through here and incorporates from the river to the road and cuts into the property that we are appealing today. Cuts into that property. So,
Excuse me. If it cuts into that property, is the area of the property that we're dealing with here still the 3.12 acres?
no. It has been reduced to 2.52 acres. Yes.
And when did that happen?
In 2000 and, the boundary survey was filed in 2020. In preparing for these appeals, the May appeal, to Judge Cochran, that's when we were just going back and checking the tax assessment data. That's when we hadn't even gotten tax cards. It was going.
I think our batteries are going dead in our microphone. I can't hear.
Okay. Yeah.
I'm sorry, I'm standing up. Let me take that off.
That's fine.
For my clarity, we're still talking about appeal number 133921, that is 4190 Mullins Cove
That's
Road.
correct.
Okay, the administrative judge found on page 2 as a finding of fact that the subject property in this appeal consists of a house on approximately 3.12 acres built in 1970. If that answers your acreage question.
Well, what I was asking though is,
I may have misspoke there. I'm sorry, you said he found it was 3.12 acres.
Approximately, yeah, that's page 2 of the order.
It has actually been reduced by the tax assessor's office, and that property has been assigned to the property
Okay,
that
but
is
we're reviewing tax year 2021 for this appeal number. Okay.
correct.
Okay.
Correct. So that property has been reduced though to 2.26, and it's still remaining the same price per acreage.
the real question on this is, when did it get reduced? When did this happen? And if the 3.12 acres is good for this tax year of what year are we looking at here?
2021.
21.
Yes.
It's still good. If it was complete in 2021, then it would still be the 3.12 acres. If it was not,
Yes.
if it was in the middle
Yes.
sometime, I don't know whether a prorate would have to go into effect or not on something like that.
And see, that's the problem, is that it again is another one that it's already, by doing this, created a whole nother appealable issue just in the meantime of this appeal taking place.
Well, I'm concentrating on this appeal, but
What? I don't understand that. What's your question?
in other words, if they appraised the property January 1st, 2021, and it was supposed to be the $162,900, 3.12 acres, but sometime in the middle of 2021, the survey was done, it got recorded, and the property had been reduced at that time, and the assessor knew about it, then it would have to be prorated as to when it was full 3.12 acres, when it became 2.6.
Those are great questions, and I could represent to you what some of the practical assessment calendar functions of how that would operate, as much to say that some of those questions are outside the bounds of our hearing today.
Okay.
Our hearing is really just to review the administrative law judge's decision. It's maybe not inaccurate for you to take judicial notice of that. And Ms. Willis, if you have, if there's an evidence in the record that shows that maybe the administrative law judge's findings of fact, again, you cannot replace your judgment on those findings of fact for that of the administrative judge. But if your argument is to say that the administrative law judge's findings was unsupported by evidence in the record, and you would like to highlight that evidence in the record, you're free to do so. But with regards to just the factual questions of that, I'm probably going to advise you guys to move past that, as that's not the purview or jurisdiction that we have to review that decision today.
And I would argue that based on that the administrative law judge's decision is unsupported by evidence, both substantial and material, in light of the record, that these were brought up, and that is what the administrative judge was evaluating, whether to affirm the assessment of the local tax board or the tax assessor. It is completely arbitrary and capricious for how this has happened, that you're taking from one property, and it's just showing that even in light of these facts being presented to the to the administrative law judge, he still just upheld the amount that was assessed by the local board. And then further, that it's arbitrary and capricious, abuse of discretion, clearly unwarranted exercise of discretion, and unsupported by the evidence. When you compare, again, you're looking at this proper, we're dealing with these three pieces of property. This piece of property is $1,600 per acre. And we're talking about comparative properties. Even though they're owned by the state of Tennessee or the Tennessee River Gorge, this one up here is $1,889, or $1,889.89. But even if you take aside this Tennessee River Gorge and the state of Tennessee, and you just look at all of Mr. Bible's properties, I think I can sit down now. If you just look at, sorry. Oh, okay. And you just look at Mr. Bible's two pieces of property that are here, and then include that if you look at the other one as a comparable, the 4070 Mullins Cove Road, which was the appeal that you just heard and affirmed, it was found to be $20,000 per acre. And there's no difference in these three tracts. They're all riverfront. They're all on the same side of the road. They're all adjoining property. That is $20,000 per acre. Then 4190, it's assessed at $52,212 per acre. And then this lot that's been surveyed now and has been, it's assessed at $29,010 an acre. And those, the property assessment would be exhibit number 7, I believe. And I believe it's got the tax assessor data for all three of these pieces of property. And we would argue that if the commission has upheld that $20,000 an acre is the administrative judge, we think it's erroneous to find that one piece of property side by side is $20,000 per acre. Then the next one is $52,212 an acre. And then another piece is $29,010 an acre. That right there is arbitrary and capricious. When there's no basis whatsoever to find any difference in the value in any of these pieces of property. All owned by the same piece of property or owner, relatively owned by him for well over 30 years. No changes. It just doesn't make sense. It doesn't make sense. Why the difference? We would argue that actually the comparable property would be Mr. Charles Dameron's property, which is valued at $13,818.18 per acre. We think that that would be a more reasonable value to price it at for the land. But even so, it can't, there's no way it can be worth more than $20,000 an acre when 4070 was assessed at that. That's all I have as to.
That exhibit, is there notes, that from the assessor's cards,
This is,
that's real estate data, that's not got.
yeah, this is I just pulled up while you were speaking, Ms. Willis, exhibit, I believe this is exhibit 7, because I heard you reference that. So. But yes, it largely appears to be a printout from the public real estate assessment data portal.
The assessor's card, if they get those from the assessor's office, they have the note. Not online.
I can't hear him.
Again, that wasn't ever
I
presented.
said, the assessor's card has the notes of the appraiser, like if they were to put in a drainage problem on there and adjust for, they're talking about different values, Mr. Pittman. And so if they get a card from the assessor's office, usually you have notes that why you made such an adjustment. If you took off or rod around the windows or whatever, that way the property owner can see that that's been adjusted for. And so that's all I was looking at. They had a copy on an exhibit of the, off the property data online for the public, and it didn't have any notes.
And to.
Correct, yeah, I think they failed to put a lot of their stuff compared to what our tax card. Now, Ms. Willis, back, the property you're talking about, the 2.52 acres, you had that was at 50-something thousand. We have that on the tax card at 12,900 for the 2.52 because it's been reduced because of the gully.
Okay, so again, we're not getting testimony. We're talking about tax year 2021.
Okay, I just thought I'd let her know that. Okay.
Mr. Pittman, I'll hand it over to you for any arguments you have about, again, we're looking at appeal number 133921, that is 4190 Mullins Cove Road. Could you say what you were asking the commission to do to affirm, reverse, or remand the decision, and why?
Just like in the last one, I failed to do what I needed to do, and I really don't have anything.
I have one question.
Yes.
Mr. Pittman, I listened to the testimony on this track, and Mr. Bible in his testimony said that there's a greenhouse, and I looked at the photos. There's little greenhouse atrium-like things against the side of the house. And one side is just completely rotten, it looked like. And he said something about this water would run into a sewer and cause a problem with his sewer if they weren't rebuilt or something to that sort. That one there with the plastic. As one of the appraisers came out and looked at any of those things that he has brung up, I mean, for the appeal.
That's on,
Yeah,
that
we're
is
not
actually
asking
on.
questions, so
I just wondered if that was in the property record card.
yeah.
It's
so
actually-
you have to ask. Excuse me, Mr. Pittman. So again,
That's the wrong house.
The wrong, that's actually on. That's
It's on 4070.
Okay, well, I would draw the question then.
Okay, yeah, that's on the 4070. And that value of those greenhouses would be under OYB, which there's not anything for those on the
Yeah.
tax card is any value.
Motion was withdrawn. So. Any final arguments, Ms. Willis? Hand it over to Mr. Rest for delivery.
Same position here. That's probably intertied, not having any evidence.
I can't hear him.
Unfortunately, we're just in a position to where we're not in a place to where we can make any change without any evidence that presented at the time of the hearing.
I agree. We're in the same situation we were on the other one. It's just, it's just much easier these appeals if you have actual sales, and for the assessor, if there's someone that's going to appeal, to send an appraiser out and look at all the problems, and houses have had problems. And that would give the administrative judge better information to look at if there's an issue that he could adjust, or the assessor could adjust if there's problems with the house. But there's nothing that this commission can do. But there could have been things done prior to this on both sides that would have helped each side have more accurate data, as well as maybe or may not been successful in the appeal. So I propose we adopt the same motion that we had in the we really have our
So
hands
just
tied.
for clarity, that motion is to affirm the decision of the administrative law judge.
Yes, to affirm the administrative law
I
judge.
second.
All those in favor say aye.
Aye.
Opposed? I'll say one other thing about this. For all three of us at different times have been on the commission when we could substitute, we could do a value. And at first I was a little leery of the law changed in 2017. And this is a much, much better situation for everyone concerned, for the taxpayer and for the counties, certainly commissioners. Sitting up here trying to decide on our own what this is, what something might be worth, whether we this, the way it's worked out here, it seems a little unfair to you, but it's a much better situation than it used to be.
I'm an attorney. I know there's a next step always, so, yeah.
The Todd Thomason. Leon Thomason.
Let's do. What I thought, let's do Timothy Thomason next. Can she remain, I mean, she's not gonna participate, but, okay, to help with it.
Hey, Mr. Pittman. We're moving on to, in regards to Timothy Thomason, Timothy Todd. Marion Count. Property ID 104-00403, special interest 000. Tax year 2021, appeal number 133739. No, it's tedious, but I will read through this as well. Official decision and order, statement of the case. The Marion County Board of Equalization valued the subject property for tax purposes as follows. Land value of $183,200, improvement value of $207,600, total value of $390,800, and an assessment of $97,700. The taxpayer filed an appeal with the State Board of Equalization on July 26, 2021. The undersigned administrative judge conducted a telephonic hearing on this matter on May 4th, 2022. The appellant Timothy Thomason represented himself at the hearing. Hereinafter, the taxpayer, the Marion County Assessor of Property, represented by the Assessor of Property, Darrell Pittman, hereinafter the Assessor's Office. Summary of the evidence. The taxpayer testified on his own behalf, and his witness, Jerry Bible, testified at footnote 1. He notes that the taxpayer requested that his testimony from case number 133920 be incorporated into this case. On behalf of the taxpayer and the Assessor of Property testified on behalf of the Assessor's Office, the following exhibits were introduced. Exhibit 1, the Tennessee State Constitution. Exhibit 2, history of the equalization in Tennessee. Exhibit 3, list of members of the Marion County Board of Equalization. Exhibit 4, land trust newspaper article. Exhibit 5, Tennessee River Gorge warranty deed. Exhibit 6, parcel map 104-004.03. Exhibit 7, parcel map 104-003.03. Exhibit 8, photos of birds on the subject property and of the river. Exhibit 9, photos of the river. Exhibit 10. Meanwhile, I made a note on this one. This is the one where, excuse me, exhibit 12, exhibit 12, the tax card of the property. If I'm, correct me if I'm wrong, but this is when we corrected the misrepresentation at the beginning of the day. There was no exhibit 13 really for this exhibit. And then exhibit 14, I think I actually handed my notes out to him. Findings of fact. The subject property in this appeal consists of a house on approximately 2.2 acres at 4700 Mullins Cove Road in Whitwell, Tennessee. The taxpayer contended that the subject property should be valued at $214,400. The assessor's office requested the local board's decision of $390,800 be affirmed. The taxpayer and his witness raised the following issues to support his contention that the local board's valuation of the subject property is incorrect and that his proposed value should be adopted. Surrounding properties that are in substantially better condition than the subject property are valued lower with favoritism to state-owned properties. The assessor's office has offered no comparable properties or proof to support the value placed on the subject property. 3, the local board was biased in the valuation of the subject property. 4, the subject property has not been modified since previous assessment and is in need of upgrades and repairs. 5, the assessor's office failed to take into account that the subject property was in a floodplain and that the water is too shallow to add a boat dock to the subject property. The assessor's office provided no valuation analysis to support the value affirmed by the local board. Applicable law, the basis of valuation set out in Tennessee Code Annotated, Section 67-5-601, subsection A, is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1-.11, subsection 1. Determination based on a review of the testimony and the evidence. The taxpayer failed to meet his burden of proof in this matter, and therefore the local board's valuation of the subject property is affirmed. The taxpayer testified that the assessed value of their property had increased at a higher percentage than another nearby properties. However, the Assessment Appeals Commission has repeatedly rejected arguments based on the amount by which an appraisal has increased as a consequence of reappraisal. Will give me the liberty. I'll skip over the citation as the same citation from Kissel we heard previously in the case before that. It is further noted the assessor's office testified that state-owned property is not taxable. With respect to the structural issues of the house, merely reciting factors that could cause a diminution in value does not establish the current appraisal exceeds market value. The Assessment Appeals Commission has ruled on numerous occasions that one must quantify the loss in value one contends has not been adequately considered. He then again cites the Fred and Anne Ruth Honeycutt decision. And if you'll give me the same liberty, I'll skip the citation to the same case and same case citation we've heard twice already. Continuing on the bottom of page 4, the taxpayer also alleged biasness in the local board, however provided no proof to support this allegation. Further, there was no evidence introduced to demonstrate that the local board or the assessor's office did not take into account the location of the property in its valuation. The assessor's office provided no proof to support the valuation affirmed by the local board, and the taxpayer contends that this fact should weigh in favor of their contended valuation. However, as stated earlier in this order, the burden of proof in this matter rests with the taxpayer, and the assessor's office has no requirement to present any evidence to support their valuation or that of the local board. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. Taxpayer has failed to meet the burden of proof in this matter, and the local board's valuation of the subject property is affirmed. He then recited those same values that we saw on page 1 for a land value of $183,200, improvement of $207,600, total value of $390,800 with an assessment of $97,700. Page 5 continues with citation of available remedies, including appeal to this commission, which is why we are here today. And on page 5 concludes with the signature and issuance of this order on May 19th, 2022, and a certificate of service noting that it was sent to the parties on that same day. So again, this is the order that is subject for review, largely being property identified as 4700 Mullins Cove Road in Whitwell, Tennessee, as noted on page 2 of the order. With that, I'll hand it over to Ms. Bible.
And I would like to arguments in bill number 13920 and appeal 921 by reference, and this being appeal number 133739. Go to my handy dandy. Moving over around the cove just a little bit. To give you, here was where we were dealing with Mr. Bible's property. Around the cove, here is Mr. Timothy Todd Thomason's property. And this is be the next one, Mr. Leon Thomas. The property I'm going to use mostly in argument in this one is Charles Dameron's property. It would be exhibit number. Yes, it'd be actually exhibit number 6 and exhibit number 7. Exhibit number 6 should be the map and assessment data of Mr. Timothy Thomason, and 7 should be the assessment data of Charles Dameron. And you can see kind of here where it comes in. Part of that's where kind of the creek runs, one of the creeks runs down, and where would be deeper water here as well. The water here is very shallow. And if you'll also see exhibit number 10, which was, I don't think it was, I don't remember if it was in Mr. Timothy's exhibits or Mr. Leon's exhibits, that was missing part of the FEMA map and the property, Tennessee property view map. But I believe those were passed around. But it clearly shows on both of them, but mostly Mr. Timothy Thomason's, his is very much in the flood zone. His is approximately,
Sorry, Ms. Willis, I can't hear you.
sorry, I wasn't talking for a second there.
Oh, okay, thank you.
Approximately two of Mr. Thomason, he owns approximately 2.2 acres. 2.2 acres, and approximately 2 acres of his property is in the flood zone. So we think that that very much should shows again that the administrative judge's decision was arbitrary and capricious, an abuse of discretion, and clearly unwarranted exercise of discretion, and further unsupported by the evidence that is both substantial and material in light of the entire record. The fact that 2 out of his 2.2 acres clearly by the FEMA maps is in the flood zone. And
Put the FEMA map up again, please, with the,
This one?
Yeah.
I know we've got the full map too. I can.
yeah,
Yeah,
we've actually got the big map over there as well. It may be easy. This is, just to explain what this is actually, a depth finder on a boat. That's what this is. This shows the depth. This is not actually the, showing the flood zone as far as that goes. This is showing the depths around the whole cove. So that's what that is.
okay. Is there a map showing?
Yes, yes, there is. That one, or if it's the smaller photo.
Yeah, this
Yes.
is.
And that's just Mr. Timothy Thomason. That doesn't take into account Mr. Leon Thomason's property. Sorry if I may. Yes, that is, that here would be the water line. Okay, and there's the FEMA one. This is,
So, Mr. Pittman, we're just looking at the maps that were corrected as exhibit
They're
10
actually-
from the
yes.
administrative judge.
yes, that's correct.
Talking about.
Yes. This is Mr. Leon Thomason's. Yes. Yes. There is a dock, but it's on Mr. Leon Thomason's. Actually, yeah, this is, got both of them. This would be Mr. Leon Thomason's, no,
That's,
I'm upside down here. Yes, it is. That is. It runs that way down. This would be Mr. Leon Thomason's dock, and it runs somewhere over here straight down.
there anything? Driveway, is there a permanent easement for this property out to the road?
His property, um, there's an easement, there is an easement, yes. It's family, this would be Mr. Timothy this is his parents, Mr. Leon Thomason, so. The taxes,
No.
no, the appraisal card is not. The, Tennessee Property Data Assessment, their data, from the internet, it is. And it is, on both those properties. And then Mr. Dameron's property would be here. And again, we think that should have been the tax assessor presenting those, and that's why we feel that he has not met his burden as well in this. And so it's arbitrary and capricious and not in support of the evidence. I don't know if you want to leave it out from Mr. Leon Thomason's or not, though, if you need to review it for that. And just further, I'm sorry, are you ready for me to keep going? Okay.
These were definitely in exhibits.
There are exhibits for both, yes, yes. One of them did not have the FEMA maps, and I don't recall without looking back at my notes which one we had to, why we have that copy, because it needed to go in with somebody's. And I don't remember which one, but it was in the other one. And to point out too, you've got Mr. Charles Dameron's property, who's right here, Mr. Timothy Thomason's property, and Mr. Timothy Thomason, his riverfront property is approximately, he has approximately 400 feet of riverfront property. And Mr. Dameron's property, which is right here, he has approximately 1,600 feet of riverfront property. So based on that, we don't think that Mr. Thomason's property should be valued at more. And to get into the numbers specifically, in comparing, and I'll also throw and compare in there Mr. Leon Thomason's for comparative purposes. Mr. Todd Thomason, Timothy Thomason's property, it is valued at $83,272.73 per acre just for the land. That's not including improvements. That's just for the land per acre. Mr. Leon Thomason, who is beside there as well and has less flood zone property, his is assessed at $51,291 per acre. Both of them have single-family homes on each of those. No real comparative difference from that standpoint. Property is relatively the same, except for that Mr. Timothy Thomason's is, as you saw, 2 acres of the 2.2 acres is in the flood zone, and it is valued substantially higher than Mr. Leon Thomason's. And then you have Mr. Charles Dameron, who has 1,600 feet of riverfront property, and his is valued at $13,818.18 per acre. And what's even more notable as far as Mr. Dameron's property, it decreased. And in fact, 2020, it was valued at $57,500. 2021, it was valued at just the land, $63,300. And then 2022, it has decreased to $38,000. That's decreased $19,000. So we believe that Mr. Timothy Thomason's property should be valued more closely to the $13,818.18. And based on that, the administrative law judge acted arbitrary and capricious and unsupported by the facts in this case in upholding the local tax board's assessment of $52,212 per acre, when clearly, Mr. Dameron's property is more riverfront, deeper access to the water. It's much better in all ways than Mr. Timothy Thomason's. That's all I have at this time.
Any questions from the commission at this time? Again, no factual questions. All right, Mr. Pittman, any other additional comments? Or arguments, I guess?
No, I hate to sound like a broken record, but it'd be the same as the last two.
Any other final comments? We'll enter deliberations. Mr. Russ. Same charge, I guess I will read again. Before. Did the administrative law judge misapply the law cited in this case, or otherwise apply the law and law of appraisal correctly? Did the ALJ act outside of the scope of his authority? Was the ALJ's decision supported by substantial and material evidence in light of the entire record? Again, we are on Timothy Todd Thomason.
I'll start out. I think we ought to remand this property. 2.2 acres and almost 2 acres in the floodplain. It just looks like that wasn't taken into account. So that is material evidence. Exhibits and just remand the whole thing to the administrative law judge. Take another look at it, in particular, the flood maps and the amount of area in the floodplain.
Wonder if that, like these, this is, just doesn't make
Yeah,
sense.
it doesn't make
It doesn't
sense.
look like he took that. And if he did, there needs to be an explanation.
Yeah,
you know.
yeah.
And so,
Then that'll give him an opportunity to do that.
way, if there is something that shows that higher value,
I totally agree. There's concerns, the value per acre. What's even more alarming to me is the overall equalization component as compared to these other properties. And that has. So, I agree.
I would just think if looks like whoever's in charge on it's just a emotional speak here, just debating, talking about this. It looks to me like the administrative part of the county should view the whole area to make sure it is sequence, because when people do reappraisals, sometimes one state employee gets these properties and the other ones gets these properties and a map line in between. You could have two different appraisers doing this and one take things into account and the other. Okay, so if there is some error, hopefully this going back to the judge.
I don't have a problem with what they've done with this, the state-owned property or the River Gorge property. And if I remember correctly, part of that would probably go straight up a mountainside. I'm not sure. Of course, I'd have to look at the maps, but I think some of that would be very difficult property. And it's much bigger. You can't compare 10 acres to 500 or 700. So there's got to be some economy of scale
You
there.
have to have apples.
Yeah, but the other stuff that we've seen, I agree with Mr. Profit on that. Okay, we have a.
Yes,
motion.
what is the motion?
It's the motion to remand this case to the administrative judge, with particular emphasis on looking at the FEMA maps and the flood, that how much of this property as compared to the others that we've seen is in the floodplain.
100-year floodplain showed the majority of the property, except for where the house is. The majority of the property's in the 100-year flood.
So
And we're remanding it back to the
To have him-
administrative judge to see if that has been accounted for in the valuation of this property and the land value. I mean,
Yeah.
properly clear.
I know in Davidson County, could never put a septic tank in there. And I don't know about, if it's not public water out there, you have to have a well. So I don't know that you can have a well in the floodplain. So those are, as much of that area that's in the floodplain, it's a major issue. It looks as if it's been overlooked.
are you
flood-
asking the judge to make a finding of fact as to the amount of property in the floodplain?
To make sure that the
Yeah.
floodplain has been accounted for. The floodplains maps didn't come out to the assessors probably until around 2007. And I remember, if I'm correct, as far as the GIS play, 2007, 2008, as far as where they could actually look at it on a property map and say, this is where it is. They had floodplain maps, but it didn't map, it wasn't in the computer where they could see where the house was with GIS systems, actually see how much it took up. So therefore, sometimes when the state issued sewer permits, they were actually across the floodplain, and which shouldn't have been done. And so a lot
I
of
think
these,
that's what's happened.
But Mr. Pittman, hold on, there's no,
Oh, okay.
so a lot of these homes,
okay.
that if they were done now, they wouldn't have a sewer permit.
Yeah,
And
so I want to clarify, we're talking about the Todd Thomason order, right?
we're exactly right.
That's
We
the
want-
one where the administrative law judge page. Their order found that the evidence introduced by the taxpayer is inadequate and couldn't be relied upon. Taxpayer failed to meet their burden of proof in this matter, and the local valuation be affirmed. Your motion is to remand to the administrative law judge consideration of the
Floodplain maps, that possibly he didn't see those floodplain maps in his evaluation. And he would reconsider and look at that and, his decisions, whatever his decision is.
Do the motion as presented. I guess any seconds on that motion?
All those in favor, say aye. Any opposed?
The ayes have it. We'll issue a written order in 90 days, remanding it back to administrative law judge. Cases that are remanded back to administrative law judge, they generally go on a status and scheduling conference with me to get a hearing date. I just work with the judges to get hearing dates. I don't do anything else with that. We hold those, if you have your calendar available, we can go ahead and get you on one of those, so we can kind of move that appeal forward as fast as possible. We generally hold those conferences on Fridays at 9 a.m. Beginning in 2023. It'll typically be the second Friday of the month for this county. So I think our last appeal earlier we did today, we put on for March 10th, because that would mean you'd get a copy of the order before we next meet. But otherwise, make sure we kind of move this appeal forward as quickly as possible. So are you available, I guess, on Friday, March 10th at 9 a.m. Central Time?
Yes.
And those are virtual conferences, by the way. Mr. Pittman, are you available on Friday, March 10th at 9 a.m.?
Yes, as far as I know, I am.
Okay. I'd just like to note that so we can make sure we move it forward. Okay. Moving on to our last appeal of the day. I have Leon Thomason. I apologize. I seem to only have 2 printed copies for our commission members. If we could share. This is for Leon Thomason. Okay, I've, in regard to Thomason Leon, property ID 104-00400, special interest 000, Marion County, tax year 2021, appeal number 133919. Initial decision and order, the Marion County Board of Equalization valued the subject property for tax purposes as follows. Land value, $234,400. Improvement value of $191,500. Total value of $425,900 for an assessment of $106,475. Taxpayer filed an appeal to the State Board of Equalization on July 29th, 2021. The undersigned administrative judge conducted a telephonic hearing on this matter on May 4th. The appellant, Leon Thomason, represented himself at the hearing, hereinafter the taxpayer. The Marion County Assessor of Property was represented by the Assessor of Property, Daryl Pittman, hereinafter the Assessor's Office. Summary of the evidence. The taxpayer testified on his own behalf, and his witness, Jerry Bible, testified on behalf of the taxpayer and Assessor of Property. He notes at footnote 1, the taxpayer requested that his testimony from case number 133920 be incorporated into this case. The following exhibits were introduced. Exhibit 1, Tennessee State Constitution. Exhibit 2, History of Equalization, Tennessee. Exhibit 3, list of members of the Marion County Board of Equalization. Exhibit 4, Land Trust newspaper article. Exhibit 5, the Tennessee River Gorge warranty deed. Exhibit 6, parcel map 104.004.00. Exhibit 7, parcel map 104.003.00. Exhibit 8, aerial map and ground river photos. Exhibit 9, photos of the river. Exhibit 10, aerial map and flood zone map. And Exhibit 11, the subject property's tax card. Subject property in this appeal consists of a house on approximately 4.57 acres built in 1955 at 4660 Mullins Cove Road in Whitwell, Tennessee. The taxpayer contended that the subject property should be valued at $300,000. The assessor's office requested the local board's decision of $425,900 be affirmed. The taxpayer and his witness raised the following issues to support his contention that the local board's valuation of subject property is incorrect and that his property value should be adopted. 1, surrounding properties that are in substantially better condition than the subject property are valued lower with favoritism to state-owned properties. 2, the assessor's office has offered no comparable properties or proof to support the value placed on the subject property. 3, the local board was biased in their valuation of the subject property. 4, the subject property has not been modified since previous assessment and is in need of upgrades and repairs. 5, the assessor's office failed to take into account that the subject property was in a floodplain and that the water is too shallow to add a boat dock to the subject property. The assessor's office provided no valuation analysis to support the value affirmed by the local board. Applicable law, the basis of valuation set out in Tennessee Code annotated in section 67-5-601 subsection A. The value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board of Rule 0600-1-.11, subsection 1. Determination. Based on a review of the testimony and evidence, the taxpayer failed to meet his burden of proof in this matter, and therefore the local board's valuation of the subject property is affirmed. The taxpayers testified that the assessed value of their property had increased at a higher percentage than another nearby properties. However, the Assessment Appeals Commission has repeatedly rejected arguments based on the amount by which an appraisal has increased as a consequence of reappraisal. For example, the Commission rejected such an argument in E.B. Kissel. I'm going to take the liberty of skipping that as I've read it 3 times already. I will also note, just for the record, that this decision is substantially similar to our last 3 appeals. It is further noted that the Assessor's Office testified that the state-owned property is not taxable. With respect to the structural issues of the house, merely reciting factors that could cause a diminution in value does not establish the current appraisal exceeds market value. The Assessment Appeals Commission has ruled on numerous occasions that one must quantify the loss in value. One contends has not been adequately considered. And then cites again Fred and Ann Ruth Honeycutt, that same decision and that same excerpt from that decision that I've read several times, followed immediately by the same Kenneth and Rebecca L. Adams, and the same block quote from that case as well. Continuing on page 4, the taxpayer also alleged biasness in the local board, however, provided no proof to support this allegation. Further, there was no evidence introduced to demonstrate that the local board or the assessor's office did not take into account the location of the subject property in its valuation. The assessor's office provided no proof to support the valuation affirmed by the local board, and the taxpayer contends that this fact should weigh in favor of their contended valuation. However, as stated earlier in this order, the burden of proof in this matter rests with the taxpayer. The assessor's office has no requirement to present any evidence to support their valuation or that of the local board. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. The taxpayer has failed to meet their burden of proof in this matter, and the local board's valuation of the subject property is affirmed. They therefore order the same value that I read previously: land value of $234,400, improvement value of $191,500, a total value of $425,900, and an assessment of $106,475. It then concludes with the available remedies at the bottom of page 5, including appeal to this commission. And then on page 6, ends the order by issuing it on May 19th, 2022, signed Jerome Cochran, a certificate of service noting it was sent to the parties on that same day. That is the appeal that is now subject to review by the commission. I don't think there's anything else further. Do the same. Ms. Willis, what arguments do you have on this one?
I'd like to reference 130. 739. Incorporate that into this appeal, which is appeal 13391. I'd like to start out by making essentially the same argument as Mr. Timothy Thomason with Mr. Leon Thomason. There's the additionally on exhibit number 10, there's the FEMA map, which would be the same FEMA map as you were shown in Mr. Timothy Thomason's, and there's Tennessee property map. And also, I don't know if you saw the photo that was in. That there is a boat. This is the property that has the boat dock. That it's got a small boat dock, but you will clearly see from this, and this is exhibit number 10, it just, so he doesn't have to pull it out there, how much of Mr. Leon Thomason's property. You can't even see the boat dock. It's way off in the distance there, but that's his property in the flood zone as well. And there's a significant amount in the flood zone there. We would also argue that Mr. Leon Thomason has essentially the same amount of riverfront property as Mr. Timothy Thomason's, around 400 feet of riverfront property, whereas Mr. Charles Dameron has approximately 1,600 feet of riverfront property, and his property is valued at, Mr. Dameron's property is valued at $13,818.18, whereas Mr. Leon Thomason's property is valued at $51,291 per acre. We feel it should be more in the range of Mr. Dameron's, as he has much more riverfront property. He has better river access. His property is just much more desirable than Mr. Leon Thomason's. That would be all the argument I have at this time.
I don't have any.
Okay, and Mr. Pittman, any other comments or any argument on this one?
Have no arguments. I do have a comment though. Just like Todd's property there, our maps, I'm looking at it now, does not show the flood area going up that far. So that's possibility the reason theirs was discounted for a flood area, because the map doesn't show it on our computer anyway.
The exhibit 10. Any follow-up? Line. Hand it over to Commission. Read it several times, but again, did the administrative law judge misapply the law cited in this case? They acted outside of their authority. Was their decision otherwise supported by substantial and material evidence?
Crossman, I'll let you go.
There's obviously a issue with the flooding, and it's very similar to the other property that just, made some recommendations on. There was a photo that indicated the flooding. Be agreeable in treating it like a profits.
So, if they've applied flood issue to the neighbor with $1,000, not acre, but 1,000. This was an acre, but, this one's 51. Whoever appraised it could have made a mistake, and we could have the administrative judge review it and, see if the same application, like Mr. Russell said years ago, we would have had to look find in that situation. This has actually made it where people that can access more data and gives the people a chance to, resubmit that fairly here. But I think that they should look at it again.
Okay, I'll make a motion that we remand this case to the administrative law judge, specifically looking at floodplain issues on this property and how that might affect value.
I second the motion.
All those in favor, say aye. Opposed?
Ayes have it. That's the, so if it's okay with y'all, we'll put the same Friday, March 10th, 2022 date. We'll get that decision, that written decision, and then we can get you back before the ALJ to get that issue heard. That concludes all the business I believe we have for today. So I will end the Teams call. Thank you, Mr. Pittman. I don't think we have anyone else on there.
Thank you.